Happy Friday, everybody. Happy Friday evening, morning, afternoon, whatever time of day it might be where you are. Happy end of week celebrations with hopefully libations. So, how you guys
And
doing?
just for the record, I am not the reason why things were late.
Oh, come on. No, he's not the reason why things were late. Come on, take it easy. The reason why things were late was that there was a certain audio file that got released today of a bankruptcy court proceeding that I had downloaded and was scrambling to listen to because it's really pretty interesting. So we're probably going to add that to the docket at some point, but we'll figure that part out. I'm getting told my audio is really low, so I'm going to do.
It does seem quiet.
Let me see if I can do this. When I was on your stream last, it was a little bit different. Is that better or no?
I think so. Although it's hard for me to tell because I don't know if it's balanced against like me.
Yeah, I can't really ever figure this part out. Either way, so that's where we are. If it's better, it's better. I've got the mic literally right up here, so we'll get it probably about as good as we can get. Anyways, there's a lot going on this week. You know, for all the weeks that we had boringness, all of a sudden, every case is back in court. Like all the cases are back in court. Corey Richins, Karen Reed. Who else? We got the new trial of the Daniel Penny cases in court. So all kinds of stuff happened. So we have a lot to talk about. In addition to things we got to talk about, I have to post this week's household debate poll. Where, and I apologize, I'm a little bit under the weather today. So if I sound a little bit different, that's probably why. So this week's poll has to do with Christmas decorations. And most importantly, when it is acceptable to put these decorations up. So the options we're going to have, well, if my computer works with me, acceptable to put up your Christmas decorations.
I don't think my answer is going to be up there.
Wait, we're gonna try and give a variety of things. So we've got November 1st. Then we've got after U.S. Thanksgiving. I'm going to put U.S. Thanksgiving in there so that we know we're talking about.
When is that?
Third week of November.
Yeah, I don't keep track of U.S. Thanksgiving.
Just before Christmas. And then what do you mean? Oh, I can't fit that. Put them up. Let me see. Put them up, but they never came down. All right, so the poll is posted so people can have the lovely internal fight.
And my answer is definitely not up there.
Yours is never, right?
Mine is like December 23rd.
That's what's just before. That's what I said, just before Christmas.
Oh, is it in there? Okay.
Yeah, so your answer is in there. I told you. Jen loves wine. Rob. Whatever makes her happy is the correct answer. See, this is
she's
what
not
I'm being
wrong.
told for the most part. So yeah, I put it all in there. There's various options available. So I'm not going to tell the chat what my mind is, but we should say that
it's wrong under the circumstances.
every time. The missus always sides with Ian Runkle usually. I don't know if that's for more humor in the household, more debates in the household. She doesn't like winning. She doesn't like not arguing. I think she was a lawyer in a former life. I don't know.
I mean, arguing is fun.
It is. Except when you end up in the arguments that never end because neither one of you will give up. Yeah.
Well, she knows where you live, so.
Yeah, and she's seen where I sleep. So, apart from that, how was your week? I know that you were out hunting, and that the deer were not listening to the beck and call of
Oh,
Ian
there was
Runkle in the
nothing.
woods. Nada?
There was nothing.
Nothing except a crack in the scope?
The scope ring, yep. So
That was cool.
yeah.
Did you figure out why? Just faulty?
I don't know why, but I gotta replace that, and that's gonna be annoying. So yeah. That's gonna be a hassle because once I replace it, I also have to
Resight?
zero my scope.
Yep.
So
That's gonna be fun. Well, no, that part can be fun, although frustrating.
it's just annoying.
Anything. Yeah.
And
Calibrating anything is frustrating.
yeah.
So here's a good question. I like this one. So how's the wood shop coming along there, Rob? The shop is actually doing somewhat okay. There's some things in disarray, but I did have a little bit of things to kind of show because I've been working on stuff for Christmas gifts from all kinds of people. And
Now, when you say there's things that are in disarray, you mean like basically life in general?
Yeah, no, life in general, that stays that way. Usually the shop, I try to make the shop an accurate reflection of my life, which means there's usually just a minimal amount of chaos. But right now it's probably an accurate reflection of life because there's tremendous chaos. So, oh, Lynn Britton, look at this. My nine trees.
9?
My 9 trees all go up next weekend.
That's not decorations. That's a forest.
Seriously. That is wild. Okay. All right, Lynn. I did not. Where's Lady Drake? Does chasing down a Santa in a fire truck with my minis count? Yes, it does. To some extent. It does. But yeah, so I have been trying to make Christmas gifts for a multitude of people, including some channel people. And I found a use for the 3D printer. Now, I like working with resin. And I started thinking, you can buy the silicone molds. You can also make silicone molds. So I was going, how would I make a silicone mold to bake a coaster that has a nice little inlay? So I printed basically what would end up being the mold. And I tried printing various things. And I bought the mold making silicone for resin pours for coasters.
Oh, nice.
Isn't that cool? So I can do essentially a double resin pour. Problem is the channel logo is such that it's very fine lines. So I already had to increase the strength of the silicone I'm using, and it's still tearing out a bit.
I remember that being extremely annoying when I was making the axe handle cover.
Oh yeah, I know. So like the first one had a bunch of tear out when I did it, so I had to recreate it, made it a little shallower, so I'll be able to pour the molds in there, so I can pour some coasters. So I think that'll be fun. But it's fun for me because this is like the first week I've been back to being able to make stuff at all, which is remarkably healing.
I am not there.
Well, you were making stuff for the live auction like crazy.
Yep, and I'm just way behind on a lot of that. Amongst other things, I'm going to have to... there's a bunch of things I got to finish, but like my whole house is full of stuff that needs to get shipped. And I can't ship it right now because the post office here is on strike.
I heard that you're having a battle with UPS.
Not so much having as one. I got UPS to completely cave. Do you know the sort of backstory on UPS and how much they suck?
Well, with that type of intro, now I need to hear it.
So UPS does this thing where they whenever you send a Canadian something via UPS, they UPS will charge a ridiculous amount for customs clearance.
Oh,
and
no. Actually, side note, I am aware of that. I have shipped things to Canada before, and I tried using UPS, and it was the worst decision.
Yeah, I mean, if I know something is going to be UPS when I order it, I just like cancel the order because UPS is so awful. But anyway, I ordered the Hot Ones pack, and I was going to do a Hot Ones for the Hot Ones challenge for the 24-hour live stream.
Mm-hmm.
Except then I was not feeling well, and I decided that is really not a winning combo. So, yeah, so I still have that. That's still sitting around waiting to go. But but it arrived via UPS, and UPS in this occasion they just left it. Right, they just left it with me, and that was fine. I got no objections to that. The problem is that after having left it with me, they then turned around and they sent me a bill. And the bill is like, you owe us a whole pile of money for doing customs clearance. Now, it's $6.79 in GST, which is the goods and services tax. So it's a Canadian tax. Okay. But they decided to charge me a total of $42.60 for that.
What?
So, yeah. Now, keep in mind the Hot Ones pack is about $100 on its own. When all is said and done, because the shipping to Canada is actually super expensive. And so then I'm sitting there going like, I don't want to pay this shit. So yeah, at that point I'm kind of unhappy with that whole thing. So I break out the Consumer Protection Act. And I'm like, yeah, I don't have to pay you this. So initially I'm like, here, I sent them this big lawyerly, PFO letter. And they say, yeah, tough, you still owe us. And then they, and Mary Coppola says, that's the Queen's tax, not UPS. No, it isn't. Of this, $6.79 is the government's tax. The entire rest of it, 38 something is UPS. That's all UPS adding it on and so forth. So
where does it go? Like if they're declaring it, if they're disclosing it as the tax, but it is, so are they just pocketing the money?
Well, it's summary of charges, duty amount, 0. Customs GST, $6.79. Total, entry prep fee, $30.40. Disbursement fee. So that's a fee they're charging for paying the $6.79. And that fee is $7.40. So the fee to pay the $6.79 is actually more than the $6.79. And then they have $1.71 for GST on their fees. And so, yeah.
Okay. This now makes sense. The anger now, I understand it.
And sometimes these fees end up getting like really ridiculous, because you can have this situation where not only do the fees exceed the, the shipping cost, but sometimes they actually exceed the value of the items.
I recall that during last year's Extra Life live stream when I ended up shipping a lot of this stuff out, and I'm happy to do it, but I just remember going, paying the shipping costs and going like, oh my gosh, well, this is more than, I would say it's more than what was bid for it, but in most cases there was $450 bid on a rock, so I don't know that it's more than it was bid for, but it was a lot.
Well, in this case, they just hammer you, right? So Anyway, I sent them a very lengthy email that said, hey, here's why you don't get your money. And they told me, tough, you have to pay. And I went, I'm not paying you. Where do I serve you with court documents? And they said, you have to pay. And I said, that's neat. Where do I serve you with court documents? And they said, we're waiving all of our charges.
That's a cute explanation. But, where is it that you would like me to serve you guys?
Yeah. They're like, our policy says you have to pay. And I'm like, or...
You chose to do business in Canada and you decided that you wanted to be subject to the Canada Consumer Protection Act.
So, and Mary Coppola says, you'll get that whether it's postal, UPS, DHL. No, that is the problem. When I get similar values of things, and they get shipped to me via US Postal Service. So that's Canada Post will charge the brokerage. At the same time, when I do the, the same time when I get like $100 value item sent to me they charge $10. And that's like, hey, we're charging you $7 for GST and then $3 for our brokerage fee. So it is way, way cheaper if somebody sends something, US Postal Service. And, when they give you the option, they're like, hey, do you want the really slow shipping? Like it's going to take forever because we're sending it via US Postal Service? Or do you want the fast, shipping via, UPS? And I'm like, I will take the slow every time. Recovery Addict. Yes, Scott. that is fine.
I ask you, so Scott, Recovery Addict says, I humbly ask your permission. So Ian, I humbly ask your permission to make the soundbite of you saying, we hate you on my channel. Just, oh gosh. How many times did that get played, Scott? What would be the trigger for it? We hate you. Sincerely us, everybody. To whatever's happening on the screen. Clearly not Scott, but whatever's happening on the screen. Anyways.
I am in favor.
I am very, very, it needs to be phenomenal. So I haven't talked to you in a little bit. Well, you were hunting, so you were incommunicado. Although the live tweeting while hunting is probably one of the most comical things I was able to catch up on. Honestly, it made my day because it was what was the one you said, like, hey dear, don't mind, look at this, young doe that's right here, eagerly awaiting. Don't mind the scope. That's nothing to be concerned about. So it was quite the entertaining for you. Let's check up on the.
Sadly, I don't think the deer are following my Twitter.
No, I think that they might be. Let's see. So we have the poll is up right now. The poll is, when is it acceptable to put your Christmas tree decorations up? And there's 4 options: November 1st. Option 2, after the U.S. Thanksgiving. Option 3, just before Christmas, which we know is Ian's vote. And then option 4 is put them up, but they never came down. I can tell you, I don't know a single human that has Christmas decorations that stay up year round.
I knew one, but they were an odd sort of duck. And that's coming from me, right? I am not exactly the king of normal. So
you said it, not me.
So when it was like, this is odd. It kind of was very much odd, but yeah.
Well, we had, let me see if I can't pull it. There was an office email. So we have an Oklahoma office, right? In our Oklahoma office, Oklahoma City, gets some interesting characters, because you made the comment of odd characters, and it made me kind of wonder, well, I had an inner office email today that was quite literally an odd character moment, and it circulated the office, and it was about one of the people that gets seen out front of our Oklahoma City office. Just a photo, standard photo taken of, just outside a law firm, what you'd expect. And Ian, I say this to an individual that I very much know sees a lot of things outside the window of their law firm. And I mean no disrespect by that. Let me see.
I mean, I do criminal law, so
does he.
Often if there's a weirdo out front of our firm, they're a client.
Fair. So,
and it's like, come on in, we need to talk.
What was shared today? Let me see if I'll find it real quick. Because some people made some comments, and they didn't. I don't think people understood the practicality of the attire that this gentleman decided to put on. Wait, why is it? No, I want.
Did you have a guy show up wearing body armor?
No.
Because I've had that.
I can't say I've had that.
I had to explain to him that what he was wearing was not actually legal where we are. And, yeah. Or at least not for him.
Well, you got to kind of find a way to... Let's see. What's interesting about all of this is you end up grabbing an image and then you end up trying to find a way to make the image suitable to share. And I don't mean, well, never mind. Chat's going to do what chat's going to do. What I mean is that you want to make sure the image is not giving any personally identifiable information, that the image is not overly descriptive in the place it is depicting, because you don't want to just, yeah. So what we had today in Oklahoma City was this. This gentleman that was right outside of our Oklahoma City office that was decided that, a traffic cone made a very good hat.
And was that incorrect? No,
people were saying, what was he thinking? Why was he doing this? I said, what do you mean? What was he thinking? Why is he doing this? I mean, the response from our office was rather frustrating to see. So, I mean, of course I responded.
You should just include that in the dress code in future.
I think it was appropriate. So you guys you're not giving this guy enough credit.
He's making a fashion statement.
Well, he was. Because I said there's a lot of legitimate reasons why someone would wear that. One, traffic and safety, right? Last thing you want is a car jumping off and just hitting you while you're trying to take a nap. Very safe. Two, rain in the elements. You lose most of the heat through your head. So...
Yeah, although the hole in the top of it is kind of a disadvantage.
I know. Aliens. Everyone knows that, traffic cones attract aliens. Fashion sense.
Attract or repel?
Well, repel. I think repel is what you want. And then fashion. Drab colors are out. Bright and bold is in. I think it's fashionable. And again, if you see someone that's having a circumstance such as that, feel free to help them. Give them jackets, clothing, whatever you can. It's unfortunate, but the traffic cone on the head was something I didn't really expect. All right, so I have 4 topics to cover tonight. I'm so in trouble.
We're going to get through 2.
No, we have to get through some of them aren't that long.
Yeah, but I'm here, so everything's long.
Melissa Webb, yay, another FNF. Why I love Friday nights. Thank you very much, Melissa. It's very kind of you. Lynn, did you get the package from Mini Mischiefs 1 and 2 from Kentucky? Lynn, I will have to double check on that. I will. I'll try to get by the post office box this weekend. I have not been there. It is still at the old address, so I have to drive a substantial... That is a me thing. That is an ADHD thing that I meant to change a long time ago, and I keep leaving myself reminders to change it. I just don't see the reminders. Kathy Parasow, thanks for becoming a member. Just Because, thank you for gifting 20 memberships. Much appreciated. I Talk About Bruno, thank you for the hearts. Phoenix, good evening to you and good evening. Just because. What did you do on recorded audio, Rob? I didn't do anything on recorded audio. No, this was a bankruptcy case, and the audio is public, so I just had to hear it because I read the articles about it, and something about the articles made me kind of wonder what actually happened. Mindy FS, such an amazing channel, and I am an OG 23-month member. Yes, you are. Thanks, Rob. Thank you. Lady Fang, thank you very much. Decorations up 24th of December, down 6th of January. That you are right. That is Ian Runkle's alley.
I mean, we're probably like down the 25th of December.
Like, it's Christmas. There's a present I'd like to give you, but I'd like to put a tree up to put it under the tree.
Yeah, under the tree. Well, the other thing is we've got 2 dogs, and the dogs are sometimes jerks. I've left the door open so that they can, because Mrs. Runkle is out, but the dogs can wander by if they feel like it. Maybe I'll get a bag of treats later and lure. Wait, I got a bag of treats right here. I can lure them when I feel like it. But the dogs very much like a Christmas tree. They're big fans, and they like to show their love of the Christmas tree by taking the tree down.
Yes,
and
I wish to hug this tree as hard as I can.
They really love the smashy noises. So yeah, I had a Christmas ornament that I'd had since I was like a kid, and it gone.
Yeah, it'll do that.
So often what we do instead now is, rather than having a full proper tree, we will put up like a tree shape on the wall so that they
oh, that's awesome. Oh, that's great.
So that way they can't it keeps them from being destructive. So
you see, I think this is a great idea. The tree shape on the wall is phenomenal. So I'm all for that.
It was necessary. It was just like, yeah, there is really no other option other than just, we're going to have not so much a tree as, yeah.
That is fair. That is very much fair. Mispronounced name. I know you were up for jury duty. Didn't make it on the jury. Oh, that's turned out to be for
let's not read those words.
No, we're not going to read them out loud. M word, R word. Part of me is very glad I didn't make it on the jury. I think that's a very safe thing to be glad that you didn't have to listen to.
And I've gotten very blurry just as my dog arrives, so I'm going to try to fix one of those things.
What, the dog? The dog, or you not being blurry, or which one?
I'm going to try to unblur myself here.
Okay.
Yeah, it's focused to like Spain right now.
Uh-huh.
I don't think we need to show Spain.
Nope.
All right. There you go. Up. There you go.
Well, now that you showed your dog.
She's a very cute doggo.
She is a very cute dog. My client does no wrong. My client is perfect. My client is best dog.
That'll work too. He's like, I'm not catching that.
That was the funniest thing. I posted there was a clip I posted 2 weeks ago when you finished the extra life stream. And I said my favorite part of that entire 24-hour stream was when you started stream sniping everybody and sending all of the laser beams to other people. And the chat, which is best chat, the chat decided that they needed to see every human's pet. So it was like, let me see your dog, let me see your cat. And all of the individuals that were getting extra donations to their charity live stream were more than happy to oblige. And when the cats would jump up or the dogs would make it on the camera, the chat just exploded. So, but mispronounced name, I'm both happy that you did not make it on the jury and sad that you did not. Maybe there's another opportunity you'll get. Leo went to, he went away to school.
Oh, did he learn anything?
Well, he's at school for 3 weeks. And there's Leo. He's like, look at me. This is my school photo with my pee out.
That's some quality photography there, Rob.
It wasn't me that took it. It was the trainer. And this is apparently just what he's been doing, just running everywhere. So Leo is he is away at fun camp where he learns stuff, which honestly for a dog like this is what he wants. So it coincides with Thanksgiving. Yes, it's Pupper Boot Camp. Pupper Boot Camp. He went to band camp. I don't know if he went to band camp, but reform school. It's not reform school. It's very much. He is a big teenager right now. And Mischief Manager and I both work full-time jobs. More than full-time jobs. Oh no. Honk Banana, no, don't even start this rumor. I did not send Leo to a farm upstate. No, Leo has not been rehomed. Don't even start. But Leo is a very big teenager, and we have 2 children in the house. And when Leo wants to play, he doesn't know his own size, and he views Mini Mischief 1 and Mini Mischief 2 as litter mates. And Mischief Manager and I are not around him enough to get the basics drilled in. Which is not possible. So that was the remedy to make sure that Mini Mischiefs 1 and 2 can very much walk him, that we are in a better place, and everyone's saying it gets better. I know it gets better.
Don't talk about the dog being sent off to a farm and it's in a better place now. That is not.
No. That was a poor choice of words. Poor choice of words. No. He is just having some recreational learning, which for a dog like that, the learning that's part of what makes him, that's part of what drives him. And I'm not able to give that to him to the extent that he needs it. So he's getting boot camp where then we'll be able to kind of continue implementing things that have been foundationally implemented. Does that make sense?
Mm-hmm.
Finishing school, someone said in the chat. Yeah, no, he's not Chloe. He's not Canton Brainworm. He's not disappeared. Leo is very much still here. Trust me. Lori Leanne, did you get the gift Bev singly sent in May? Honestly, Bev, I don't know. If you were concerned about it, send me an email, lawandlumber@gmail.com. There are boxes that are still unopened in the house. So I will try to find it. Thank you very much for following up and for asking. I will look for it though. Thank you guys. You guys are very kind and very generous. All right. So we'll leave the poll up while we go through our first topic. Which should our first topic be? What do you want to talk about? You want to talk about the Murdaugh banker getting a new trial? Do you want to talk about Karen Reed? Do you want to talk about Corey Richens, or do you want to talk about the bankruptcy hearing that I listened to?
I mean, any and all of the above are awesome.
One of the problems that I have with the Corey Richens one is the Corey Richens one is bifurcated into multiple things. You know, everyone's saying Corey Richens.
I got to do a stream on the Corey Richens thing because people want to cover it.
So how about this? Tom D, thank you for reminding everyone. 1,700 watching, only 617 likes. Please like it. Please do. Liking helps. Just a little like button. Little like button helps. Okay, we can start.
Zora is now camped right there because she's like,
yeah, she sees
the bag is gonna happen.
Yeah, she sees the treats. You know, let's do Russell Laffitte first because that was on the docket, and then we'll get to the
Russell Laffitte.
No, we're not going to wrestle the feet. I don't want to wrestle the feet.
I'm like,
you want to wrestle the feet?
What?
I'm not going to wrestle the feet. Russell Laffitte. For those of you who don't recall, Russell Laffitte was the Alex Murdaugh's banker buddy, the guy who helped facilitate all the loans that were never repaid or anything like that. So Russell Laffitte, not wrestling his feet or their feet or any feet whatsoever.
It's like, oh, suddenly this is becoming OnlyFans.
No, it's only feet. It's only Russell Laffitte. You see, this is what I'm talking about. I get back into a stage of making things, and my mood is just elevated. So I feel like the energy's back. I'm happy. It's like, so when I make the comment of go make something, you'll feel better, I sincerely mean that 100%. Even in my own life, it does it. All right. Russell Laffitte. Russell Lucius Laffitte. Oh, we swoop. We shall swoop. We shall swoop. Swoop. Okay. So this is out of the Fourth Circuit Court of Appeals, which I am presently in the Fourth Circuit. So Fourth Circuit Court of Appeals, appeal from the U.S. District Court for the District of South Carolina. These are the individuals that had the distinction of arguing the case. And this is the judge, Judge Aggie, who delivered the opinion. Russell Lucius Laffitte appeals his convictions for bank and wire fraud in violation of 18 U.S.C. sections 1343 and 1344, subparagraph 2, in the U.S. District Court for the District of South Carolina. He also appeals the district court's denial of his motion for judgment as a matter of law and 2 motions for a new trial. The government cross appeals from the district court's restitution order. For the reasons explained below, we vacate Laffitte's convictions and sentence and remand for a new trial. That is a big deal. It's not we vacate the sentence and we order resentencing. It's not we find harmless error. This is one of those very unique situations where the Court of Appeals saw something that happened at the trial court and said, nope, nothing's going to fix this. We need a brand new trial. So the government alleged in the indictment it sought to prove at trial between 2006 and 2021, Laffitte used his position as CEO at Palmetto State Bank to assist Alex Murdaugh, a disbarred South Carolina attorney, in defrauding his clients, Murdaugh's clients, that is. And I love the footnote here. The Supreme Court of South Carolina disbarred Alex Murdaugh on July 12, 2022. All right. Laffitte and Murdaugh were alleged to conspire to defraud Murdaugh's personal injury clients and to obtain money and property by materially false and fraudulent pretenses, representations, and promises by making misleading statements and omissions. It's a whole lot of vagary there. Basically, they did some shady stuff that stole money from clients that had money on the line, and there was a lot of lending going on in the background. In furtherance of the conspiracy, Murdaugh requested that Laffitte serve as the conservator or personal representative for the settlement accounts of multiple clients. So he was the one that would receive money after the settlement. And in receipt of that money, he was supposed to hold that money sacred and safe and not give it out except for the purposes the client needed or requested.
And I'm sure that's what he did.
Yeah. Yeah. That's exactly what he did. Yeah. Except no. As a result, Laffitte could access the settlement accounts and use those accounts to collect over $450,000 in fees and to extend 16 unsecured loans worth approximately $960,000 to Murdaugh, because Murdaugh was entitled to a portion of those, having received settlement funds. In total, Laffitte and Murdaugh were alleged to have stolen nearly $2 million from the settlement accounts, making them pretty terrible people. Because I don't think there's a set of facts where this part is anywhere in dispute. In September of 2021,
I feel like Murdaugh also achieves pretty terrible people by virtue of the murders.
Yes. Yes. But again, we're focused on the finances, not just the murders, the finances. So, in September of 2021, Murdaugh's law firm discovered that he'd been stealing from both the firm and his clients. The firm subsequently fired Murdaugh, reported his thefts to the authorities, and notified Laffitte that Murdaugh was no longer with the firm. After learning about Laffitte's involvement in the Murdaugh thefts and settlement funds, the board of directors at the bank voted to sever the bank's relationship with Laffitte. CEO, bye-bye. In September of 2022, Laffitte was charged in a second superseding indictment, which means an indictment that is brought after the first one that has additional charges or information, in the District of South Carolina with a conspiracy to commit wire and bank fraud, wire fraud, and 3 counts of misapplication of bank funds. The 5 substantive counts charge Laffitte as a principal and an aider and abettor. Not a better. Well, he did bet. He bet on Murdaugh and he lost that bet, but abettor, the singular word. During the 9-day trial, you see, folks, you can have trials that aren't 6 weeks long.
I mean, most trials aren't 6 weeks long.
I know. Like the Sarah Boone trial was a restoration to normalcy.
I mean, the Sarah Boone, I kind of knew would be quick.
Those trials are.
So, well, and she didn't really have a whole lot to do anything in that one.
No. Right now,
it's like, how long does it take for a plane to crash into a mountain? Just not long, right? It's, boom, and then you wait for the smoke and fire to go out. And
it depends on the plane, though, because you have planes that go in there fast. You have planes that go in there like a flying a pack of gum. Or a quote from Ron White. Anyways, during the 9-day trial, the government presented 15 witnesses. Look at that. That is efficient. That is efficient AF. 15 witnesses, 9 days. I love it. 5 of whom were the bank's board of directors. And Laffitte called 8 witnesses himself and testified his own defense. You had a total of 23 witnesses. Well, 24 if you include Laffitte. 24 witnesses over 9 days. Look at that efficiency. That is remarkable. That is, Ian, that is a very well-run plane that didn't go straight into a mountain, kind of. During direct examination of his sister, Laffitte sought to introduce testimony regarding the desire of the government's witnesses, who were also board members of the bank, to sell the bank. Laffitte also sought to introduce, so he seeks to introduce a bunch of the stuff that doesn't end up getting in. At closing arguments and the court's instruction to the juries, after closing arguments, the jurors began deliberating at 10:22 a.m. on November 22nd of 2022. For those of you who think that appeals get resolved quickly, this is an appeal to the Fourth Circuit Court of Appeals from the District Court, which is the intermediary court. There's no other appellate court here. This was a deliberation in 2022. It is now November 15th of 2024, almost 2 years later before an opinion comes out. 7:45 p.m., the court summons the parties and counsel to the courtroom to disclose the receipt of 2 notes from juror 93. Ian, would you mind reading a little bit?
The first note stated, need antibiotic at 19:20. I can delay 1 to 2 hours. Okay, important. And was signed number 93. The second note read, feeling pressured to change my vote, and was signed number 93. Okay, the first one about needing the antibiotic, not such a big deal, but needing antibiotic and I don't know if I'm going to get it unless I change my vote, that becomes a big deal. So after reading both notes to the parties, the court said that its instinct was that we have alternate jurors and we should get to a verdict, and it is not practical to get her medicine and drive back. The court also welcomed any thoughts, and defense counsel suggested that the jurors return in the morning, but the court reiterated its preference to utilize alternate jurors. I would have just said, we done here.
Mistrial.
7:20 is enough time to say you've deliberated all day, right?
Yeah.
Like, if you've been there till 7:20, and in fact they say I can delay 1 to 2 hours, like 9:30 at night is not a good time to be like, we good. Even just 9 o'clock, right? Being like, we good. Come back tomorrow, more deliberation tomorrow.
Well, it wasn't even that the judge said, we're going to take you for the next 2 hours, right? The judge said, my inclination is to swap it out for an alternate.
Yeah, no. I mean, if the guy actually died from lacking his antibiotics, then you need to put an alternate in. But until then, yeah.
In her note, this is the other part, emphasis added. In her note, juror 93 underlined pressure twice. So it's like, I'm feeling pressured, double underline to change my vote.
Yeah,
I would say
that is not
the last juror you want to be getting rid of in a case where is the one who's saying this.
Like the one who's standing up for themselves.
Exactly. The government agreed. Of course the government agreed. Of course the government wants to swap out the juror who's feeling pressured. They put on a slam dunk case and they're like, yeah, swap them out. They're feeling pressure to change their vote. So you know what? Let's go ahead and just put someone else in there who will. The government argues with the impending holiday ahead of us. Or I guess it was Thanksgiving. We would like for the jury to continue to deliberate tonight. Echoing the government's concern, the court explained, I could just tell you right now that if I tell people that they have to come back tomorrow, I don't think that it's in anyone's interest. Okay. What about the defendant?
I mean, here's what you can do as well as a judge. You can be like, what antibiotic do you need, sir? And you'll be like, I take, whatever. Just so long as it's not like meth or the like. Then you say to like a sheriff, hey, can you drive to a pharmacy and tell them we really need like 10 pills of this? And I guarantee you the pharmacy, assuming it's an antibiotic, will hand it over.
See,
and you're just like,
put that assuming it's an antibiotic in there. Because if you didn't, you lost context. And
I mean, yeah, they might be a little more reluctant if a sheriff walks in and is like, I need, a whole bunch of Disoxin, which is the drug name for meth. If you're just like, hey, then they might be like, sure you do, officer, corruption, but like, this is not a hard problem. This is not an unsolvable problem.
Well, yeah, here's the part where it gets worse, because somehow, like, you're looking at this and going, all right, I'm seeing you walk into a problem, Judge. I really am. And I'm not sure that you're thinking about it right now because it's 7:30 at night, Judge. Like, I've been in front of judges making decisions at 7:30 at night, and I will tell you, it is not usually a good thing to get someone making a judgment call at that time of day after they've been in court for a full day. So the judge goes on, he says, and I'm going to be honest, I'm kind of trying to protect defendants here in this situation. And this part kind of bothered me. Judge, you had 24 witnesses over the course of 9 days, and it's a monetary transaction issue with the feds prosecuting. I'm pretty sure that everyone in the courtroom was reading the writing on the wall. So I don't know how you're trying to protect the defendants by swapping out a juror who's saying that they're feeling pressure to change their vote. Because I'm doubting that the majority is innocent.
I see somebody noting U.S. pharmacy cannot dispense an antibiotic without an order. Hey, guess who can write an order?
Judge. A judge. Exactly. So, and I don't think it's in your interest to try and force people to come back tomorrow. I don't like the effect that has on pushing people to a verdict. Well, what are you doing, Judge? All right, and never mind. At that point, the court received 2 additional notes. So they're having a discussion about this, and all of a sudden, 2 more notes come back. So the additional notes were signed by multiple jurors. This one read, "Dear Judge, we are writing this to express a shared concern. On page 11, your final charge to us states that, quote, if you let fear or prejudice or bias or sympathy interfere with your thinking, there is a risk that you will not arrive at a true and just verdict," end quote. A juror's previous court experience, you know what would have vetted that out? Voir dire. And you're stuck with the jury you got at that point. A juror's previous court experience is influencing that juror's ability to discuss the trial in a group setting. That juror has made comments about having been, quote, bullied, end quote, as a juror on previous trials and will not consider the evidence in this trial. The juror is hostile to hearing any debate from certain other jurors, and the juror disagrees with your final charge and specifically the definitions you provided. We respectfully ask that you consider speaking to this issue so that we are able to proceed with deliberations. This is quite the note. I don't know what I made from this. Ian, do you have any thoughts on the dialogue within that jury room, the deliberation room? Like, how did it get here?
Yeah, I feel like this is a problem.
But you don't know, based on the context of this, who the problem might be or what.
Oh no, you don't.
Problem. So,
because I mean, this could be either side is the problem, right?
Really could, because when I'm reading this, I'm viewing this as, I could read this letter or this note as being a bunch of you guys ganging up on someone who seems pretty firm and fast in their belief and understanding of the evidence. So you're trying to get them to reevaluate that evidence, and they're saying they don't want to. So at this point, if I'm the judge, I want to bring the jury back in, and I want to give the instruction of, if you feel resolute in your position, you are asked to, you give them the Allen charge. There's been a lot of time put into this case by both sides, blah, blah, blah. You're supposed to review the evidence. You're supposed to review that with an impartial mind. If you feel like you've made a decision, I ask you to reinvite or reopen your thought process to welcome other thoughts. That one. But also reminding the juror, if you feel firm and fast in your convictions, do not change it. So there's another note. Final note came from juror 88, and it said, "Your Honor, can you please call an alternative as I'm experiencing anxiety and unable to clearly make my decision." Under the signature as juror 88, she wrote that she could, quote, "provide more information as needed if necessary," end quote. At this point, if I'm the judge, man, aren't you freaking out a little bit if you're the judge? Going, this is just not sounding good at all.
Yeah. I'd be like, we got a problem here.
So after reading the jurors' notes to the parties, the government contended that the court should, quote, "put two alternates to replace both of those jurors," end quote. In response, the district court reminded the parties that there are, quote, "three alternates for a reason," end quote, and noted that it is unclear whether the notes raised issues, quote, "with two jurors or three jurors." Well, we don't know who is who. So one, you got to figure that part out first. But also, I mean, this is just turning into a mess. The government proposed that, quote, "the person with the medicine should be allowed to go home," end quote, and that the, quote, "person that cannot follow the law," end quote, "should be struck for cause." This part kind of pissed me off by the government. One, you are buying into what the other jurors are saying automatically without giving any context, and you have no idea whether this person's following the instruction or not, because it's up to interpretation. The judge is instructed on the law, but they get to debate what the judge told them back in that jury room. Mm-hmm. Court counsel cautioned for the juror who allegedly was not deliberating, stating, begin quote, "I can't let a juror be bumped out one way or the other who says that's not accurate. I'm fully participating. They just don't agree with me. That, that's not a juror I remove. I mean, I tell them in my charge, hold your convictions," end quote. See, he should have stuck with that. Right there. Stick with that. Consequently, the court proposed that it speak with the juror referenced in the third note, but expressed its view that it would be a huge mistake to conduct the interview in the courtroom. Why? I guess because the anxiety? Is there a footnote there? No. After a short colloquy with the government, the court proposed the following. With the consent of the parties, we're going to set up a place where I will take a court reporter, and without anyone present but the court reporter, I will create a record. And with my deputy and my court reporter, I will ask the juror if there's a problem. You know what I would have said right here? With the consent of the parties, I will, as defense counsel, "Judge, you don't have my consent. You can do that against my objection." Like, you can decide, but you don't have my consent. You don't get to go talk to a juror outside the presence of me.
Yeah. Rather than my consent, you have my, what's the word? It starts
Objection?
with F and then ends with you not doing that.
Yeah. Both parties consented. Well, that's a mistake. To this action, the court directed the courtroom deputy to ask the jury foreman to identify the juror number of the juror referenced in the third note. Upon the return, the courtroom deputy informed the court that the parties, the jury foreman, did not know the juror's number, but she stated that she would get her number from the name. Before leaving the courtroom, the court said, okay, I'm going to take action. Fair enough. Everyone happy with that? And, oh, God. At that point in time, if you're an attorney, you said, Judge, you can take action. Doesn't mean I'm happy with it. 8:20 p.m., the court conducted an in-camera interview with the juror 88 to address her request to be replaced with an alternate. The discussion is reproduced in full below. The court. You're juror number 88? Juror number 88? Yes. The court. You can take your mask off if you feel more comfortable. I received a note that you told me, can you please call an alternate as I'm experiencing anxiety and unable to clearly make my decision? I can provide more information as needed if necessary. You want to share anything with me? But don't have to tell me anything about the deliberations themselves, okay? But don't tell me. So he instructs her. Okay, good. I thought it was an open question.
Yeah, you
Juror
don't have to
88?
tell me. No, that is not correct. It's you should not tell me.
Do not tell me anything. Juror 88, give me a minute. Court, take your time. Juror 88, I was very proud to do this. At one point, I thought I wouldn't be able to, but I'm prescribed medication, and I've been taking notes clearly. I have my decisions that I made, but I'm starting to feel very anxious due to some of the reactions to my decisions. Well, interesting. The court, do you feel like you can perform, or do you want me to replace you with an alternate? Wrong question, Judge.
Also, perform is a weird term.
Very strange, right? It's the wrong question, and it's phrased terribly.
And it makes me, yeah. I'm like, that's weird.
And again, 8:20 at night is not the time to be having these debates. You make bad choices. Juror 88, Your Honor, I don't want to be replaced. Oh, look, the Court of Appeals did the benefit of highlighting that for us and bolding that text for us. Your Honor, I don't want to be replaced, and I'm usually very strong when someone is butting up, but I don't want to be trialed for my decision. We all get what she's saying. Court, whatever decision you make is your call. Juror 88, yes, sir. The issue is, are you able to perform your duties as a jury, says the court. Juror 88, at this point, no. Well, Judge, doesn't the prior statement here inform this one? Like, at this point, no? And isn't the at this point, no make it feel like they're being bullied? And shouldn't you kind of admonish the jury and give them that final instruction? The court, okay, I'm going to honor your request to replace you then. Juror 88, thank you. The court, Crystal, who is the bailiff or the clerk, not the witness or not the juror. Crystal, could you handle it from here? The court deputy, yes, sir. I'll just send the court security officer into the escort her from here. The court, I'm going to go back. You stay here with Juror 88. I don't know your name, but hello and goodbye. I wish you the best. Thank you for your service. Juror 88, I'm very sorry, Your Honor. The court, I understand. The court dismissed Juror 88 sua sponte, which means of its own initiative, without consulting the parties, which, again, big boo-boo. Even though you were allowed to have the in-camera review, you don't get from the in-camera review to making a decision without allowing the parties to be heard.
Yeah, no, you got to actually... That's just so not on.
Doesn't this sound like the ex parte a little bit from YSL? Like similar tones.
I mean, it just sounds like a giant fire of tires.
Kate Maybe asks a question for you. Curious for Runkle's insight. Had a friend whose partner had a jury trial in Toronto and was sequestered overnight. Does this happen a lot?
It doesn't happen a lot.
Doesn't Canada not really. Doesn't Canada jury trials in Canada? How common are they? Aren't they less common?
I mean, they're less common in general, yes. But the other thing is sequestration's expensive, and they don't normally like to do that. So, like, usually the jury goes home and does, whatever the jury wants to do, which is almost never almost never doing the sequestration thing. So that is odd.
Kate saying it was an M-word trial. Yeah, that actually makes sense. Well,
yeah, but even then, it's unusual that they would do it.
Yeah, like as a minimum, it would have to be a murder trial in order to do that.
Not necessarily. There's some other big words for, where that might come up.
True. Fair point. It's a fair point. Okay, so court dismisses sua sponte from the jury without notice to, or an opportunity. When a court says this, when a court of appeals puts this in, without notice to, or an opportunity to hear from, or argument from the parties, that's called telegraphing.
Yeah. If I'm reading that, I'm like,
oh,
okay, I know how this is getting ruled on.
Yeah.
And depending on which side I am, I might be having a little celebration or I might be having a little sad.
Yeah. Your Honor, people be crazy up in this deliberation room. We need a referee. The district court intended to also, quote, sit down with the alleged problem juror pursuant to the same procedure agreed to by the parties for juror number 88, end quote, but the court was informed that the previously unidentified juror was the juror with the medication issue, number 93, and this juror had already left the courthouse. Oh, so they released the medication juror already.
Okay.
8:27, the court returned to the courtroom with the parties and informed them that the juror in need of antibiotics had been excused. As for the juror with experiencing anxiety, juror number 88, the court explained that during the in-camera interview. Oh, so now this is the court explaining after the fact why the decision was made. Oh, I have problems with this. Juror 88 asked to be relieved and said she wasn't able to go forward. And I removed her. I relieved her. I granted her request for an alternate. I just basically said to her, tell me, can you do your duties? And she said, I cannot do my duties. She got medication issues herself, anxiety issues, and I relieved her. Well, Judge, here's the problem. That's not exactly how that conversation went. You recapped it a little bit differently. You put some words in different places, and I see a problem with that. The court did not read back the in-camera interview or provide any further explanation. Federal judges, man. Federal district court judges. They are the king of their own castle. Holy crap.
Yep. That was a whole choice.
And based on the removal of juror 88 and 93, the court explained that the issue outlined in the third note that the juror's experience was influencing his or her ability to serve on the jury, and that juror was not deliberating was resolved. After the district court announced the removal of the juror to the parties, Laffitte's counsel objected not to the juror that was replaced with medication, but to the removal of the second juror that was replaced with anxiety. Look at this. You know the word objection, and you raised it just a little bit late, but you still raised it. So I'm going to give you half points.
I will give them no points. And may God have mercy on their soul.
The court noted defense counsel's objection, but clarified that juror 88 was emotionally very fragile, could hardly speak, was shaking, was on anxiety medication, and was not physically capable or emotionally capable of going forward. Well, Judge, that's an assessment that should have been made in an open courtroom in front of everybody present so that they could observe it and not have to take your word for it.
I mean, what is this? Like court of law here?
Carly's Ma, this case is the case of Russell Laffitte, the banker for Alex Murdaugh, and it gets overturned. The jury, which now consisted of 10 original jurors and 2 alternates, was brought back in the courtroom. After the court's instructions, the jury was excused to return to jury room at 8:33 p.m. Soon after the court was notified, the jury had a verdict. Well, wouldn't you know? Surprise, surprise. We have a verdict.
Hey, and it only takes like eliminating all the, all the jurors who are annoying.
Dissenting juror. Yeah. There's one of you dissenting. We shall remove you and replace you. Oh, look. Order. Yeah. Wow. Wow. And I don't care if the evidence was lock solid, man. This is, you run the gambit with a jury. Around 9:30 p.m., the parties returned to the courtroom for announcement of the verdict. Oh, so the 8:30 when they returned, 9:30 was when the parties came back into the courtroom. So it was what, 15 minutes, 30 minutes? At that point in time, the two alternates who had not been deliberating would have had to been caught up on 7 hours of deliberation. So the alternates walk in, and what? The other jurors kind of say, so this is how we're leaning. And the alternate's like, yeah, sure. Do I get coffee? 9:30 p.m. at that point. So defense counsel Matt Austin again noted that his co-counsel objected to swapping out the alternate, explained that it was akin to moving for a mistrial. Well, nope. Moving for a mistrial is moving for a mistrial. The court expressed surprise at the objection. Why? Why, Judge? And Mr. Austin clarified the defense counsel thought we were just going to be interviewing jurors, not necessarily replacing them. In response, well, this is a little bit late. A little bit late. In response, the court explained that it tried to be as transparent as possible at that, and that, in its view, the parties agreed to the actions it took. You see, when I go back to this one, here, when the judge says, here's what I'm going to do with the agreement of the parties. And I will go ahead and make the comment again because it bears fucking repeating.
There's a time and a place to agree.
Parties, with the consent of the parties, we're going to set up a place where I will take a court reporter, and without anyone present with the court reporter, I will create a record, and with deputy the court reporter, I will ask the juror if there's a problem. Yeah. You say, Judge, I have a problem with that. I get you want to protect the jury, but you don't get to bypass that and do that in secret. You have to do that in front of me. Like here. Specifically, the parties agreed the court would meet with juror 88 and could make the decision to remove her upon realizing that she was plainly incapable of continuing and in an emotional meltdown. Mr. Daniel reiterated his understanding that the court was coming back to tell us what the jurors said or give us what your decision would be so that we could object to it. That's the proper objection right there. There you go. Took you a minute, but you got there. The court. Okay. So you're now telling me
he got there a little late.
I mean, after the verdict got read, the thing is when the jury goes back, you raise the issue there. You say, Judge, I think you just made a mistake. And I'm going to object and I'm going to move for mistrial now. The following exchange then ensued. Court. Okay. So you're now telling me that I had come back and told you that she was emotionally incapable of functioning and she asked me again to remove her. That you would have objected to that? Mr. Daniel, I did object to it. There you go, Mr. Daniel. Mr. Austin, yes, Your Honor, I think we would have stated that it's a hung jury. The court, it's not a hung jury. I have alternates. Oh, so we're doubling down. Wow, Mr. Austin, we just want to note for the record. Oh, and the court cuts him off.
Your Honor, I want to move for a bad court thingy.
Wow. This, by the way, this is district court. This is U.S. District Court. Welcome. This is lifetime appointment. That's what you get. Lifetime appointment. Mr. Austin, we just want to note for the record, ... The court. Okay. You know, folks, come in after the fact here, after the court laid it all out and we agreed on a process. Really, court? I thought it was very clear, and I did, but there's a record of her I don't think anyone would really question. It's all on the record about what she told me. And I was, of course, following up on her request that she be removed and told me she could explain it to me. And she did. I didn't want to invade her privacy, but she is on significant medication and she was, in my estimation, in an emotional meltdown situation. Okay? Oh. No. I'm not okay with any of that. The jury was then brought in the courtroom and a verdict of guilty on all counts. Oh, so this was in the interim, was announced. Oh, good. So they preserved the hell out of this one. The jury was individually polled, and each juror affirmed that it was his or her verdict. So subsequently, Laffitte was sentenced to 84 months in prison and ordered to pay $3.5 million in restitution.
I mean, that's not that much.
Yeah. Laffitte moved for a new trial. He argued, among other things, the district court's
He'll
replacement
just have
of
to save
88.
a couple of weeks.
Yep. So he moved that the court's replacement of juror 88 and 93 violated his Fifth Amendment right to be present because they were excused outside of his presence. That is proper objection. In addition, Laffitte contended that his Sixth Amendment right to an impartial jury was violated because the jurors were improperly removed based on their views of the case.
I mean,
in support of
this
the
is
motion for, I mean,
that is huge.
You took a dissenting juror who said they felt pressured, and
you're like, oh, let me solve the pressure by just yeeting you,
not leaving you on the jury.
Yeah. Like, that's not how you solve that problem.
And listen, don't get me wrong. Russell Laffitte, I think the government probably had him dead to rights. I think they probably had ample evidence for a conviction. I'm not disputing that at all. But as will be the theme this evening, when you're going to do something, do it the right freaking way.
Can't we just do whatever we want though? And because we're the government?
Well, it's bad people bad. That's what it is. Bad people bad. Tell me they would have been this much like bending over backwards if the same argument was being made on the other side.
I could tell you that, but I would be,
I know. In support of the motion for new trial, Laffitte sought permission. Okay, so wait, hang on, I'll address this. Jury was saying not. Yep, Julia, I'm saying that. You're right. It would have been a mistrial and it would have been retried. It would have been retried, and I imagine that I don't know if you're going to get that lucky holdout. I mean, that's defense counsel's dream. That holdout.
Just that one person who says, nah, not doing it.
Did the judge want to create, here's the thing, did the judge want to create a situation for a mistrial? No.
No, the judge does not. This is not something that happens because the judge is doing it on purpose.
No.
Because
you know what the judge can rule there? The judge can rule that it's a hung jury and it's a mistrial. The judge can rule right there on the spot. This right here is just a more expensive, lengthier way of getting the same result, which is a mistrial, a new trial.
And the judge isn't going to actually humiliate themselves to get the mistrial.
Yeah. So Laffitte wanted to file affidavits from the jurors under seal, interview additional courtroom personnel who may have had interaction. I don't know if I'm not going to admit that. Oh, it actually permitted the affidavits? Interesting. Government filed a memo opinion, March 2023. District Court denied the motion for a new trial, finding that Laffitte waived his arguments related to the removal of the juror. See, I don't know about that. Nope. Nope. Not based on that colloquy that I read, and that's why the Court of Appeals put it in there.
Yeah.
The court denied the consideration of the affidavits. I figured that would be the case. I don't think you're going to get the affidavits. I don't see that being a problem. Laffitte appealed, arguing the district court's removal of the jurors violated Fifth Amendment and Sixth Amendment. Argued that district court's decision to exclude the jurors' affidavits was an abuse of discretion. Let me tell you which one's going to lose. That one. Government noted a timely cross appeal and the failure to order interest on the restitution amount. Court has jurisdiction under blah, blah, blah. Exclusion of the affidavits.
Jurisdiction under blah, blah, blah. That's a popular ground for jurisdiction.
It really is. I have seen courts actually put that into opinions. I have jurisdiction under blah, blah, blah.
I've also just noted, I've seen a court say jurisdiction is not contested, and I will not belabor it because I don't think the judge knew how they got jurisdiction, but nobody was complaining.
Yeah. This could have been, this entire argument could have been summed up in this paragraph. Here you go. In sum, in light of the broad reach of Rule 606B, and the clear connection between the affidavits and the statements and incidents made during deliberation, the district court correctly excluded. Oh, they actually went so far to say the district court was correct. And then they said they did not abuse their discretion. Okay. Figured that was going to be the case. Waiver. Did they waive the objection? Laffitte did not waive his Fifth Amendment or abuse of discretion claims related to the removal of Juror 88. In outlining its plan of action on the juror's notes, the district court stated, with my deputy and court reporter, I will ask the juror if there's a problem. That is all the court stated they would do. Ask if there's a problem. Then, shortly before leaving to conduct the in-camera interview, the district court asked the parties for their consent to create a record to question the juror. Oh, gee, Judge, all you were going to do was ask questions. Both parties gave consent. All right, so we allow you to ask questions. Laffitte was not on notice that the district court might remove the juror during the in-camera interviews. That's a very different thing, Judge. Asking questions and then making a decision without me asking about it. Indeed, the record reflects that Laffitte's counsel came to the same conclusion. In response to the district court's announcement that it had in fact removed the juror, Laffitte's counsel immediately objected to that removal. When the verdict was returned less than an hour later, Laffitte's counsel again objected to the replacement of one juror. There you go. You renewed it. You preserved it. You did it. Waiver arguments there. You don't get 93. You waived that. You don't get that one. You agreed to that juror being removed. Yeah. See, we agreed with that. We agreed with that at the time. No. 88. Yeah. You get that. Ineffective assistance of counsel. They tried to make a late argument there. You can't because he was more than a bag of potatoes. Because counsel was present. And although he didn't do the thing you wanted him to, he was there.
I mean, the thing is there can be, or at least in Canada, you can ground ineffective assistance of counsel on a little bit more than that, but it's tough. And I think the U.S. is really like, so long as your lawyer has a pulse. I'm not even sure if a pulse is necessary. I think that if your lawyer died midway through, they might still find them effective.
Because they would have said he objected before he died.
Yeah.
The reason why we laugh about this is the case that sets the precedent in the U.S. is literally the lawyer was drunk, like hammered during the trial, and was seen sleeping
and like passing out. Yeah,
passing out in the trial, was asleep during the course of the trial. But the Court of Appeals comes back and says, but he objected at some occasion and he made arguments. You had counsel. They might not have been the best counsel, but they were counsel. You kidding me? Really?
Whereas like in my area, it's considered a fairly straightforward ineffective assistance of counsel argument. If you've got somebody who's got immigration issues and their lawyer fails to advise them when they're pleading guilty or the like, that, hey, this could have immigration consequences. You're pleading to you're pleading to robbing a liquor store and bear spraying the cashier and, punching the cop. Like after that, they're going to deport you. So, yeah.
Oh, you guys are curious about the story of the lawyer that was drunk and fell asleep? No, that is really the binding. That's the precedent. That is against whom all others are being measured as far as what effective assistance of counsel is. It is pretty terrible. Sixth Amendment, blah, blah, blah. Let's see. DC Circuit, when confronted with the issue. Second, blah, blah, blah. All these. Let me see. Brown rule, settled the past 4 decades.
I also just want to note for the record, I've been mostly quiet, so these delays are all Rob.
Well, they are. But would you mind reading this part here?
The standard used to evaluate this inquiry warrants a brief discussion. In Brown, the DC Circuit held that any possibility that the removal stems from a juror's views of the case was sufficient to implicate the Sixth Amendment. The Second Circuit similarly held that a juror cannot be dismissed where the record raises any possibility that the juror's views on the merits of the case, rather than a purposeful intent to disregard the court's instructions, underlay the request for removal. That said, the DC Circuit recently redefined its position, holding that the pertinent question is whether there is a tangible or appreciable possibility, not merely whether there's literally any possibility, even just a theoretical one. Okay, I'm fair enough on that. Fair. So the DC Circuit's rearticulation of the standard under Brown follows the current circuit consensus. So the 3rd, 6th, and 9th Circuits employ a reasonable possibility standard. See Kemp, and that is as far as I can go without scrolling.
11th goes the substantial possibility. All of them kind of go to the same thing, right? Which is, and I don't even know if applying the analysis here is very difficult. She made the comment at various stages, I'm being pressured to do this. Like, I'm proud to do this. I'm proud to be here. But I started feeling anxious due to some of the reactions of my decision.
But everyone wants to convict, and I want to hang, and yeah.
Yeah. So, I mean, regardless of what standard you're setting, this falls within it. I like the Court of Appeals here. We recognize the district court faced a difficult situation, navigating the tension between the duty to dismiss jurors for misconduct and the equally, if not more important duty to safeguard the secrecy of jury deliberations is a delicate and complex task. It had been a long trial and a long day. This again goes back to my statement.
Yeah, but that's all the reason to let the jurors go home.
Well, that's what I mean.
Just tell them, go home, have some turkey.
Come
Everyone's going to ask you about jury duty. Tell them to go F themselves. Offer them a turkey leg with which to do it if necessary. And
it wasn't even Thanksgiving. It was having them come back on Wednesday. Not even Thanksgiving Day, Wednesday. So I don't see why this was a hard consideration for the judge. And again, it had been a long trial and a long day, which means, Judge, you shouldn't be making a risky ass move at 8:30 at night. See, okay, here we go. But to permit the removal of juror 88, where the record shows a reasonable and substantial possibility that was related to her views in the case, violates the Sixth Amendment. Our concerns are heightened in view of juror 88's statement that others disagreed with her decision, and that after nearly 8 hours of deliberations, the reconstituted jury returned a verdict in less than an hour. Violation of the right. So, and then they go through some of the government's counterpoints, which they dismiss. Looking at the motivations. I mean, a 37-page opinion. So having found that a violation of Laffitte's Sixth Amendment right to an impartial jury, we turn to the government's contention that any error was harmless.
No.
Oh, please. Yeah.
The government always argues harmless error, and they're never correct, but they always win on that.
They win on it all the time.
So.
Do you think they're going to win on this one?
Yes.
Oh, you do? You think they're going to win on this one?
No, I mean, I already know the answer, but...
Oh, you know the answer. But you thought your gut is, yeah.
My gut would have been yes.
And I would have been there with you, except for the fact that the court forecasted this decision way early on.
That's fair. Normally they're super yeah.
Oh, interesting. At the outset, we note that it's unclear whether the improper dismissal of a juror during deliberations is structural error or subject to harmless error review. If it's substantive error and not structural error, general rule is that constitutional error does not automatically require reversal. But there are certain errors, which can be known as structural errors, which shouldn't be deemed harmless beyond a reasonable doubt. Where any court decided the issue, government conceded oral argument in cases where this error was held to have occurred. Convictions were reversed without discussion of harmlessness. Oh, interesting. Look, usually oral argument doesn't bring out anything. And usually the government, the court will focus on the government made this point that solidified their case. Here they're like, no, during oral argument, you lost. Oh no, but then they punt again. Ultimately, we need not decide. I hate when they do that. They go through all this analysis and they say, ultimately, we don't have to get there. What a dick. Even under the harmless error standard, we cannot uphold the removal of juror 88. An error is harmless if it does not affect the defendant's substantial rights. For constitutional errors, the government bears the heavy burden of proving beyond a reasonable doubt that the error complained of did not contribute to the result obtained. And I don't think you can meet that burden here by a mile. Government has not carried its burden. 88 admitted that she was experiencing anxiety due to the jurors' reactions of reviews of the case, suggesting disagreement with the deliberation room. Indeed, before she was removed, the jury deliberated for nearly 8 hours. Following removal, the jury returned a verdict on all counts in under an hour. On this record, we do not find the government has shown beyond a reasonable doubt that removal of juror 88 was harmless. You failed. How many times could you read that sentence over and over again, Ian, as a defense attorney?
A lot.
It would never get old, would it?
No, I was gonna say I might take that sentence like into the bath with a nice glass of wine and just like let's just enjoy this for a second.
Yeah. It's something else. It really is. So yet the government argues the strength of the evidence submitted during its case in chief was sufficient to render any error harmless. But Judge, we proved the hell out of the case. So don't look now. Without passing judgment on the merits, we note the government presented extensive evidence that Laffitte engaged in charged conduct. Yeah, but the Court of Appeals doesn't care. Not at this point. Not with what they found. Now, in 9 out of 10 cases, the Court of Appeals is going to say, yeah, but they were guilty anyway, so we're going to keep them guilty. Fifth Amendment. Due process guarantees the defendant the right to be present at all stages of trial where his absence might frustrate the fairness of the proceedings. You mean like removing a juror? And the Court of Appeals says, yes, removing a juror outside the presence of the defendant or his counsel is reversible error. And again, the government goes back to their old bag of tricks. Go ahead, Ian. I didn't mean to cut you off. I'm sorry. I was just reading fast.
It's all good.
No, what were you saying?
I wasn't really. It wasn't important. Move on.
I thought you were. Fifth Amendment.
I don't remember where I was on that.
Removal of a juror outside the presence of the defendant or his counsel is, in fact, an important part of the trial.
Yeah, that's fairly critical, you'd think.
Yeah. The government argues harmless error.
Of course they do.
Oh, look, we have more colloquy.
Harmless error is like the government answer to every problem. They're like, oh, sure, there's an issue, but it's harmless.
Yeah.
You know, we shot your client in the face mid-trial, but it was a harmless error.
It was a harmless shot. They were going to get a hanging anyways. Right? So we just expedited the process. Judge, you were going to sentence him to life. It's not our fault. Harmless. So to satisfy that burden, the government argues that even if Laffitte had been present when the court decided to remove juror 88, the court would have removed her in any event.
How do you know?
Yeah.
And also, like, I hate the harmless error because it's like, okay, then what's the harm of just doing it right then? Like, why do we assume that the government gets to get away with playing fast and loose? Because it kind of suggests that if, that these rules are really just kind of optional. And I don't like that.
Yeah, I don't like any of that at all whatsoever. In so arguing, the government focuses on the following exchange between the district court and defense counsel. I love the Court of Appeals. God, I love you guys. I don't like you always, Fourth Circuit. Sometimes you really are dicks when it comes to criminal procedure, but you know, in this one, at least you get it right. So thank you. Mr. Daniel, we thought you were coming back to tell us what the jurors said or to give us what your decision would be so that we could object to it, and not the court cutting off Daniel. Okay, so you're now telling me that had I come back and told you that she was emotionally incapable of functioning and she asked me again to remove her, that you would have objected to that. Mr. Daniel, I did object to it. Mr. Austin, yes, Your Honor, I think we would have stated it's a hung jury. The court, it's not a hung jury. I have alternates.
Judge, it's not a hung jury. I measured.
I will never get past that statement. There is no way I'm ever going to get past a court having the straight up temerity to say it's not a hung jury. I have alternates. They can't decide. I can just swap someone in who will make the decision. That is so fucked up. What the hell? Where? Oh, Villanova Law, because it's fun to read things dramatically. It is.
Don't mind them. They've been sort of trolling off and on.
No, it's fine. I don't mind it. They can troll all they want. I just think it's wild. You don't get to, this is just messed up. And plus, federal district court judge, you don't do anything that's not dramatic. Sorry, if there's a federal district court judge that's watching me right now, I hope it's not in Eastern District, Virginia. And if it is, I am not me. I am a different person. I'll refer back to whoever I was before this. The government's argument is very colorable only if we ignore context. During the in-camera interview, Juror 88 tied her anxiety to her views of the case, which was a direct nexus to Laffitte's Sixth Amendment rights. Although the cited post-removal exchange shows that the district court expounded upon its decision to replace Juror 88 with an alternate, the court deprived defense counsel and Laffitte of their right to be present before the decision was made. It's that part, the before. It is reasonable to infer that if Laffitte's counsel, now this is an inference, I don't know if I'd go that far. If Laffitte's counsel was present for the in-camera interview or fully apprised of Juror 88's statements during the interview, that part, if Laffitte's counsel knew that Juror 88 had made the comment about, I'm being persuaded to change, counsel may have raised the implications of her removal as a result, and in line with Brown, the district court may have kept Juror 88 in the jury or declared a mistrial. I think mistrial would have been more likely. Not harmless error. Accordingly, we hold that the removal of Juror 88 also violated Laffitte's Fifth Amendment right to be present, and such violation was not harmless beyond a reasonable doubt. For the reasons discussed, we vacate Laffitte's convictions and sentence and remand for a new trial. So a whole lot. It's a whole lot of government resources. Pull Ian down so he comes back. A whole lot of government resources for nada. It's a whole lot of time and energy expended for a decision to be made at 8:30 at night that ends up resulting in a brand new trial for Laffitte. And it's where I get here, where I understand prosecutors and pushing to get to that finish line. But at some point in time, there's an element of caution that you have to, I guess, engage in, where, you know, how hard do you push? What do you do? So, I don't know. Ali Owl, unfortunately, this was in federal court. Federal court does not allow cameras taking place, no cameras in the courtroom, but I did read. So one of the reporters that was in court during this entire process was Fitz News. Fitz News extensively covered Alex Murdaugh and Russell Laffitte and the entire Murdaugh affair. And when I read their article, oh no, now it's behind a paywall. I read the article earlier today before it was behind the paywall, and apparently there was a bunch of people that were expressing concerns back when this decision was being made. The reporters that were in the courtroom, attorneys that commented on the trial during that time, who were actively following it. Fitz News, I know, covered it extensively, and I know they podcasted a bunch about this. This is correct, Julia. Ian can throw himself back on screen when he's back. So, will it be the same judge in the second trial? Likely, yes. So it's one of those things that you get a new trial, but a new trial is a chance, right? And people are going to say wasted resources, and it's not about that. It's about doing it the right thing for the right rate, the right reason, the right way. There. See,
I have the power.
He has the power.
Also, people were like, "We need to see the pins."
Ooh, fancy,
I got
fancy.
pins.
Very cool.
Also, it's a good thing I'm wearing a red shirt because
Did you stab yourself?
Well, the pin has like a little rubber thing and a metal spike on it, and right after I was putting the pin on. And Zora was being very friendly. Now, one of the things Zora does is she will leap up to try to like give you a hug. And so she leapt up and slammed a paw right on the pin that I hadn't yet got the end in. And I was like, ah.
You know what I'm going to say to that as her attorney? You invited it. You did the universal gesture for jump up and give me a hug. You were pinning it on your chest, which we know every dog perceives as come up here and give me a hug.
She's a good dog, but oh man, the stabbing was not something that I was looking for today.
Yeah. John Scott, thank you very much. Don't worry, government. If we don't like one juror's vote, we'll find one we do like. Didn't you get that impression a little bit? Just a bit, you know?
Yeah, I mean, we've got alternates so that we can find somebody who's going to convict here.
Counsel, it's not a hung jury. I've got alternates.
I like mine line better, but yeah.
I know. It's just, you know, I can read that as drab as you want me to read it, but it's still going to have the same impact. My God. Yeah. Moondragon, thanks for a needed relaxing night. Rob and Ian, thank you for being here. Jolly Roger, speaking of bad judges, did you watch Andrea's coverage of the Richard Allen trial? Terrifying. Mm-hmm. I caught pieces of it. I didn't catch all of it, but I caught several pieces of it, and I will tell you that every part of it gave me serious concerns. I also know that Andrea is not one for hyperbole in any respect, and when she is expressing things that give her dire concerns, I have no reason to doubt that judgment. She has never given me a reason to doubt that judgment. Mispronounced name. The judge said sequestration would happen during deliberation only, Ontario, if it makes a difference.
Yeah, but it's still
different.
It's still uncommon.
Yeah. Sandy, thank you for gifting memberships. I don't know why you're a mod, but you do it every single time. Thank you for growing the community. Francie Lou Who, thanks for becoming a member. Much appreciated. Steve A, to me, these notes spell mistrial. U.S. Court of Appeals agreed. That is correct. Catherine Frazier, Christmas decorations go up just before Christmas. You are in Ian's camp. Megan Durham, thank you for becoming a member. XCDA, so happy you're back making things. I started projects this last week too. Great. That's awesome.
Ideally, the timing should be that Santa is racing you putting stuff up.
Hey, Santa, just wanted to throw the tree up now so that you had something to put presents under. What are you having?
I am having a dark and stormy.
Oh, good beverage.
It is a great beverage, and I got some ginger beer, and yeah. The only downside is that if you drink it too fast, you end up breathing it, and ginger beer is not for breathing.
No, it's for drinking.
Yep, the breathing, not so good.
No, fluid in lungs is called pneumonia.
It depends how it gets there.
I know that because the walking pneumonia is going around the elementary schools these days, including, people. Lovely. Mama Wolf, FNF is just what I needed after a long week. Thanks for being here. Kristen M96, no snow in South Carolina. That trial was short. It was. Absolutely was. Chris Mullen, thank you for gifting memberships. Much appreciated. Canonical Heat, who's here every week. Thank you for gifting memberships. Much appreciated. Very, very much appreciated for all the support of the channel. Chris Mullins, everyone, all of you guys are amazing. Adrian Angevine, we had 4 cats. We would put the tree in the corner under the stairs and would tie the tree to the spokes of the railing and use only unbreakable ornaments.
That is fair.
I can see that. And I can imagine that even with all of those measures taking place, there was still damage. CS Tears, I've seen my daughter in the hospital after the shooting on Saturday. CS Tears, I got your email. I have not had a chance to read it all the way through, but I'm very sorry for what has happened. I will try to respond to that over the weekend. Thank you for sharing, and I'm very glad that you got to see her. Outside the box, we traditionally put up Christmas tree on 8th of December in Ireland to celebrate the Immaculate Conception of Mary. Interesting. We take them down on the 6th of January. I know that. The Epiphany when the Magi visited baby Jesus. Thank you for sharing that and your family tradition and reasoning. Elizabeth Me, so thankful you get the membership. Well, thanks for being a member. Elizabeth, go check out the shop stream videos. M169, outdoor lights go on Thanksgiving night.
So in Canada, it's a major party foul to put up the lights before November 11th.
Why? Why the 11th?
Remembrance Day, which is, sort of a Veterans Day equivalent.
It's our Veterans Day, yeah.
Yeah, and it's considered not cool to do that.
I can see that logic tracks.
That said, most veterans don't actually care, but there's still it's still not a thing that is considered good to do.
I get it. You want to be in good taste. I understand that.
Yep.
Bambarina Cone Guy was clearly a vampire who drank someone's drug blood and now is a wizard. The cool kids will get it. Okay. I missed that one. I'm not a cool kid. Nancy Druby made my first year, so look forward to FNF. Thank you for being here for a year. Thank you for that membership and congratulations. Laura Leanne, 27 months since you broke the bed with us, Rob. Well, that's a statement that could be made without context, given the fact that it's been 27 months since my first video. Celine, happy almost birthday to our robot queen, Kristen M96. Her birthday is in 2 weeks. Happy almost birthday, Kristen. Happy almost birthday indeed. I still have a present for you, by the way, that I need to get in the shop and make. But I'm back to making things, which makes me happy. So I can make more things. Maverick Angel, Best Friday Night Duo, and Peppers. Okay. Chris Gatqueen, I once sent a $12 book to a friend in England, and it cost me over $50. I can relate.
Oof.
Hawk Banana, no, it's not usury, it's UPS. That's pretty good. I like that. Yeah. Mary Coppola, we call this one out. It's Queen's Tax, not UPS, happens in the UK. Ian did the classification. Edward Wagner, I'm making a resin chessboard as I watch. That's awesome. Feel free to send pictures. I always appreciate that. It makes me very happy. The next poll will be, when do you take them down? I actually was going to ask that poll. So shall we wrap the poll before we begin the next topic? I think we should. So you have another 5 minutes to answer the poll, and then we'll ask the poll of when you take down your Christmas decorations. Lady Fang, I got called for jury duty for the first time, was super excited. They canceled it the night before, and I am now exempt for the next 2 years.
It's like when you want to do jury duty, they're like, nah, bro.
That's what I'm trying to say. It's horribly. So many people are like, I really want to do jury duty. And so many other people are like, this is the worst nightmare. I don't want to be on a jury. I would love to be on a jury. I will never sit on a jury, though. They will never allow me on a jury. I am automatically DQ'd in cases in Fairfax.
Yeah, I was going to say, are you allowed? Because in Canada, you're not allowed. Or at least in my area, I'm just disqualified.
You are technically, there's nothing that prohibits you from being there. But when I got a jury duty summons once. And on the back of that summons, it says, check any of the following boxes. And it says, you are an attorney that regularly practices in this court. And I was like, check. And it goes, do not appear. And I was like, oh, okay, fine. I imagine I could have arguably appeared dressed down in street clothes and tried to play it off. I also imagine that had I been in front of a few judges, they would have immediately called me out on the spot.
Yeah. Oh, and hey, Emily. I see Emily in the chat there.
Oh, hey, Emily. How you doing? Emily, we're about to cover a topic. We're about to cover a bankruptcy hearing that went not the way I was thinking it was going to go. And I'll give a little context to that. Let's see. Joshua, thank you for gifting memberships. Much appreciated. Again, you're a mod. Why are you doing that? But thank you. I love what you do for the channel. Thank you. Thank you guys. Thank the mods. Everyone that's in the chat right now, thank the mods for all they do to make this thing run seamlessly, to make the chat a good place to be, for keeping me somewhat focused and oriented. I mean, they could do a better job at that, but given the fact that it's both Ian and I on the same screen, I think they do a pretty damn good job.
Yeah, there's only so much that can be done.
Yeah, you could probably hit me upside the head with a baseball bat. I'd still get distracted and go sideways.
I feel like getting hit upside the head with a baseball bat would itself be pretty distracting.
It was a terrible analogy. I didn't mean it that way. You're better at those than I am. Apocalypse DOA, ask yourself, do you want to be right or be happy? Oh, when it comes to debating mischief manager, you know what? I don't know that there's... Do I want to be right or do I want to be happy? There's a strong... I can't give an answer to that question without getting in more trouble. I would like to be happy, but I'd like to be happy because I'm right.
Yeah, my answer to that is being right makes me happy.
So I don't know if I can give, I think it's the best answer I can give right there. Gretchen Call, in-house decorations and outdoor decor is different timing because weather. Fair. Fiona W., thank you for gifting memberships. That's very kind of you. That's a lot of memberships. Thank you very much. Again, to all those new members, please go check out the members only stuff. We do shop streams. We do book readings. There's a book that's sitting right in front of me that says Mike Lit. Shouldn't be hard to find. And yes, if you think that book has some interesting connotations, you're right. It is. People find it funny to send me these books, these children's books that are not children's books that I read because it turns my face around. And it makes me feel uncomfortable. I dropped something I need to pick up. Okay. Baby steps. Happy to have been here since the beginning. Just was late to membership. First ever membership. Thanks for all the moments, especially the Wood Daddy Stacks. That was a funny moment, indeed. Just reading a note from Sandy in the private chat made me laugh. Dina Kawaji, thank you for that super chat. Mary Coppola, you'll get that whether it's postal, UPS, or DHL. Oh, the Queen stacks or the surcharges, it's pretty wild. For the kids, why am I still a rookie after 2 years? I have to figure out how to change some of this stuff. I have to make channel changes over the holidays to try and figure some things out. WW, we have 3 birthdays around December 1st, so Christmas decorations will go up after the birthdays to give them their own space. I like that policy. It's a great policy.
Yeah, no, that is fantastic because a lot of kids who have they get the Christmas birthday.
Yeah, I get it. Light Queen, I made a wonderful tissue box sofa in the last few days. Now several friends want them. I'm going to have a busy weekend. Busy weekends are good. Torin 3, we are horribly tacky. We never take down our Amish Christmas lights. This Torin grew up Mennonite. Going to try for a shop weekend. Torin 3, please do. I love the stuff you make. Also, thank you for sending me the stuff on the dust collection. I'm still advocating. I will get a new dust collector. Rosebud 26, I see enough decorations at work. Retail. Ugh. Retail. Holy crap. I think that they're messing with us. I think they're trying to reprogram our brains because I saw Christmas stuff up before it was Halloween. Bop it.
And
Having
that's
a nice time.
unfortunate because Halloween is an awesome holiday, but Christmas is
awesome.
eating it.
Eating Halloween?
Well, it's retailers like Christmas better than Halloween because you buy more stuff on Christmas.
Side note, if anyone wants to see a fun debate between Christmas and Halloween, go to Ian Runkle's channel and go. Is it up?
Which the
Lawyers and
24-hour what's the 24-hour stream?
Yeah, the L&D part of it. The separate one
yeah,
for that.
it's still up and ad free.
So please go look at that. And while you're there, you'll also see a link to contribute to the extra live stream. You can do that. Please do that. But we did a 24-hour, or Ian did a 24-hour live stream, a part of which was a Lawyers and Dragons, which is where we play a role-playing game, tabletop game. And in this particular version of the game, we were all elves, and we were going to a town that had Christmas or had overstayed Halloween decorations and creatures, and had to destroy them or get them out of the area. And I was a manager of chaos, and I decided whether I was going to start my day with espresso or food based on a roll of the dice. And I actually decided whether I would start my day with pants or no pants based on a roll of the dice.
And we're really glad that the
dice rolled the right way. Me too.
Yeah.
But if you want some laughs, please go check that out. It is great watch and a lot of fun. And if you don't know Dungeons and Dragons or any of these tabletop games, please go check it out. I guarantee you're going to have a good time. Bop it.
The number of people who are like, I don't know D&D, and then ended up going, this is hilarious.
Yeah.
Was pretty entertaining. Also, there was one like curmudgeon in the chat who's going, I don't like D&D, and then later was like, this is the funniest. So yeah.
It's funny. It's funny because you end up finding out that lawyers are used to playing roles. Like we play roles in court, and we stick to a role very, very aggressively. My character did rails of straight espresso off the coffee bar. That was experience that I didn't have in real life. It would never do, but hey, chaos, chaos.
Doubt.
Rude. Bop it. Having a nice time as I recover from heart surgery. Oh no, Bop it. Bop it, the puppers, or Bop it, the puppers owner. Which one's recovering from heart surgery? Either way, I hope the recovery goes smoothly. Cookie Mon Steve, aloha from vacation land. Y'all never guess where I am. I hope everyone else is having a great week. I hope you are too, Cookie Mon Steve.
Hopefully
Chris
not
Mullen?
Canton.
No, Canton is not vacation place. Chris Mullen, you want to be the happy, don't be the dead, right?
Don't be dead right.
Don't be dead right. Yeah, I read it wrong, but still, it made me debate internally. I don't know. Torrin says, dust collection upgrade is fabulous. Enough flow through it. Doesn't entirely balloon the catch bag. Very little back pressure. Awesome. I'm glad that turned out. That's just a Harbor Freight thing that he had too. Okay. So we are going to end the poll on when it is appropriate to put up Halloween decorations. You're going to have 1 more minute to vote on that. So there's 4 options. When is it acceptable to put up your Christmas decorations? First option, November 1st. Second option, after U.S. Thanksgiving. Third option, just before Christmas. And the fourth option, put them up, but they never came down. There's 2,173 votes right now, and after Thanksgiving is taking the lead pretty substantially. Light Queen, starting October 10th, you literally see Halloween on one side of the island, Christmas on the other side. Ugh. Let holidays have their own life, please. Just let them do it. Okay.
Once upon a time, it was considered crass to do any sort of Christmas sale or whatever, because it was considered that was sort of taking away from the holiday.
Well, we're ending the poll. The poll is ended.
I don't know that I disagree with that one.
Which one?
The whole thing about, it being crass to do big sales for Christmas and so forth.
It
I feel like that might have might be a better world, but
Well, the poll has ended, and some of you are going to be upset. Some of you are going to be happy. 61% said after U.S. Thanksgiving. 21% said November 1st. 10%, Ian, you were in the 10% crowd just before Christmas. And there is a bold 6% of you who said put them up, but they never came down. So 6% of you. What is 6% of 2,100 people? How many of y'all are trolling me? What is 6% of 2,100? Of course I can't do math. I'm not going to do the math anymore, especially not live. Times 2,100. 126 of you. 126 of you have decorations up all year round. That is remarkable to me. So, and you know, you fly. I'm going to call it the freak flag. It's not a freak flag, but fly the freak flag high. You absolutely love that. I love it for you. Emily says, I said 11-1, but I don't yuck anyone's yum with Christmas. I put up lights Thanksgiving week, but November is fair. It gets dark here like 5 p.m. now, so it's love to see the lights. Here's the other. So talk about Christmas. My paralegal, Starbucks does Red Cup Day, apparently, when they switch over the Christmas cups. And if you buy I have no idea what this is. My paralegal, who does not drink coffee, sends me
you say that like it's completely unheard of.
Well, it's not. I don't drink coffee. My paralegal, who doesn't drink coffee, says, see, this is a thing. It's a big deal, Red Cup Day. I didn't know it was a thing. She calls me and she goes, do you like coffee? That's a very odd question. You know the answer to that. I don't drink coffee. Damn. Well, I got you a coffee. Okay. It's some caramel creme brulee something. I'm not going to drink it. Will you drink it? Yeah. Okay, fine. I'll drink it. Good. Because it was Red Cup Day and I needed to buy something to get the red cup.
What is the red cup?
I don't know. I don't have I have no clue what this is.
My work got me a Starbucks gift card. And I was like, I just sort of was like, you take it, because I haven't been in a Starbucks in like a decade.
Oh, so you get a free holiday themed reusable red cup to customers who purchase a special seasonal drink. Oh, that's why I drank the creme brulee espresso or latte or whatever it was. I mean, it was good. I think I had more sugar that I took in than I had all week.
But I already have a reusable cup. It's an Emily D. Baker.
It's called a cup. I've got it in front of me. If I bring one more cup into this house, by the way, I will get shot.
Yeah. I need to get more glasses. And the reason for that is one of the dogs, it's Potter.
I know. Where are you going with this? I just said if I brought another cup in here, I'd get shot. And you're like, I need to get more glasses. Why?
Potter swept a bunch of them out of our cupboard and onto the floor with his big swoopy tail. And yeah, we don't have a whole lot of the like tall drinking glasses. So yeah.
You want some of mine? I've got some to ship, but I'm not shipping to Canada. Never mind. Take that back.
I was going to say, they'd get expensive to send them out.
We had that debate. I don't think Potter did it either. I don't think you have the proof. Is Laura M. Yeah, exactly. Allegedly Potter. Exactly. Okay. So let's swoop and we'll talk about another funny, interesting, well, not funny, fascinating case that might, we're going to be respectful about this one. Okay. Swoop. So there's a person on the interwebs who's rather controversial. His name is Alex Jones, and his platform, Infowars, among others,
got him sued for every dollar that exists.
Every dollar he had. because among other things that this individual does, he went out loud and proud talking about how the Sandy Hook school incident was not real. And that got him sued for a lot. And the things that happened in that trial, while I don't agree with all of it, it was a lot. It was a lot that happened in that trial, but it ended up in a very, 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 very large judgment against Alex Jones in the favor of the families of these victims. Okay. So Alex Jones filed bankruptcy. And you guys might remember I covered some of this a little while ago, the bankruptcy filing. And I was asked a question rather directly. I think it might have been on Hunley's channel. Someone asked me a question of whether Alex Jones's accounts, whether his social media accounts, whether his Twitter account, whether his, the website, whether these things were all property of the bankruptcy estate. And people were advocating and saying, it's not property of the estate. It's part of him, yada, yada. And with the exception,
it's all him. It's all property.
That's what I mean. It's IP.
If Rob goes bankrupt, I will buy Law and Lumber, wait the appropriate amount of time for the bankruptcy to clear, and then give it back to him.
Everything has value. And the role of the bankruptcy court is to liquidate an individual's, well, in a Chapter 7 proceeding, is to liquidate an individual's non-exempt assets and distribute them, rather sell them, to amass money, quantifiable dollars, for the benefit of the bankruptcy estate. The estate then gets just distributed out to the creditors, who are classified in different class, whether you have special class creditors, whether you have priority claims, secured claims, unsecured claims of special class distinction, general unsecured claims. We did swoop, Laura. We can swoop again in a minute. So Alex Jones filed Chapter 7 bankruptcy, and several lawyers asked me, well, he's got these social media accounts. Are these assets of the bankruptcy estate that can be sold?
100%.
With the exception of a few. For example, his X or Twitter handle. So X has noted an appearance in the case because the handle, that little thing there, it's not really owned by the individual. It's owned by X. X has the right to terminate it, suspend it, do whatever they want with it. It's not really owned by you. So you don't actually own that handle. So X will at some point in time, they're gonna concede on some of the issue. But I think that they were just preserving their rights today. It didn't really come up that significantly. But
this is also interesting because I'm working on a paper talking about influencer law in Canada. And so one of the things I point out is that in certain circumstances, it might actually make sense to have forfeiture of channels. Where people's channels are basically crime. Like the guy who, that kid in the UK who kept breaking into people's houses.
I don't remember that one.
Oh, he got repeatedly, he got charged repeatedly for a lot of his videos because he'd do videos like he broke into people's houses. And this is a video, by the way, that you can only do in the UK, because if you do this video in Texas, the video ends up being a YouTube short. And
you've got about that. You've got that amount of time, essentially, until you get.
Yeah. So,
or as I've said in the past, break into someone's house in Appalachia and see what happens.
Yeah. It wasn't Johnny Somali. It was this other kid. I'm trying to UK influencer break and enter. Where is the
well, let's without
Mizzy is his screen name.
So Alex Jones is in a category of individuals that is honestly, we've talked about bad facts make bad law. Alex Jones is kind of that example. Like, he is the worst facts, terrible facts, awful facts. And those bad facts can lead to some results that people really want to see, but they might have a lot of questions being asked. So a lot of you probably saw this article. floating around. And you probably saw it yesterday. The Onion is a satire newspaper, which has remarkably hilarious headlines, articles, all of the above. Some congressmen are remarkably famous for retweeting articles of The Onion, thinking that they have won the argument, only to realize that The Onion is, in fact, satire.
There's a whole subreddit for people who have eaten the onion.
Hilarious of terms. So The Onion, and you'll notice there's a little case number at the top of this because it is, in fact, an exhibit to a filing, and a filing that made me very curious. The Onion has won the bid for Infowars' assets. Also not really entirely true. We'll go through why. This article was posted 11:53 a.m. on November 14th. We're going to go back to this 11:53 a.m. November 14th, which again, yesterday at 11:53 a.m., because the timing is rather interesting. Satirical news site The Onion won the auction to acquire conspiracy theorist Alex Jones's Infowars, which was sold off as part of a defamation settlement after he falsely Wow. Who published this? This is CNN?
CNN.
Jesus, of course CNN's wrong. So leave it to CNN, because now I get to call out CNN for doing stupid stuff. Satirical news site Onion won an auction to acquire conspiracy theorist Alex Jones Infowars. Sold off as part of his defamation settlement. No, it was not. It was sold off as part of a bankruptcy proceeding in which he filed bankruptcy protection, and the creditors, all of his creditors, filed claims in that bankruptcy, and the bankruptcy case decided to liquidate several of his assets to pay off the debts. Not a part of a defamation settlement at all. There was no settlement in that action. That case went to trial. He was not allowed to present evidence. The case resulted in a damages award that I think was what, $100 million, $100 billion, something like that. Emily is right. CNN seems to have fired all their fact checkers. Yeah.
I think that their fact checker now is Chat GPT.
Might be. People ask why
is
I get
this
pissed
fact
at news.
true?
It is people ask why I get pissed off at media, and it's this. No, your first paragraph is wrong on several counts. Paragraph 1. There you go. The Onion's bid was backed by the families of 8 victims of school shooting and 1 first responder. It also gave an exclusive advertising deal with the gun control group, Everytown Gun First Gun Safety. These are a lot of details from what we are going to learn was a sealed bid. It will also have an exclusive advertising deal with the gun control group. CNN was the first to report the humor website had entered the bidding. Well, CNN, I wonder how you got the news. And also, what the fuck, man? Can you just check your articles, please? No, don't do that. Jones previously ordered to pay $1.5 billion to the families. But he's dragged his feet on paying back any of that judgment, even as court records show he continued spending tens of thousands of dollars a month. Yeah, not great. Like I said, he is bad facts make bad law. Everything from the platform, studio equipment, online dietary supplement store, a Pterodyne armored truck. What the fuck is a Pterodyne armored truck? What is that?
He's got this massive truck, and it is armored. If you see, like, I'll try to. Did you look it up?
Yeah.
Yeah, it's a huge truck.
Seriously?
Yeah. I mean, I wish I had the money to make a bid on that thing, because that would be hilarious.
I mean, okay. Let me see if I can't pull this up for the chat to see. We'll show you what.
Let me put it this way. If I saved all of my pennies and got them all together, I could probably buy 1 tire for that truck.
Ian, if I pull a link, can I put it in the private chat? Can you pull it up so that I don't have to remove this from the screen?
Yeah. I'm trying to find the picture of Oh, here it is. Here, let me just pull up it's going to be grainy. Maybe there's a better one. Yeah. Here's a picture. It'll be grainy, but I mean, it's going to be on YouTube, so it is what it is. That's Alex Jones by his truck. That's the truck they're talking about.
Okay.
So it's a big truck.
It's a big truck.
Because Alex Jones is not a small guy, right? So, yeah. That's the truck.
All right. Big truck. Everything from the studio equipment, dietary supplement store, armored truck, social media accounts, and even a Winnebago motorhome was up for sale to the highest bidder. That's how auctions work. The amount of the bid was not announced.
Don't buy the motorhome. You will never get the smell out.
Probably not. Jones had used Infowars to spread some of those disturbing, disgusting lies and conspiracy theories in the public discourse. And he enriched himself with millions of dollars in the process, profiting off of a commercial engine he built off the fear that he peddled on his platform. People wonder why I say that there's a difference between news and editorializing news. This is a lot of opinion in there. I just don't necessarily know that you need to go there. I get it. The Onion is proud to, so this is a quote from The Onion. The Onion is proud to acquire Infowars. We look forward to continuing its storied tradition of scaring the site's users with lies until they fork over their cold, hard cash. The Onion CEO, Ben Collins, or Bitcoin. We will also accept Bitcoin.
They really should have gone with some really niche meme coin.
Yep. So that is the article. And here is the filing notifying of the successful bidder. Now, I will go ahead and tell you that the filing of successful bidder came after the article was published. So please take notice that Christopher Murray, Chapter 7 trustee for the bankruptcy estate, solicited bids for the auction and sale of the IP assets and relating the remaining assets consistent with the order. I'll get to the order in a second. The IP assets deadline for submission was November 8th at 2 p.m. Trustee caused notice to be sent to those bidders who submitted qualified bids, notifying them, 1, that their submission were qualified bids, 2, that they were invited to proceed to the final round of bidding on November 13th at 10:30 a.m., and 3, that the form and format of the overbid process for the IP assets would be by submission of highest and best bids in writing. This part is where we get confused. Qualified bidders submitted their final and best offers by the date of the IP asset auction. Trustee reviewed and considered the qualified bids, their cash value, their cash value, right? Their overall effect of recoveries for creditors in the interest of all relevant stakeholders. That part is going to get the trustee in some trouble. Just where we are right now. In his reasonable business judgment, the trustee had designated the joint bid by Global Tetrahedron, which is The Onion, and Connecticut Families as the successful bid at the IP assets auction, and Global Tetrahedron and Connecticut Families jointly as a successful bidder. All right, so that's the notice that gets filed. So we have a notice that's filed. Shortly thereafter, same day, within a matter of minutes, request for status conference. Comes now First United American Companies, the designated backup bid, and requests a status conference to address the apparent defects in the sale process, including changing the procedures, lack of transparency, and inaccurate disclosures to interested bidders. Because the value of the assets is in the process of being destroyed at this very minute, FUAC requests a status conference today if the court's counter can accommodate it. So they file something electronically on.
I know it sounds hilarious, but what does FUAC? What does that actually work out to?
Fuck.
That's what I was thinking. Like, it's got to be something else.
Sure. Fuck. So Flock comes in and they say, Judge, it is November 14th. I know that you just got this, but we needed a hearing today. And surprisingly, the judge obliges. Again, all of this is taking place. This is on the same day. You read an article, 11:53 a.m. The notice of the sale came out after that article was published. Then there was the request for status conference, and status conference was granted for 2:30 in the afternoon. So the judge said, hold my beer, we're going to go ahead and have a hearing. Everyone get on the damn phone, and we're going to do this. Okay. So that's the notice status conference. There's the article. Order granting trustees motion for entry of an order authorizing the wind down of the entity. So this is the wind down notice. This is what authorized the transactions, right? So auctions and sale, payment of the sale proceeds, sale notice, who's allowed to be there, who's allowed to bid, for what purpose. Here are the assets that are being disclosed, the time that the bids have to be submitted, the assets being auctioned, procedures for the bid, confidentiality part of it, identity, good faith. Like this was really well documented as what could or could not happen in this regard. Among the assets being bid were literally the studio, the website, everything that was happening. And there was still a debate going on where some of these assets, the court had not yet resolved whether all of these assets were assets of the estate. Oh, that's too fast. So let's pull this up, and you guys have to let me know if you can. Well, we're going to speed it up. Actually, I'm going to try and play it here so I can speed it up a little bit. Let's see. Just a second. It's down. Hang on. One sec. Open with. I can do this way.
So chat, while he figures this out.
I know. Sorry.
I am thinking I am going to have chicken drumsticks for supper. I have not started making those. Yeah, I also have an entire Hot Ones gift box. And or a challenge box. Oh, echo.
Oh, damn it. Okay. Here's what I have to do. Because it is yelling at me. Can you hear that one?
I could hear it.
All right. There is not closed captioning.
Sorry about that. Aaron Jones for the Chapter 7 trustee.
Thank you.
Joshua Wolfshaw also for the Chapter 7 trustee.
Howen for the U.S. trustee.
Good afternoon.
Your Honor, Steve Lemon for PQPR. I want to apologize to the court in advance. I don't expect that this is going to go on for too long, but if it does, I'm actually in Judge Perez's courtroom right now, too. So.
Sounds like a better place to be. I completely understand. I don't know how long this is going to go. I don't know where we're going.
I think I mentioned before.
I don't know what's going on, so, but if you need to leave at any point, I completely understand.
This
No
judge
worries.
sounds like he is the Crypt Keeper's older brother.
Yeah, he is not. This judge is not happy that this judge has granted a hearing. This judge, the notice gets sent out. So all this happens in the morning. And the judge sends this notice out and sets this hearing, and this hearing is now remote. And you hear all these people that are calling in. There's 20 people on the line. Ton of individuals. And the judge is and the other attorney says, I don't know if you can hear me, Judge, but I'm in the other courtroom. And he says, sounds like a better place to be. So he's just not in a good place. Celine, yes, you're watching the empty table because this is what I imagine some of these attorneys are sitting at. So that's what we're watching. Because rather you guys have visual than anything else and just hear anything.
713 number.
Your Honor, Walter Cisak, C-I-C-A-C-K, on behalf of First United American Companies.
Okay. Here's a
American.
214 number.
Oh, that's what Fox stands for.
Yeah, fuck.
I was like,
Good afternoon, Your Honor. It's Kyle Kempler on behalf of the Connecticut family.
Okay, good afternoon. An 832 number.
Good afternoon, Your Honor. Jared Martin from the Texas Families.
Alrighty, and a 212 number.
Good afternoon, Your Honor. John Weichselbaum, Weichselbaum, on behalf of X Corp.
Okay.
They just entered an appearance like this week. So X is in the building.
Okay. Mr. Cisak, you filed a request for a status conference. Why don't you get us started? I will level set the playing field in terms of my level of knowledge. So I remember we were here sometime in mid-October. There was a request to clarify what could be sold in an auction, and I was not comfortable signing the order because I couldn't make sense of what exactly was going to be sold, and I wanted to make sure that there was clarity as to what parties were going to sell and what was going to be purchased in terms of there was a separation between what were estate assets and Mr. Jones's assets, and that's where I left things. Maybe you can, I just want you to kind of start me from there to your...
So, this judge woke up on this fine day yesterday and was like, here's where I left things off. My understanding was we were still debating what was going to be sold. That's where my head is. And y'all are coming to me a month and a half later, or a month later, and someone's going to have to catch me up to speed. Because what did we sell? For what? So the judge sounds like he just woke up from a nap, and he's about to get inundated with a whole lot.
Knowledge, and someone else can fill in the gaps, but that's what I know. And I'm now learning about an auction, and sounds like you're not happy with the auction, so maybe you can kind of tell me where things are, and I'll listen to other folks.
Okay. Thank you, Your Honor. First, let me say that I apologize for my attire. I am in California. I don't have a jacket or tie with me.
Let's put all that. Let's put all that to the side. Let's get to where we're here.
He's like, I don't give a shit.
I don't care about that.
Thank you, Your Honor. All right. Yeah. I just wanted to make sure that I said that.
And the thing is it is important as a lawyer to
Honor,
say that, because otherwise you will run into the judge who does care.
Yeah, shoot out. Yeah.
And yeah, they will tear you. Now I'm just wondering, like, how inappropriately attired he is, because I am picturing he's wearing a big shirt that says like "I'm with stupid," or
and
like
it's pointing up, or yeah. I don't know.
Or it's pointing down. Was even worse.
Or it's pointing down. or his client sitting to his right and it's pointing to his right. But he's on vacation. I'm not going to fault the guy for being on vacation and this happening rather surprisingly.
My client was designated as the backup bidder in connection with the auction of the Infowars and FSS.
Yeah, holy fuck.
Assets, and that designation was made this morning at docket number 903.
So why don't we start a little bit, backtrack a little bit for me. So there was an auction.
Okay, so if anyone else is playing catch up real fast, the judge is like, hold on, back up. So you're saying there was an auction?
Yeah. Walk me through the beginning of this, because I don't know.
When was the auction?
Like, I don't know how we got here.
What happened, Your Honor? What happened is that there were qualifying bids made.
Okay.
And then rather than what the original plan was to have an open auction, the trustee decided that rather than do that, he was going to go to basically a sealed, secretive, best and highest offer, as opposed to having an auction where everybody was present and could see what other people bid and overbid. that's what he decided to do. And
to
so
your
there was
to your knowledge, when was this decision made? I'm telling you, the last public knowledge I have, and again, I was in October.
Also,
where
keep
there
in
was
mind,
confusion about the assets that were going to be sold. That's where I left things. So
the
you're
trustee's
telling
job
me
is to
that there was
maximize
a
the
kind of
money
a
brought in.
closed bid. To your knowledge, your client submitted a bid. Is that what it is?
Yeah.
All right.
my client, as other people.
At this point in time, I'm very sympathetic to the judge. The judge is very much like, hold on, y'all have been in this for a while, so you gotta catch me up on this one. And I'm gonna do this because is the audio loud enough for you, or can I boost it a little bit? Would it help?
You can boost it a little bit.
Okay, so I'm gonna remove this and I'm gonna do this because I found a way to throw it on the tab. And when it's on a tab, I can actually boost the volume a bit.
What happened is that there were qualifying bids made.
Okay.
And then rather.
Or is it loud?
No, that's good.
Misati, hang on. Because it's really difficult because they're all over the place on volume. Because it's Zoom.
Than what the original plan was to have an open auction. The trustee decided that rather than do that, he was going to go to basically a sealed, secretive, best and highest offer, as opposed to having an auction where everybody was present and could see what other people bid and overbid. That's what he decided to do. And
to your knowledge, when was this decision made? I'm telling you,
He's
the
like,
last
"Please,
public
for the love
knowledge
of
I
God,
have, and again,
tell me."
Yeah. Go ahead.
He's just like, please, for the love of God, tell me what's going on.
Yeah. Will someone please? This is one where every judge will do this, and lawyers, every single lawyer makes this mistake. By the way, every lawyer, young, old, doesn't matter. You have been living with a case for whether it's a week, a day, a month. You've been living with the case for a long time, and you are so invested in that case that you know the facts backward and forwards, and you start usually about a mile ahead of where you need to. Because you think that you don't even realize that everyone is supposed to be up at your speed, but you are a mile ahead of everyone else. So you got to back up. Like you got to be like, there was a man that met a woman and they had a child, and that child is me, Your Honor, and I'm in front of you right now. You have to start back there.
In the beginning, the earth was formless and void.
Exactly. Because the judge is like, the judge goes, look, I just told you that the last.
Sometimes you got to go through the begats.
you got to do the begats. But the judge is like, I just told you. I'm sorry for those of you who didn't hear me. I told you. Last I heard, we were having a discussion on an auction, and you guys couldn't decide on assets. And right now we're here. So, figure this out.
Was in October, where there was confusion about the assets that were going to be sold. That's where I left things. So you're telling me that there was a kind of a closed bid. To your knowledge, your client submitted a bid. Is that what it is? All right.
My client, as other people, submitted bids that were then to be determined whether or not, quote, they were qualified to attend the open auction. On Monday of this week, we were notified that in light of the types of bids that the trustee received, that the trustee decided, instead of going to an online live auction, he was going to scrap that idea and go to a sealed bid, high and best. And so he sent out revised bid forms and things of that nature.
How did you know what you were bidding on?
If the trustee gave us a list of the assets we were bidding on, we knew what we were bidding on.
Oh, the reason I'm asking is I didn't know what y'all were bidding on in the middle of October, so it sounds like that issue somehow got resolved.
Well, I think there might be there is a question on what the trustee called Lot 4 as to whether or not, because Lot 4.
I'll get there. I can't wait to hear about this. Go ahead.
Lot 4 was.
When the judge says, "I can't wait to hear about this," there's a little bit of dishonesty about that.
Or there's a little bit of, this is going to be interesting, as in like, oh, I just can't wait to hear how we got from, I thought there was going to be a debate on what assets we were talking about, and I'm now hearing about an auction. So I don't know. Let me see. Hang on 1 second. I'm trying to do something to help the chat out here. Oh, give me 1 second. People keep asking about the topic, and I'm trying to find a way to put this up so that people don't have to keep guessing. There. The Onion buys Infowars, question mark? That's the topic.
Someone says, Julia says, Ian, say things. I'm not sure which things you want me to say, but you should email me. I think, Julia, I think you're one of the people that there's still an ongoing thing with the auction. So email me.
Oh. Okay.
Was designated as disputed domains. So I wasn't involved in anything that happened before then. All I know is that there was some assets that were called disputed domains. In order to access any of this information, you have to sign a non-disclosure agreement and then have access to the data room, which we did. And so that's what we did. And then this morning we found out that after providing the best bid, highest and best sealed bid, we found out that we were chosen as the backup bidder. Sometimes those things happen. If you lose, you lose. But then... Wait,
hold on. I have questions. So you were designated the back...
Judge, I don't know if you know, but that phrase might be trademarked. I'm not sure if it is or not. Just saying.
The bidder. Did you have an opportunity to bid higher?
No.
Do you know what the...
And not only that,
wait, hold on a second. But how do you know what the winning bid was?
We don't, Your Honor. That's exactly right. Not only do we not know what the winning bid is, we found out from a news article that the trustee, despite no disclosure, despite telling me contrary, the trustee allowed the parents to do a credit bid on an unsecured claim.
So at this part, I was
driving basically in my car. Bidding money they don't have yet.
I was driving in my car on my way home, and I said out loud, "Holy shit!" And a lot of people. Let me explain what this means.
This is the point where the judge dropped his scotch.
Yeah, this is the point where the judge is, and the judge is going to get testy. So what he just said is that there were various creditors. I mean, Alex Jones probably owns a shitload of people, a shitload of money. Everyone does at some point in time. There's probably the vehicle loan dude. There's probably other personal loans. There's probably other claimants. There's civil claimants. I know there's civil claimants in various jurisdictions, right? So if this attorney is correct, and it's also if this attorney is correct, what the trustee did was the trustee said, I will accept all of these bids, some of which will bring in cash to the estate, and some of which will be a credit bid, which means the estate owes this person money, and therefore that person will forgive a certain amount of money, and in exchange, they will receive this thing. So, translating, the families to whom Alex Jones owes a shitload of money said, we will forgive a certain amount of this debt to the estate, or to this obligation to the estate. In exchange, you give us Infowars. And here's where I have a problem with that.
You're like, let me begin. No, it is too much. Let me sum up.
Let me sum up. In a world where we're talking about, ultimate comeuppance and karma and all the things that people have coming to them for certain reasons. You want to entertain a discussion about a credit bid where the victims get the assets? In that world, okay. In the context of a bankruptcy proceeding, where the ultimate goal of the estate is to maximize the return, the monetary return, for the various creditors and interest. Again, I go back to what the trustee said, the stakeholders. No. The creditors. Bankruptcy is not a process by which we rectify all the wrongs of the world. Bankruptcy is a process by which we liquidate assets that are not exempt, and we distribute the proceeds of that liquidation to third parties that are creditors. That is bankruptcy. This is transcribing. Not that ever. This is put out by the court. The court published this.
Rob is not breaking the law.
Not breaking the law. The court published this. And if
Rob
you don't
is not
believe
doing
me,
gangster things.
If you don't believe me, here, I'll show you. Here. I'll show you the docket. Because the court docket, because people are going to, and I don't want people to pick this up and be like, Rob's doing the blah, blah. No, I'm not. And I will actually show you the docket entry itself.
I'm going to be right back. I'm going to put, what is it? I'm going to start the oven cooking so that I can maybe eat something.
Yeah, let her in. Here, it's the court docket right there. This is the one, see? PDF with attached audio file. That's what we're listening to, the audio file. This is filed by the court. This is the transcript of the court proceeding. So that's what this is. And no, it's not a call out, anything else. I just want to make sure that everyone's clear. This was recorded by the court and released to the public because bankruptcy itself is supposed to be a very open process. Everything that takes place, we remember I covered the FTX bankruptcy, Sam Bankman-Fried, his case. Everything that takes place in a bankruptcy court is supposed to be done in the sunlight of day so that everyone realizes that what is being done is a fair disposition monetarily, that there's not any self-dealing, that there's no, imagine Sam Bankman-Fried showing up and his buddy, it's just all of it. All transactions have to be approved by the court. They can't be done under the table. Is very, very protected. So this is all public, and we're now learning that a credit bid exists, which was not outlined because, again, you remember in the declaration regarding what the sale was, and if I can go back, let me see if I can't pull that one up. What was that? Notice of sale. 903 was notice of sale. 903. Notice a successful bidder. Final round of bidding. Overall process. The trustee reviewed and considered the qualified bids, their cash value, and their overall effect on recoveries for creditors and the interest of all relevant stakeholders. This part. Bad people can make bad law. And I think we're kind of getting to that point. But again, I don't want to put the cart in front of the horse. We are trying to... Oh, A to K. Guys. I'll put this right back. I am trying to explain that when these articles run from CNN and everyone above and all the other stuff, that there's this conclusion that's out there in the public and everyone wants to do this spike the football and yeah, we did these great things. One, let's get our facts right. Two, you are running way ahead of the discussion. Way ahead of the discussion, because I doubt that any one of them listened to this hearing.
Disclosure at all in any of the filings that there was going to be allowed a credit bid. In fact, I specifically asked Mr. Murray in a conversation we had, are you going to allow a credit bid? And he told me no. And so now we find out that, in fact, the highest and best bid apparently was not the highest and best bid, but was allowed to credit bid apparently up to $1.5 billion. We don't even know. I've been on the phone blowing up everybody that you see on the picture here, everybody's email, everybody's cell phone. What happened? Tell us what happened. Nobody has responded. So we don't know what the winning bid was. We don't know what the credited bid amount was. We don't know any of that information, which is why we have asked for this status conference. There's been no disclosure. There's been no transparency. In fact, the disclosures have been
Wait. Do you know what the winning bid is now?
No.
Okay. Mr.
I have heard several attorneys argue in court. Very rarely do I have an attorney that's that discombobulated because they're that caught off guard. So I have no doubt that this completely caught him off guard. He's probably learned a lot, and he threw a lot of things out there that are clearly speculation or clearly conclusions he's made. Wolf Chiara, did the Onion complain to the judge, or why are they there? No, the Onion didn't complain. The Onion was they're the highest bid, or they were the bid that was selected by the trustee. The trustee is Mr. Murray. We're going to hear from him. He's the third person that's going to speak. And I don't think it's not that he's screwing anybody. I don't think that that's the case, but you're going to hear the bankruptcy judge explain, not that he thinks that anyone's being screwed, not that he thinks it was a wrong choice, but it's how it's being done.
Driver, I'll turn to you, and then I'll turn to the trustee. I just want to make sure that I understand. So who won the auction?
You're 10 minutes into the hearing and the judge doesn't know who won the auction. The Onion isn't the credit bid. The Onion joined with the families. The Onion didn't have the cash. The families had a credit offset. The backup bid, the one that the trustees said, oh, you guys were second place, which my understanding is it's a conglomerate of individuals that I don't know have a vested stake in Infowars or are friends of Alex Jones or are other third parties. I have no clue who they are. At this point in time, it doesn't matter. This is the point I'm making. At this point in time, it doesn't matter. I don't care who's bidding for the items. And the trustee shouldn't care who's bidding for the items either, because that's not the goal of the trustee. And it's not that the family wants to, it's not that. The families aren't wanting money. The families are not asking for money. The families want Alex Jones off the air. Let it play out, guys.
Do you know that?
Global tetrahedron, which I understand is the Onion and the Connecticut families.
What's
combined.
What's the Onion? That
It's a satirical, publisher website.
I don't.
If you put them in a website,
I'm not doing it. So Global Tetrahedron 1.
Judge, you can Google the website. I'm not doing it. I'm not doing it. What's the Onion? Someone tell me what it is. The judge is like, you missed that part. Hang on, I'll rewind it. It's kind of funny.
Connecticut families combined.
What's the Onion?
What's the Onion?
It's a satirical, publisher website.
I don't.
If you put them in a website,
I'm not doing it. So Global Tetrahedron.
This judge is so old.
So he's like, I don't give a fuck. I'm not doing it. I'm not doing it. I'm not Googling the Onion right now. Someone get me up to speed, because the judge is now, like, the coffee's kicking in. If the coffee's not kicking in, the judge is now going, I'm not happy with what I'm hearing.
Tetrahedron 1, the auction. Okay.
we don't know how much they bid, and we don't know how much the credit bid was, because the auction.
No, I got it.
Was not
I got it. Miss Driver, what do you know?
I love the judge doesn't say I want to hear a different. Who else knows some more that can fill me in on this shit?
Yeah.
Your Honor, so far the timeline sounds accurate.
Speaking as Alex Jones's attorney, this is Alex Jones's attorney, who doesn't really have a vested interest here. So, and she doesn't come across making that point.
She wants to get paid.
Doesn't, because the assets are being sold. The only interest she has is the methodology of sale and the implication it has on the timing of certain assets and how they're being used. That's her interest.
Mr. Jones was not party to any bid. He did not get direct communications, although the trustee and his counsel have tried to keep me updated as much as they can with information that's publicly available to other parties. What I do understand is that this morning the Infowars website was shut down. Mr. Jones was told he's not allowed to broadcast today. He did broadcast for a while. And I understand that the employees are being let go. What I don't understand is how much was bid, how much of it is some sort of a credit bid gift from the Connecticut families who only hold at this point. Your Honor's own order in the motion for summary judgment said that the ultimate amount of the non-dischargeable debt owed to the Connecticut families could change if Jones succeeds on his state court appeal. That appeal is still pending. So I don't know. I can see nowhere in the bankruptcy code or in any case where an unsecured creditor has ever been allowed to confer value to an estate, and how we could value that in a vacuum, not knowing if they actually have a final judgment. I'm just unclear. And quite frankly, I'm very concerned that there are employees who didn't know that they were going to lose jobs on a sale that hasn't been closed and money hasn't been transferred as of 8 a.m. this morning. It's been very quick, and we were very disappointed to see that there was
people
not
didn't
a live
know they might lose their jobs with a bankruptcy.
No, so when remember how this hearing started, where the court was like, I have not decided what assets are part of the estate or not. Certain things were there, certain things were not, and even when a sale goes through in a bankruptcy case, the sale goes through, right? So you bid on something, but the court still has to approve it. You don't get it. There's no rights passed at that moment. The second you are the winning bid, you have no right or entitlement to anything until the bankruptcy court passes off on it and says, okay. And let's say that you want to, as the trustee, you want to sell the item, but you're concerned that the assets might be dissipated or that something might happen to the assets after sale that might make them valued less before you get to a judge signing off on it. Well, what do? You ask a judge permission. You say, Judge, incident to this auction, I'd like the ability, when the auction concludes, to secure the assets and terminate the service to this stuff. This is,
You got to figure there's a potential to be out of work when your company is going.
Well, you do. So I'm not really crying for this whole Alex Jones thing. I'm not crying for him at all. But I'm saying is the auction takes place, and all of a sudden the assets are possessed, taken. They're removed before any ultimate disposition is signed off by the judge. So I agree. I don't think
the dogs
employees
went back
were shocked.
outside.
What?
Oh, I see people commenting that the dogs are making noises. Yeah. Specifically Potter. Potter wants back outside because Potter is like, so I go to like take some stuff and put it in the, and like get the oven ready to go and preheating. And Potter's like, I want to go out. And Ripley's like, I want to go out. So off they go. And then Zora and Potter. Zora's like,
you said Ripley.
I did, which is a dog I used to have. But Zora's like, I want back in because it's cold out here. Potter, on the other hand, loves the cold. He's just like, okay, that's where I want to be. So I'm going to go tell Potter that he's got to chill the F out. So, Potter.
And the chat's also there. So the family's claim isn't set in stone yet. So how can they use it as big collateral? Kind of, a little bit. Isn't it the judge's fault for not knowing what's going on? Not really. The judge signs the orders, but the judge has an expectation the orders are going to be followed, and we'll get to that in a minute. We will get to that, I promise.
It's held in a realm where overbids could be had.
Okay. Let me hear from the trustee or his counsel.
I'm happy to talk to you, Judge. What you've just heard is mostly inaccurate, and I think we're talking about something totally different.
Let's start with, was there an auction?
Yes.
There was an auction.
All right. I'm going to turn this up a little bit because the trustee's quiet.
Mr. Cisak says he didn't know that he doesn't know what the winning bid is, and he was not given an opportunity his client wasn't given a bid to bid higher.
Right. So
is that right? No. Let's just start here.
No, that's not true.
That's not true. Mr. Cisak, he's saying you're not telling that that's not accurate. Okay.
All right. So we knew this was going to get spicy, and here we are. And now we don't know who's yelling at who, because the judge is not yelling. This is kind of close to, this is getting there. We're getting there.
So now someone tell me, was there an auction where somebody said, I bid 10, you got 10 minutes, let's go to a higher number?
So
that's when I think auction.
Right. This is the auction procedure that the court approved in September.
But then y'all came back to me.
To add assets.
Add stuff.
And we didn't add them.
And you're saying that I approved some secret?
No. I wish I could have a chance to explain.
Oh, here's your chance.
FSS has assets. We filed a motion to wind those assets down in auction. We hired an auctioneer. We had a process. We had a timeline. We had a marketing process. There was a list of those assets. That was never in doubt. The court approved that. Everybody got notice of that. That's the auction that happened. We came in October because there was a request to include.
They don't even know the winning bid.
No, they do.
He says he doesn't know it.
Well,
Mr. Cisak, they're saying that you don't know the winning bid.
At this point in time, I was laughing my ass off. I fucking love this. I'm sorry. This is the drama.
They're saying you do know it.
No.
Your Honor, I guarantee you, if you ask Mr. Murray whether he has told us what the winning bid is, he's going to say no.
Well, he just said you know.
We don't know. He's not. He's lying. He's not saying that.
He's lying. Whoa.
All right. Well, let's figure out. He says he doesn't know the winning bid.
No. Under the procedures, the court approved. We're required to say.
Does he know? Does he know the winning bid?
He doesn't know the amount. He knows who won.
Oh my God! But how's he going to overbid?
We asked for a.
By the way, that was the judge laughing like, oh my God.
Yeah. And when the judge is laughing at you like that, it's a bad place to be.
Yeah. So now, for all of those that were complaining that I was late, are y'all now understanding why I was late and why it was important that I listen to this audio?
This is like if you encounter a new dog and the dog gets that big, toothy smile and starts making the real bass rumble. That's what that laugh is like.
Yeah. Yeah. It's this point in time, here's the thing. It would be helpful if the judge actually lets you explain. It would be helpful. Here's how you get to explain. You would get to explain when you answer the judge's question. When you dodge the judge's question, the judge starts attacking you because the judge sees that you're trying to wiggle away from their question.
The judge is like, I'm going to keep biting you until you, until you figure out why.
If you want to hear the wiggle again, we can hear the wiggle again because
the list of those assets.
Wiggle. Yeah.
Proved that. Everybody got notice of that. That's the auction that happened. We came in October because there was a request to include.
They don't even know the winning bid.
No, they do.
He says he doesn't know it.
Well,
Mr. Cisak, they're saying that you don't know the winning bid. They're saying you do know it.
No.
No, Your Honor, I guarantee you, if you ask Mr. Murray whether he has told us what the winning bid is, he's going to say no.
Well, you just said you know.
We don't know. He's not. He's lying. He's not saying that. I think what he's trying to do is part.
All right. Well, let's figure out. He says he doesn't know the winning bid.
No. Under the procedures, the court approved. We're required to say.
Does he know? Does he know the winning bid?
He doesn't know the amount. He knows who won.
Oh my God! But how's he going to overbid?
We asked for a round of highest and best bids.
But how do you know it's for highest and best? I mean,
because I have both of the bids and I analyze.
But how do you match one against the other and say, okay, now somebody put this on the table, can you go higher?
Because one person bid just cash and another party bid cash and another mechanism.
Was there a credit bid? Was there a credit bid by?
That's weaseling. Did you hear the trustee said one party bid just cash, the other party bid cash and another mechanism, and as he's saying another mechanism, the judge goes, was there a credit bid?
By the families.
Sort of. It's not a credit bid because they're not secured.
That's it. We're holding an evidentiary hearing, and I'm going to figure out exactly what happened. No one should feel comfortable with the results of this auction. We're going to hold an evidentiary hearing, and today's just a status conference. I'm going to understand exactly what happened. I'm going to give parties an opportunity to fully explain it to me. Not comfortable with the process and the highest level of transparency that took place. I approve.
So, yes, John Smith, you're right. That's a sealed bid. Sealed bid auction in a nutshell. Yeah.
The thing is the judge didn't approve a sealed bid auction.
He quasi did. This is where I think the trustee has some latitude because I think there was more that went on in the hearing. I think the trustee might have snuck an order past the judge. And I got to go back and listen to the audio from that hearing. But I think the trustee snuck an order past the judge that didn't really reflect what the judge, because you hear the judge is confused about the auction part, right? The judge intended there to be an auction, an actual auction where there's the possibility of an outbid. And I don't know that this is right. Now, where the trustee steps in it is some of the approval stuff. All right. So even if the judge allowed the silent bid, did you allow for a credit bid?
No, hold on. I approved an auction. Auction means you go, I bid 20. We go, someone says the highest current bid is 20. Go to 25, go to 30. How can I say, you don't know. He doesn't know what the highest bid is. So his client couldn't overbid. His client couldn't bid higher than the current bid because no one knows what it is.
Well, he could have bid more. We asked for highest and best, and his bid wasn't.
But he doesn't know what the last bid was. So how do we know that you got the highest and best?
I mean, I could explain it, and I guess we'll do that.
All right, no. I'm going to stay quiet. I want you to explain to me your process.
All right. FSS has many different categories of assets. It's got some domain names, it has IP, it has trademarks, it has equipment, it has inventory that it sells. When we started the bidding process, what the auctioneer advised was, let's have a round where people can submit sealed bids that say which lots they're interested in and how much they would pay for each one of those. And then under the auction procedures, when those come in, we evaluate that and then decide how to proceed to, if we do it all, the next auction. The order is very clear that there doesn't even have to be another auction. I could decide based on the qualifying bid. We ended up only getting 2 bidders, but they bid on slightly different sets of assets. And so we talked with the auctioneer and we said, how do we do this? How do we go lot by lot and say, well, how much for this and how much for that? Some bidders wanted some assets, but not others. Some bidders wanted one lot, but only if they got the others. So there wasn't a real way to do an apples to apples money bid. There's another layer of complexity, Judge. It's not just money for the assets. What the Connecticut families did with their bid with Global Tetrahedron is they said if Global Tetrahedron...
Hang on. I got to turn this up because you need to hear this part. This is the trusted explanation. What?
I said I can barely hear it.
Yeah, I'm turning it up. So because you need to hear this part. This is the crux of his argument. So here's the thing. The auctioneer was faced with a very complex situation where people are going to come in with cash, people are going to come in with credit buyouts, people are going to come in with all kinds of stuff. So there needs to be a setting where, one, we can figure out who's actually got the goods to make the purchase, so we actually can go and filter through who's qualified to make a bid, right? So we sift out the qualified bidders. And of those bidders, we go to those bidders and we say, here, you're a special subgroup. And this subgroup now gets to submit a bid. And what you would expect, or what at least the judge seems to have expected, is the judge expected that that subgroup would have the opportunity in an open bid situation to put a bid on the table, and then the other group would have the opportunity to counter that bid. And the trustee's trying to explain that, Judge, that's really complicated because I'm looking at different values. One is a credit swap. So basically saying, I will release this debt that you owe me, and that has value, right? The estate no longer has to pay money out to me. They have money to pay other people. And you'll also get some cash. And they come to the table with that bid. Well, what the judge was contemplating was that another bidder would be in the room and would see that and would say, that is not really dollar for dollar. So what if we up our dollars and we do this higher amount? And ultimately what you get is a bidding war, which is what every bankruptcy estate wants because you want the best payout. You get a bidding war, and in that process, you find the strongest bidder, or you allow an opportunity for a back and forth. Here's the thing with sealed bids, sealed auctions. There are sealed auctions that allow for one, which is the highest and best, where you come in with your highest and best offer and then you just choose right off the bat, one shot. In no world is that the best outcome for the estate. Yeah, see? Common bankruptcy, the debtor tries to devalue it all and buy back just what they want for the pennies from him. Exactly. You actually want a bit of a fight.
Yep. Now, I mean, here there was an interesting aspect of, there's only 2 bidders, which was interesting. They said.
No, there were more.
Okay, I thought they said there was only 2.
No, there were 2 that were chosen as the winning bid and the alternate. And no, Nebraska Jeff, I'm not saying he was paid off at all. I'm saying that, you want me to get to the punchline of this headline of what it would have read? Alex Jones's friends buy Infowars to keep Infowars up and running. That's what it would have looked like. Or families of children that were mocked by Alex Jones take down Infowars and sell it to the Onion. You have 2 headlines that can run the next day after this bid. And I think that there was, I don't know.
All sorts of room for
there
headlines.
Wasn't a real way to do an apples to apples money bid. There's another.
Hang on.
but they bid on slightly different sets of assets. And so we talked with the auctioneer and we said, how do we do this? How do we go lot by lot and say, well, how much for this and how much for that? Some bidders wanted some assets, but not others. Some bidders wanted one lot, but only if they got the others. So there wasn't a real way to do an apples to apples money bid. There's another layer of complexity, Judge. It's not just money for the assets. What the Connecticut families did with their bid with Global Tetrahedron is they said, if Global Tetrahedron, if this is the winning bid, they will waive, and they're unsecured of SSS, which I think I need to maximize their value, they would waive their potential recovery and give it to all the other unsecured creditors so that those other unsecured creditors would be better off than they would be under an alternative only cash offer. That's why it wasn't simple. We thought about all the different ways that we could do an auction. It was never going to be a live auction on the courthouse steps. That was not ever the way we were going to do this, and we never said we were going to do it that way. We told everybody, we said, here's a bid form that's the different permutations of combinations of lots that we think people are interested in bidding in. Submit your bid form and tell us what you think, what you would be willing to bid on each one of these things, and give us your highest and best. And then once I get those, I can analyze them against each other and figure out which one was better. We did that, and I've got a spreadsheet, and I can show you the analysis that we did, and I can walk through it. The bid that Mr. Cisak presented was for $3.5 million.
I know, don't put the numbers out because no one knows anybody else.
Don't put the numbers out. Open hearing, Judge. And by the way, articles that published this ran with this figure. And it's correct. The trustee shouldn't have done this. This is fucked up. This is really fucked up. Now, granted, this is going to come out at some point. It is. And you guys, here we're going to fight. We're going to fight the fight now. I'm going to fight the fight now. Part of the agreement was that the trustee had discretion in the winner. Trustee had business judgment rule. The business judgment rule was in the trustee's favor. That was what the trustee had to rely on, which means business judgment. Business judgment rule does not allow you to make decisions that are contrary to the natural business interest of the estate, which is monetary equivalent. To make sure it wasn't sold Jones's friends. And I know that part of the negotiation was that, but that's also why there's approval of the sale. The court is pissed, not that fuck didn't get it. That's not the problem. The court's pissed in how the process played out because it has the underpinnings of looking shady as fuck. It looks shady.
And the reason why it looks shady is because it appears to be super shady.
I get why people want it to go to the Onion. Ian and I were openly laughing about this, saying it is objectively hilarious that the Onion bid and got this asset. I agree.
I mean,
it's hilarious.
There is just no way around that. It is objectively hilarious.
But the process, that's the problem.
Else's numbers. We'll have an evidentiary hearing. Today's just a status conference. He doesn't know everybody else's number, so let's not put anybody else's number out there today. Not for purposes of today. So I got it. He put a bid.
Right. And the alternative bid had a cash number that was lower than his, but with this other mechanism, the creditors ended up significantly better off. And that's why I chose to select that as the winning bidder, and that's what we gave notice of. Now, we want, and the buyer wants, an additional order with some of the additional bells and whistles.
He's so quiet.
Findings and things like that. So we intend to file a motion and come back and.
I don't blame him. The judge is on attack mode, so the way you counter that attack mode is you calm the hell out of yourself. You've been there. I've been there.
Yeah, but he's super quiet.
I know. I even gained up 600%.
Ask for that.
I'm not blaming you. I'm just going
out in detail the way the math works. But it's not something where I can just say the winning bidder was X dollars, because that dollar amount isn't.
You hear that part?
The buyer wants an additional order with some of the additional bells and whistles of a sale order and good faith findings and things like that. So we intend to file a motion and come back and ask for that, at which time we can lay out in detail the way the math works. But it's not something where I can just say the winning bidder was X dollars, because that dollar.
We intend to come back and propose to the court an order of approval, at which point we can lay out how the math works.
Fair.
But shouldn't you have how the math works before you award the winning bid?
Also, shouldn't you and your microphone be located in the same time zone?
Yeah. Reader, that's kind of that's the concern. That's what the trustee allowed here. Now, in this case, the claimant had a $1.5 billion, arguably $1.5 billion claim. But again, the judge also said prior to, as far as the dischargeability of that claim, that was subject to review on a court of appeals. So it's not even
a final decision.
Amount isn't really known yet. I know within bounds what it is. I know what, because there's a mechanism. I know that it's certainly much better than the second offer. It could be way, way even more better, but that depends on things like
way even more better.
The ultimate claims pool ends up being. But all I know is I have a virtually guaranteed gift, essentially, from one group of creditors to another. And I've never seen this before in any other case, and we did a lot of research and we've never found it. But I've always thought my goal was to maximize the recovery for unsecured creditors. And under one bid, they're clearly better than they were under the other. And that's how I made the decision. And this was not an attempt to sell assets that we asked the court for permission for in October. That's a totally separate issue. It's a completely separate set of assets that we are not. They've always been excluded from this auction, and we're not dealing with those today. These are the assets of FSS that back in September we said, we want to wind down, we want to sell them. All of the creditors agreed, let's sell FSS, let's wind down FSS. And Ms. Driver's wrong, I didn't fire the employees today.
Did I give you authority to authorize waivers of recoveries?
And this is where he gets into it. Not that, Amber, I'm not calling you out for any reason, because I know that this is a reason why a lot of people feel this way. A lot of people feel this way. You are not alone.
It's also not that it's against Jones. It's against everyone else who is owed money here. Because if all they get is a credit swap, like is, a waiver of this, then there is no money to pay out to anyone else, that's going back into the pool. So some of the people who Jones owes money to might be decent human beings. I mean, at least one of them statistically must be.
And here's the thing. No, the fundamental problem isn't that he announced the winner. The fundamental problem is that he allowed for a mechanism of bidding, one, that was behind closed doors and didn't allow the public to see what was going on or allow people to come back in and challenge the bid. And two, it was that he allowed for a mechanism in a credit swap or in a credit charge off. He allowed for a mechanism that was not previously approved by the court. The court didn't sign off on that methodology. That's the problem. And this is why I said bad facts make bad law. And it is these cases, and in criminal cases where you have the worst defendants. What was the Florida kid where the judge just completely railroaded him? The death penalty case. That one. The judge behaved terribly. And the judge got taken off, removed from the bench. Well, took her name off the bench. Cruz, yeah. Bad facts bring out something in us where you want redemption, justification, you want karma, you want the justice system to do something that honestly it's not designed to do. The bankruptcy court is not designed and cannot be designed. It's not a punishment tool. It is not a punishment tool. It's not something like that. And you have to apply the law equally. And I know people make examples left, right, and center about how it's unequally applied. I get it. I 100% get it.
I have a peeve about chicken, which is that even though it smells delicious, you can't be like, it's cooked enough, I'm just gonna eat it. It's like, nope. Yeah.
And Zealous Boot, perfect. We don't know how much the Onion will be paying. You're exactly right. Exactly right. If it's $3 million and all the Sandy Hook parents released claims on any money that would be ended up, you're right. You're 100% right. But in this process, what the judge contemplated is that someone who was in the room or allowed to be in the room would be able to see that bid and say, okay, then we'll go 5 million cash, 6 billion cash. And it's still subject to the court's approval. And the court can still do the same analysis. Who's buying it? For what purpose? Is it an insider? Is it just getting Alex Jones's property back? Is it all these things? All of these things still happen. It is the problem with the process of the sale. And the judge just asked the question. And the trustee, John, you got to go back to biblical times if you want to take an issue of bankruptcy. And I mean that. Like, go back 3,000 years. Bankruptcy law is bankruptcy law. And no, it does not get people out from under their debts. This debt was deemed non-dischargeable, which means that he is never getting out from under this debt, ever. And there's only so much you can do.
I mean, if he somehow manages to make
1.5 billion, doubt it.
Yeah. By the way, chat, I could really use like a billion or two.
Says, and Ms. Driver's wrong. I didn't fire the employees today.
Did I give you authority to authorize waivers of recoveries?
No.
Your Honor, may I be heard, please?
In a moment,
and
Mr. Kimpler.
He's like, sit down. I'm not done beating on this.
That's a whole nother issue. I don't know anything about that. I'm just learning about what happened here.
Yeah, but you got, yeah. And so we have a disappointed bidder who's making lots of accusations about a process and calling it secretive.
He didn't answer the question.
It's not. Sealed bid doesn't mean it's not an auction. It doesn't mean the public couldn't participate. We had hundreds of people request information.
He doesn't know who the winning bidder is. He doesn't know the winning bid.
Because it's hard to describe the number.
Well, no, it is secretive. He doesn't know the winning bid. Right? No one knows what the winning bid number is. No one knows what the winning bid number is. They don't know.
I could give you
that there's no. I'm just saying it's not like he's completely unfounded. I understand it's more complex than maybe Mr. Cisak understood it, but perhaps my concern is the lack of transparency in the process. He doesn't know.
I bumped it to 1.25.
And maybe it's the better deal. I don't know whether it is or it isn't. I just know there wasn't transparency in the process. So some person's putting up cash and some person's putting up cash and agreeing to a waiver, it sounds like, but no one knows what everyone else is doing. Okay. Mr. Kimpler, you asked to speak.
Yes, Your Honor. I would like to just clarify because there's a lot of...
Hang on. I'm going to address this. I'm going to address the chat. I'm also addressing the mods in the chat. Guys, I'm not dissecting Alex Jones's conduct or the underlying trial. None of it. We're not going to it. We're not talking about it. We are talking about right now, and this is why I'm talking about this case right now. Take every bit of emotionality out of the equation. You have to. This is bankruptcy law. That's what it is. It is dollars, cents, creditors, assets.
It's Chinatown.
We are not going to go back and evaluate what took place in the underlying trial. Words, conduct, whether or not a judgment was the proper amount, whether the process was fair, whether it wasn't, whether the families got what they could. This is not about that case. This is about the fact that there is a judgment, a $1.5 million judgment. That judgment is on appeal to the Supreme Court. We don't know whether the judgment will be changed, modified, reversed, remanded. We have no clue. We have a judgment by a trial court that's on appeal. So we're dealing with a claim filed in the bankruptcy court that could be 1.5 million, could be zero. We don't know. No, M169, don't be sorry. Do not be sorry that you asked. Don't. It allowed me the opportunity to kind of readdress
We
this
love
issue
people
because
asking.
I saw the chat going and having this debate. And I want to make sure that we're not having that debate, that we're redirecting the debate to where we are here. I don't care about the person. And if you're talking about the person and Alex Jones, you're off topic. You're not listening to it. Yes, you know, not that ever, I don't mind that. Listen to other podcasts. Go listen to other podcasts about other things about Alex Jones. Go and make your opinion about him. I'm talking about the liquidation of an asset and monetary value coming back to creditors in the bankruptcy estate and how that is done fairly. And how when, remember I said the Russell Laffitte, not Russell Laffitte, there might be some very, very, very bad characters where we think there are 11 jurors that are sitting there in the jury room and they all have him convicted. And there's one juror who's saying, I'm very firm in my belief, and my gosh, I'm firm in my belief, but I feel very much anxious about the pressure that's being exerted on me. And a judge says, we're not a hung jury, I have alternates. That's what we're talking about. You cannot make exceptions for the worst of them. Just to get to a conviction. Or just to bring karma.
Versions being made that are completely unfounded here. First of all, the bid.
This is counsel for the Onion.
As Mr. Murray just said, what you last heard in October is a totally separate issue.
Got it. I got
None of that is being so. So this is just the order that you entered on September 25th.
I'm with you.
All right. Okay. If you look at page 6.
I read my order. I read my order. Are you telling me that I approve?
He's like, I read my order. I also wrote my order.
Yeah. Walking a fine line, counsel. Walking a very fine line, please.
The way Mr. Murray just described it.
Your Honor,
I'm just asking you. I'm asking you if you're saying. Okay.
I believe it is.
I think okay. I just disagree, and that's okay.
Well, if I could just explain, Your Honor, maybe we won't agree, but I'd like to at least know where it's coming from.
I've been there too. I've been there. Ian's been there. We've all been there. Where you are, like, Judge, you got. Let me make my point. Let me make my point. And the judge's like, I'm done. You're done.
Okay. The definition of purchase price.
I read it. I read it. You'll have your day in court. You'll have your day in court. You read it.
Okay. Your Honor, and just I have no problem explaining what we did. My client.
I'm not worried about. My concern is not what your client did. Not at all. I don't know. I have zero concerns about what your client did. I'm more focused on the process and the transparency in the process. That's what.
Thank you, Judge. Thank you. And chat, please, I want you to hear that one more time because, my God, everyone who's been, I was terrified to cover this because man, you get into Alex Jones and people have fucking opinions. No, they have opinions. Ian, before you say it, they have opinions. They don't have fucking opinions. They have opinions, but they're very strong opinions.
I mean, they could be that kind of opinion too.
I guess they could be, but the judge just said it.
You read it.
Okay. Your Honor, and just I have no problem explaining what we did. My client.
I'm not worried about. My concern is not what your client did. Not at all. I don't know. I have zero concerns about what your client did. I'm more focused on the process and the transparency in the process. That's what your clients. My concern is the process itself. Your clients were participants in the process.
And
I got no issues with them.
We faced the exact same concern that Mr. Cisak is. On Monday, we were informed that we were supposed to submit a best and final bid.
Got it.
We knew that. I didn't hear anybody object to that on Monday or Tuesday or Wednesday.
I got it.
We had to have the same discussion that he had to have with his client. Well, I don't know what the other bid
I don't. Yeah, but okay.
But it was an even playing field. That's all I'm saying, Your Honor. There was no disparity of information that we had information he didn't, or vice versa.
Yeah, and I hope I'm not. I'm not conveying that somehow you knew more than Mr. Cisak. I hope I'm not conveying that, because it's not my.
However, let me draw attention to something the judge just pointed out that's going to be fodder for a lot of people on the media, and why this should have never been a sealed auction. Ever, 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 ever. Ian ran away. This should have never been a sealed auction for one express reason. Because of what the judge just went into. People are going to make the accusation, founded or not, they're going to make the accusation that the trustee somehow tipped off the families what the other bid was. Or the trustee gave an indication to their family that they should come in with a credit bid. Or everyone else. People are going to make the accusation. They're absolutely going to do it. You know what makes that accusation easier to make? If it's a sealed auction. Why? Just fucking why? Why open that door? Why go down that road? Why would you allow that to be made? Why would you even open that door? It just, And of course, the attorney for the Onion's like, well, Judge, we absolutely didn't know that we didn't get any advance. We were not treated any differently than the other person. Well, now 90%, like there's a bunch of population out there, not 90% of one side over the equation. I don't give a shit how you want to say it. There's a bunch of people out there in the droves who are probably sitting there saying, well, he obviously knew what was going on. He knew that it was going to be this amount. He knew that there were going to be these bids, and he came in with the credit bid swap, and he was the only one that knew how to do that because the order didn't expressly call for that. It's just asking for problems. And that's why the judge is pissed, because the secrecy, the behind closed doors, the just, why would you allow the questions to happen? Just why? Why would you even allow the implication? And here's the other part about this. I imagine there's going to be a discovery at some point, and I imagine we're going to find out whether there were any other credit bids. If the Onion was the only credit bid, and it also opens the door between the conversation between the Onion and the families. I mean, shit, like this just kicks open the door to a whole discussion that we didn't need to fucking have. If this debate had just been, or if the auction had just been open. If it had been open, standard auction, people show up on the 13th and they continue to outbid each other.
And the thing is, you know, with all of this stuff about like some people wanted some assets, some people wanted, you know how auctions have solved this since the beginning of time? You just
auctions.
Put the auction, like you just put the shit up and you don't take.
Yeah.
And it's just like, oh, you don't want all the assets? Well, you're bidding on all the assets. And if you don't want some of them, then yeah. Like, you know, in the same way, if you bid on like all of the contents of a storage locker, you get the like gold statue, but you also get like the box of dirty underwear. And you got to figure out what, you know. So
bop it. Yes, bop it. I used to do sealed bids, all bids opened at the same time. Then a bid competition with additive and deductive alternatives. The results were then published for all to see. It's all about transparency. It is. It 100% is. It is so infuriating. And that's where the judge is right now. The judge is like, how the fuck did this happen? And I'm sorry. Like, you can say a lot about Alex Jones, but I will guarantee you one of the highest value items that he has after this many years that he's been in business are his. Oh, no. Let you be down. We're going to get there. I'll get there. I'll bring that up. My gosh. Yeah. Okay. Yes. Sealed bids are commonplace for state-funded projects in Argentina. Thus, corruption is plenty. So you're being pissed off about it is understandable. It's not just Argentina. It's no-look bids. It's no-look bids in the U.S. No-look government contracts where there's no look at the bid. It's all of these things are automatically granted. It is honestly, it is the fount of it just. Just because something yielded the correct result when you did it one time doesn't mean it's replicatable in every instance. We have foundational principles that we need to stick by because, my God.
My intent or that your clients did anything. I'm more concerned about the process.
When we heard there was not going to be an auction, but instead a request for a best and final bid on Wednesday morning, I went back, I looked at your order, I said, can they do that? And I said, I found multiple paragraphs where they said they could do that. I had no idea that the trustee was doing that until we got the same notice that Mr. C said.
That makes two of us. I got it. Mr. Jordan. The families, in my opinion, I don't think they did anything. As far as I know, they haven't done anything wrong. You haven't done anything wrong. What you're hearing out of me is I'm concerned about the process where
he's like,
even
I'm pissed
today,
at the trustee, not you.
Mr. Cisak has no idea what the winning bid is, but he's the backup bidder. It just seems odd. Maybe I can say it that way. And got it, your client won, but they don't even know what the winning bid was.
We know what.
I'm just saying that's just odd. That's the part and you don't even know what the backup bid is. Sounds like.
I want to be, in my view, the bid should be made public. I have no problem with that.
I got it. That's what I find odd. That's what I'm finding odd, Mr. Kimpler. It's process. That's what I'm finding odd. That's what I mean. In every bankruptcy case, it's public. People know who the winning bidder was, right? There's full transparency in it.
Yeah, I think what Mr. Murray was saying was the idea was they announced the identity of the bidders this morning. There was going to be a request for a hearing to get a sale order. All of the terms would be public and everybody would have a chance at that hearing, which is typical, I think, of many sale hearings, to then object to the sale.
Darian, I think you win so far for the comment that I have most enjoyed seeing in this dialogue. Darian, with the comment that brought me out of a sadness, I'm concerned that this may not even be the Onion's lawyer. Is he a paid actor? Is this satire? Is this proceeding even real? Well, Darian, given the fact that there is an image on the screen of a green desk and no one at the head of the desk, and we're hearing audio that, may or may not be real, I would caution you. We have no clue whether it's real.
ChatGPT doing a great job.
ChatGPT has manufactured the voices of everyone on screen. Or you can verify it just by going to the court docket and downloading it. But is this the real world? Is this fantasy? Well played, sir.
You could fault everybody, and fairly so, for saying you should have disclosed all of the terms this morning when the notice was filed on the docket. And that could have been done. I think that there are still agreements being negotiated. That's frankly an issue with Mr. Ashmead's client and FSS, not me. But I think the idea was they're trying to finalize the documents. They'll then publish the final sale agreement. They'll go for a hearing, and it will all be public. I don't think anybody ever thought that this wasn't going to be.
If I'm the judge right now, and I wish I could see the judge, because I'm imagining that if the judge was on, not camera, he'd be like this. Yeah, that's what I fucking contemplated when I thought the word auction. that it would all be public and we wouldn't be having this debate.
Yeah.
100% transparent.
Okay.
I think the objection that there was not a traditional auction where everyone's in the same room, I think that's just a different dispute, and we can have an evidentiary hearing on whether that was necessary.
Your Honor, may I respond just really briefly?
Now,
the real issue here.
Hold on a second. I'm going to hear from Mr. Jordan, and then I'll hear from Mr.
Thank you,
Cisak.
And I'll be very, very brief. The biggest concern we have is that the sale has been put in place. I tried to get on the website because we were told that the business was shut down. Alex Jones was instructed not to go on the website, to not broadcast, and I tried to get on, and it's closed. Now, maybe the trustee says, no, I decided not to close the sale and give it to the buyers and let everybody sort through the problems. Because one of the problems we have, and again, I'll be very brief, you instructed us that if there's disputes about the IP, that you don't want that property sold, you want it to come to you first, let you decide, and then have a clean sale. But they sold hundreds of websites, 100 websites with Alex Jones' name. They sold one with Alex Jones and another very high profile talk radio. It has nothing to do with the case. They sold those with only a notation disputed when you said don't do that. So the only thing I would like to ask the court is, can we stop this treatment of the sale as if it had closed and as if the buyer is now the owner and he's telling people what to do, and just put it off for the few days or time that you need to give us an evidentiary hearing? That's the only request I have.
Mr. Jordan, no one has told me here, and I don't want to read into this, that my understanding of what Mr. Kimpler was describing to me was that someone was, and I think Mr. Murray did the same thing, they were going to file a motion and they were going to ask for a traditional sale order, and that this would be subject to dispute. So I don't, if somehow, I don't know what you're talking about with the web.
Well, Mr. Trustee, you might want to chime in and tune the judge into the other part that you didn't really let him know about beforehand.
Site being down. I do recall in the prior October hearing, there were some questions about websites, and I said, let's just figure out what's property of the estate and what's not property of the estate, but let's just have clarity so that buyers know exactly what they're going to buy. And if I needed to make the call, then let me make the call. I don't know, but I'm being told that has nothing to do with what's being described here. So maybe it does make sense to have an evidentiary hearing on this. Mr. Cisak.
Yes, Your Honor. The one thing that I think has come across loud and clear is the fact that it was never disclosed at any time that any bidder was going to be allowed to make a credit bid or waive claims. And in fact, your sale order says that the purchase price should be in a specific amount of U.S. dollars, not a range. And what we're hearing today is that Mr. Murray can't even tell you what the amount is. And if we knew, and it was full disclosure, and they came to you and said, Your Honor, we've now decided that we're going to allow or request the authority to allow credit bids or waivers of claim to be considered. If we knew that, we might have bid something differently.
Well,
we did not have full disclosure.
Mr. Murray, are you contemplating now that you identify the successful bidder and the backup bidder filing a motion for approval of this sale?
Well, I am now. I thought it was approved in September. Apparently nobody understood that.
No, Mr. Kimpler, it sounds like...
That part pissed me off too. The fuck you say? No, you do an auction, you get the dollar figure, and then you go to the judge and you say, Judge, here's the potential bidder. Can you please approve this? He thought it was pre-approved in September. And Nanner, yep, in the family's waiving some or all. Yeah, it could be a shitload of money. It could be. We don't know. The problem is none of that was transparent. he's like, Judge, I thought you approved this in September. If I'm the judge, the fuck you say?
It was like there was a misunderstanding as well, Mr. Kempler, because I think you were contemplating that someone was going to file a motion and this would be all public knowledge as to what it was, but now it seems like that's not the case. Well,
Your Honor, all I can say is in any 363 auction I've ever been in, I assume there is an auction. You don't always get the full purchase agreement the next day.
I agree. No. I agree.
To be published, it will all be public.
But you were contemplating me signing an order too.
Yeah.
I believe that you would need to sell.
This is the judge putting the trustee in a corner and saying, trustee, you're in a corner. Everyone else is saying they were on the same page. You did not do that.
I'm sorry, sign an order. I think the order that you entered in September authorized the trustee to sell the asset.
Mm-hmm.
I think a buyer, understandably, would like a sale order with traditional findings and things that you see in a sale order. You have obviously not approved that. We have to come back and get your approval, and the way this would typically work is you would file a motion, you do it pretty quickly after an auction, and we'll come back and we'll defend the sale if there are people that want to object to it.
My understanding of what the trustee was describing was that he didn't need one, and so that's why I said we need to have an evidentiary hearing to then determine what it was. And if someone's going to file a motion, then that would then serve the purpose of having the evidentiary hearing. Mr. Wilshire?
That is the intent, Your Honor.
I feel like the judge wants to fumigate the courtroom right now.
Yeah, it kind of
I believe
does.
what he was alluding to is that the sale process had been approved because we do think it had been approved. What we intend to come in front of the court with is the details of the offer that was the winning bidder and ask the court.
So has the sale closed?
Not, absolutely not.
So can you, if they're disconnected, just tell me they're disconnected.
Okay.
Mr. Jordan and Ms. Driver, I think, are connecting the results of that auction that y'all had, well, the result of the process that you had with like the closing of a website and stuff like that. Is there a connection between the two?
Yes, Your Honor.
No, hold on a second, Mr. Driver. I need to hear from Mr. Wilshire. What I'm saying is that's my understanding is that what you described. I was trying to convey what you described and just ask Mr. Wilshire if there's a connection between the two.
Well, there's a connection, but it's not for the reason that I think that they think. I mean, it's not because there was a sale that has occurred. It's because as a result of us doing the notice, which now set in motion the fact that we're moving forward with a particular bidder, there is significant concern now that everybody knows who it is, that the assets need to be locked down. We were always contemplating that the FSS was going to be shut down and wound down.
Mm-hmm.
Mr. Murray has conveyed to the employees that we're going to pay beyond like all.
No.
I think through the end of the year.
Hold on.
Why is it pausing? No. You've been behaving. Stop. Don't do this.
No. If you can just mute your lines. I apologize.
So, Your Honor, in answer, there's for sure a correlation. There's been an announcement as to who the winning bidder is, and I understand Your Honor's concern with it. The idea was we would be coming back into court with a motion and an order that would set out all the details of it. But now that everybody knows who the winning bidder is, in Mr. Murray's business judgment, I think he exercised it the way he should have. He went to Austin and began the process of securing assets, locking things down. It is true that you know the servers are down and that the show is not currently being publicized, but he has the ability to do that whether we're selling the assets or not. And because of who the buyer is, there is a significant concern that assets would start going out the back door because people don't like who the buyer that's been selected is. We intend to be in court next week.
You know what you do? You ask for that approval before you do the fucking auction. That's what you do. This is I understand every concern. Every concern. I get it. 100%. Russ, what if on appeal the judgment gets reduced and it's below what they gave the credit for? Uh-huh. That's a problem. That's one of the problems. That's one of the problems with this. Yes, that's right on the button, right there. That was what was said earlier. Yep. Laura Lienny.
So could it be, it might be funny if the families ended up on the hook for the difference. you know, that wouldn't be a complete absolute gong show of like, you know, Sandy Hook families now owe $12 million as a result of buying Infowars.
Lori Leanne, no. I want to clear this up. It's a good question. I highlighted it for this reason. If there's a credit buy in exchange for the $1.5 billion, right? So the creditors have said they will waive their claim against the estate for $1.5 million, right? If they get Infowars. Then can Alex be discharged eventually? No. The debt was deemed non-dischargeable because the debt was resulting from personal injury. So Alex Jones is always on the hook for that debt. What they get paid out in this instance from the estate is different. So it's not a total waiver. Now those circumstances could be different at the ultimate disposition, and the judge could require that there be an ultimate waiver. But at this point, no. Ian Paler, thanks for an impartial overview of the Infowars snafu. Yeah, I heard this and I read their news articles and I read what was going on and I was like, I want to listen to the audio, and the audio got released today. So I read the pleadings and I was going, I have some concerns. And then I listened to the audio and I was going, holy shit, what the hell is happening?
And the thing is it's not like, you know, everybody's always like, why do you like this person or whatever? And it's not about that. I defended a guy who had committed, I think probably like 200 crimes, but he didn't commit this one, right? And that's the key thing, right? Is like everybody deserves fairness.
Yeah, and Chelsea, to your point, the discussions tonight are hard but important. They do not need to be avoided if we want to move towards fairness for those without resources to fight. I agree, these discussions are really hard, and not that Amber, who I've been disagreeing with in the chat, like, and trying to explain stuff. Yeah, thank you for the super chat. The thing is, of all the things that happened this week, right? So you had Corey Richards, you had Karen Reed, you had the Russell Laffitte. This little audio hearing, right? This one hearing that's just transcribed via audio, in my opinion, is the most important of all of those things. Because it's the process and it's the how the sausage gets made. And what you're also hearing is you're hearing how lawyers talk to each other when they're in motions. Lawyers in motions practice, oh no, we don't pull punches. We don't act nice to each other because we're in front of a jury. No. We argue. And we make our fucking point. And the judge oftentimes has to play mommy or daddy and basically say, no, you guys get separate. You stay in that corner, you stay in that corner. I'll deal with you later. Shut up, stop talking. I'll listen to you in a second. But this is the...
By the way, don't ever call the judge daddy.
No. Nope. Don't do that. Don't do that. And also never say, I would submit to your honor. Never say that. That's a bad phrase. Bad phrase. This is lawyering. You get a shit sandwich thrown at you at the 11th hour. You have to jump up and make your case, and you have to do it with limited facts and adversaries from all ends, and you have to do it on the fly. This is lawyering.
Yep.
And also, this is why we love what we fucking do.
Mm-hmm.
And honestly, I want you guys to know this for the truth. Just because people are standing up and arguing on behalf of Alex Jones does not mean that they support Alex Jones in any respect.
I mean, people are always like, oh, why do you support your client? And it's like, well, I argue my client's position, but that doesn't mean I like the client.
Exactly. They have a right to have their case heard and their arguments heard. And they have a right to call bullshit no matter who they are or how nefarious they are as a character.
I do criminal defense. The vast majority of my clients, I would not bring to my house.
Before your honor, to ask for approval of the sale Mr. Murray had the ability to wind down the FSS operations at any time. He chose to go down there and basically make sure that everything was secure because there was an announcement as to who the winning bidder was. And that bidder is somebody that I don't think everybody is going to be happy about. And so we have not transferred anything. We haven't given the buyer access to anything. We haven't executed any documents with the buyer. We are still putting the final touches on the APA that we intend to file when we file the motion to approve the APA. So I think what Mr. Murray was saying is we believe that the sale and the sale process was approved, but we are coming in front of Your Honor with details about what the sale is. We're going to have an APA, and I think what I hear Your Honor saying is you want to hear about how we made the decision and how the process went, and that's going to be part of what we present to the court when we come before you.
The other question I have for you is, it sounds like some websites were sold, and you're telling me that they're not related to the stuff that people were asking for on the 18th, but I do recall, whatever, we met in October, but I do recall us having a conversation about, if there's some confusion between what Mr. Jones thinks is his assets versus what the trustee thinks is property of the estate,
I mean, somebody's getting kicked into a hole right now.
But I also said, if you and the Jones folks can agree on what is purely a state asset versus what's not, I probably don't have an issue. I think I said something to that effect, but I don't know. It sounds like they're telling me that you sold some stuff that they think is Jones-related stuff, and my concern that I said on the 18th, and I got it may be the same, different assets. I think I said I wanted to make sure that the buyer didn't purchase something and then later have to set up litigation on the back end. I'd rather deal with it on the front end and say this is a state property, but I found it, and then parties can then go appeal me, as opposed to kind of going to state court and fighting about it there.
And that's the other part. There were several questions that I saw that this now brings relevant. Ada K, is there a chance this would redo the auction? They would redo the auction submitted for client.
There is a chance. The judge could go there.
The other thing is, the reason why the court has to approve the sale is that order is appealable to the district court to review and make a determination as to whether that sale gets approved. When you go about it in a process that is maybe not the most clear and transparent, you fuck up the whole system.
Yeah.
Is there a concern? They're expressing that some of this is going to be subject to dispute as suit, and I'm just trying to make sure. I know you told me that's different, but I think we also talk generally about concepts. And are there some things in here that folks are disputing from your understanding, or they seem to be shaking their heads yes? And again, I don't want to get into what's going on. I just want to make sure that you all feel comfortable that the buyer knows that these are true estate assets, and that there's no. So someone's going to ask me to make that the trustee was authorized to sell it.
Yeah.
Right.
And I think, look, Your Honor, I remember the conversation we had in mid-October about this issue, and if Your Honor recalls, we were talking about the things that we were asking for permission to sell that were in the individual bankruptcy estate, and we did tell Your Honor we might come back with an agreement as to how we were going to deal with those assets. But I did say, and I don't know if Your Honor remembers, I did say, Your Honor, I want to make sure that we're not going back and retreading issues related to the order that you had entered in September. The wind down order.
But y'all can only sell estate assets, right?
Well, we can only sell, in this instance, we can only sell assets that belong to FSS, which, and Your Honor didn't give us, we haven't come back to you on the other assets. Now, if what Mr. Driver and Mr. Jordan are saying is that, some of the assets that are in FSS's name, we think those are also individual assets. I mean, we can have that discussion with them, but this is a different conversation in my view.
It very well may be. I'm just trying to flesh out all the issues so that when we show up on whatever date we show up, and I want to make sure that Mr. Ashmead's client knows exactly what they purchased, and that there's no, if I sign an order, that the order gives him at least some comfort that he can say, my clients own this free and clear, and I suspect he's going to want something so that they can, if anybody challenges it later, that you would have an order of the bankruptcy court, a final order of the bankruptcy court that they could then go use and protect their clients. And I'm thinking, Mr. Ashmead, about your client. If they're the successful bidder, I'm not sure you were here on the last conversation. There was a different.
For those keep asking, Lady Drake, no, it's not for fuck's sake. It would be funny if a judge was saying for fuck's sake, over and over again. But no, FSS is what they keep referring to. It's Free Speech Systems LLC, FSS, which is the entity under which Infowars operates, and all the things that the entity owns. That's FSS.
Set of assets, and I just did not want to create a situation where somebody purchased assets and then got sued in some state court in the middle of, who knows where. And, and it was because we didn't do the hard work up front. And I wanted to just smoke out these issues before then. And it was, I agree with Mr. Bush. It was a different set of assets that we were describing then, but I conceptually was just concerned about that issue.
And I think
just about what 541.
That's why one reason that we come in next week, right? I mean, I think that would be a perfect opportunity for us to lay out in the sale order so that there is no confusion and so that we're not inviting a situation where Your Honor's having to deal with disputes, every, week and a half because somebody's complaining something was or was not on the list of assets. So I think that would be a perfect thing to include within. And I would suspect that Mr. Laffitte is going to want that specifically in the sale order, and that's part of why they had requested that we actually, proceed with a more traditional sale order that includes things like good faith findings.
Mr. Weishenbaum, I think you had your hand up. I just want to make sure I was responsive to you, sir.
Thank you, Your Honor. So, for the record, Jonathan Weisselbaum of Layton Watkins. I'm appearing on behalf of X Corp, and my colleagues Caroline Reckler and Chris Harris apologize that they're not able to make it. Ms. Reckler is traveling back from being part of you this morning. I thought this was a good point, just a good time to just make one remark about the assets that you were discussing. All
right, he goes in and tries to preserve the issue. So, the punchline. No, it was not satire when we saw the article that was being thrown out there that the Onion bought Infowars. It was not satire. It was an auction. It took place. And the auction is subject to a very, very, very large debate as to whether it was proper, whether it was improper, what happened, all of the above. I mean, what could happen from here? There's a hearing on November 25th. Let me see. When was that hearing set for? Where's the hearing? It was November 25th, I think. So the hearing is descending. Hang on. Audio file. Oh, by the way, the trustees submitted an application for compensation. So, bankruptcy counsel for the Chapter 7 trustee. So Christopher Murray is allowed to have an attorney. The attorney is allowed to bill the estate. The attorney billed the estate from June 14th until October 31st. That's not bad. $14,000 for the attorney. Now, application for compensation for the first interim trustee, for the trustee themselves. Hang on, I'm going to show this. This is too good. Application for compensation for the first interim trustee for the bankruptcy trustee. This is the trustee. This isn't the creditors. This isn't the families. This is anybody. Christopher Murray for allowance of compensation and reimbursement of expenses for the period from June 14th through October 31st. $593,000, 114 cents, or so $593,114. Expenses, which are the lawyer fees, $14,034. Oh no, that's counsel. That's counsel. That's the lawyer. Here's the lawyer fees. So the Chapter 7 trustee who's allowed to have a lawyer. The lawyer is always, by the way, in bankruptcy cases, the lawyer is always the firm at which the trustee works. The trustee is allowed to hire their own firm to be counsel for them. So lawyer fees, $593,114. Expenses, $14,034. Application for compensation for Jones Murray, attorney, $427,000, $773, and $5,442. Yeah. For those who are wondering how these bankruptcies work. And yes, the trustee gets paid before any creditor. That's how it works. Next hearing in this case is November 25th, I believe. Where's the minutes? Minutes. Nope. Yeah, I'm going to say November 25th. Yep, Monday, November 25th. So, yeah, that's what the trustee gets paid. Oh, no. You're up to $1 million for the period from June. That's for one period of time. From June 14th of 2024 until, so that's 4 months. 4 months, you're up to $1 million. 4 months. Here, I'll do this. Let me filter this by application for compensation. Filter. Three 339 690 623. I'm guaranteeing they're well over 2 million right now. I'm almost guaranteeing it. Yeah. So it's no joke. And no, it's not just greed. It's hard fucking work. It's really hard work. Exactly. It's really hard work to be a trustee in a bankruptcy case. Laffitte, in a bankruptcy of this size, the only ones who make money are the lawyers.
I mean, that's true of a lot of cases.
It's a lot of litigation. Okay, I'm going to cover one more topic, and it's going to be Karen Reed. I know people want to see Corey Richens, but unfortunately, that feed was funky. Also, Ian said that he was going to cover Corey Richens, and his chat's been asking to cover Corey Richens. So, let you guys know, he and I are always on the same page usually, except when it comes to like logic and what we agree with and don't agree with. So we're going to cover Karen Reed. Same with divorces. And you know what? I'm a divorce attorney, a bankruptcy lawyer. And honestly, I wish I took home less. I really do. I wish that, I don't know. I wish people were not assholes. And that I wish it wasn't the case, but people want to litigate everything. Everything. So, wait, where was it? On the same page other than Google Maps. No, we're just on different maps. Just different maps. Darian, I've been there and done that too. It's hard cleaning up people's messes. And let's do this because we get our first glimpse in this Karen Reed case. It's pretty quick.
That case needs to finish. They should have just acquitted.
Haven't even started yet. We'll see. I like the new special prosecutor. So we get our first glimpse. Hang on, swoop. Well, God, Rob. Let's see if there's any questions first that were relevant on the issue. Amount not discharged. Yes. 1.5 portion, 1.5 by the estate. The amount that gets satisfied by the estate, or the amount that they are saying was satisfied by the estate, they cannot go after Jones for. You can't get double recovery. If you are waiving a certain amount, right? So let's say the sale amount is 3.5 million plus 3.5 million from the waiver. The amount that is waived by the claimant they can't go after Jones for that because they actually received compensation for that. That's how that works. Jamie,
if Rob goes bankrupt and he owes me $10 and I like take his shiny lights and I waive the $10, I can't also go and get the $10.
Correct.
I got the shiny lights. I don't think Rob's going to go bankrupt.
Thank you for becoming a member. Lynn, the print, waking up and starting at the beginning. Oh my, it gets spicy. Hang on. It'll be fun. Lauren would have preferred Ian's auctions tonight. Can you commit to a date, please? I will defer to Ian on that, and we'll probably do that at a later time in the deferral. Mispronounced name, gifted 5 memberships. Thank you very much. Megan, aka Meg is autistic. Thanks, Rob, Ian, mods, and chat for keeping me company while I make a Grinch cushion for my niece's 3rd birthday coming up the first week of December. That's fun. Keep making stuff. Like I said, I made something this week and it made me feel like $1 million. Honestly, keep doing it. Torin 3. For our first anniversary, I hired Mrs. Torin 3, a divorce attorney. I imagine there's a whole lot more to that than you could fit in the little box that you had.
But I kind of want to see you try.
I don't, but you can message me anytime and I'm happy to listen. Oh my. Megan, this is fantastic. Love your streams. Thank you, Megan. Shiraz, thanks for becoming a member. Much appreciated. 80K, thank you for making this accessible to the deaf community. 80K is streaming this in sign language simultaneously. 80K, I apologize. I talk fast as it is. I get told by judges to slow down all the time. So I'm sorry. And to those who are hearing impaired and watching 80K stream, I am also sorry. Wait, where is that? Hang on. I can find it. Can we do an Inception moment?
Sure.
Let me see. I gotta find this. Ah, there we go. I found it. Here, we'll mute it so it's not too distracting. This is Inception. So, 80K, I've got your chat pulled up so that people will see. But yes, 80K. Oh, look at this. Now I get spinning wheel of death. Of course I do. 80K is signing all of this and our commentary back and forth for the hearing impaired community. And it's a lovely thing that she does. And of course I give her authorization. I know that Ian asked me beforehand if I would give approval for this. And 80K, you don't have to ask me for approval ever again. Ever. You can do this for any stream I do. You can absolutely translate this for the deaf and hearing impaired community. Please.
And likewise.
So
I feel like we've got a little bit of Inception going on here.
It is. It's a bit of a much. It's a bit of much. It's kind of funny. But we'll pull that down because I'm going to get confused because I'm going to get distracted looking at stuff. But it makes me very happy to see that she does that, and it's actually pretty awesome. You're not hanging on anybody's coattails. You are providing a remarkable service.
Absolutely.
And God bless people that do what you do to help make any content accessible to those who could not otherwise hear, see, or observe what's going on. So thank you for that. So want to shout that out. Little Miss Historian, thank you for becoming a member. Much appreciated. Katrina Turner, Christmas decor not before the night of December 15th and down Christmas night for younger siblings' birthdays. That is an intense timeline. That's 10 days to get stuff up and down. That's a lot of work. I don't have that ambition. Patty Hoffman, Potter is innocent, always, forever. K-Rap,
Potter is not, oh my God, Potter is such a mischievous little...
Don't. Yeah. He's not. Don't make me do anything. K-Rap, going to visit my daughter in Orlando over Thanksgiving. I'll be cooking a turkey on Wednesday. Have to work around work schedules from my studio at Animal Kingdom Lodge. We'll be meeting her boyfriend's family. Good luck. And be gentle and nice and fun and enjoy every moment of it. Status update, back to work so Ryan YYC, back to work part-time in the first week of December. Congratulations. Way to go. What an achievement. Wow. A non-mouse. A great kids book, ? Dear as salt. See? You wish you had deer as salt on your last trip that you did not.
I got nothing.
Sharon and Ken Sharp, 2 years. Wow. Thank you for being here 2 years. Much appreciated. Henhouse Bath Company, who celebrated her first year being cancer-free and asked a very important question on Twitter, or X, whatever you want to call it, of whether that celebration should entail wearing a tutu and tiara, and absolutely it should, and hopefully it did. Tiara ordered 1 year cancer-free celebration coming. Tiara is always appropriate for that. Steve A, the 6% aren't trolling, they're lazy. That's the 6% that leave their decorations up all year. Kathy Trout, my vet has an elf on the shelf named after the founding MDs. When I took my fur babies in for shots, I asked if we could be seen by X. The new assistant looked shocked and said he passed away. We didn't get a pic with the elf.
Oh, that's unhappy.
I feel like I missed something.
It looks like the vet passed away.
The vet passed. Oh, no. That's sad. Hopefully the fur babies are okay, and hopefully that fond memories are recalled. Zesalex, I know you guys are covering the Maya trial. It's CRPS Awareness Month. Thought you'd like to know. Thanks for all the great coverage. To all those who have been afflicted, suffering, or are otherwise dealing with CRPS, my hat goes off to you. I could not do what you do, and when the neural synapses are firing and telling you that pain exists that you can't find on your body, I can't comprehend what that pain is like. So those of you who have the mental fortitude to be going through that, my hat is off to you. And for CRPS Awareness Month, please be mindful of that condition that so many people are afflicted with, including Maya Kowalski and various other people. Matt Bond in the chat, who's often here. So if you suffer through it, my hat is off to you. Cheers to you, and keep fighting that good fight. Katrina Turner, it is tight, but I'm 10 years older and Army family. Cheers. Thank you for thank you for the service of your family, or you, whoever did it. Okay, so swoop to the last topic. Double swoop. So we got our first sighting of the new special prosecutor. A special prosecutor is an individual that is appointed who is not yet not originally part of the DA's office or the prosecutor's office, but is separately an independent attorney, often a defense attorney who was previously either a prosecutor or just always a defense attorney. But they are appointed because they're outside counsel. Either there's a conflict of interest or they need someone else to run a prosecution because there's the appearance of a conflict of interest, or they need some specialized type of prosecutor, or they just run out of resources. So that is Mr. Hank Banner. Banner? Please say Banner. Yes.
Banner?
Brennan. Hank Brennan. So Hank Brennan is a practicing defense attorney.
And usually special prosecutors are pulled from the defense attorney pool.
You kind of have to, because the prosecutors are prosecutors. And usually special prosecutors are being designated because they're conflicts.
Yeah. Sometimes they'll pull like a prosecutor out from another jurisdiction or something like that. It happens. But yeah.
Yeah. Good example of another case. Carrie Morrissey was a defense counsel, brought in a special prosecutor. So this is our first shot at looking at Hank Brennan, who is now retrying the case about against Karen Reed. And this trial is about some discovery disputes, some different things that are going on. And again, it's kind of a gleaning of where we expect this trial to go. And we learned some little tidbits here and there that are interesting. Lindsay, not impressed with this guy at all so far. I disagree.
I mean, that's fine.
Remember what I said about lawyers in front of juries versus judges, and we're different people? Sometimes you just want to win your argument. And sometimes in order to win your argument, you make a lot of conciliatory statements that aren't really conciliatory, but are just to win your argument. I didn't hate him. He didn't really win anything. He didn't lose anything. It was just business as usual. But you know what? In this case, business as usual is better than what we've had, because holy shit, yeah.
I mean, Lolly was going to tell us about the snow again.
Yeah, you can see Lolly sitting there in the bottom left-hand corner.
Lolly's sitting there shouting, "Tell them about the snow."
No. Mr. Lolly, you can stay in that seated position, please, if you wouldn't mind. 1.25 speed, here we go.
Documents. Then I'll begin that task, and if there's any concerns, I'll note them. If not, then I would have no concern about releasing them outside of protective order. The juror information stands in a different posture, in my perspective. I think that should remain impounded at this point. There's a pending appeal before the SJC based on the request of the defense. If they are successful, would then reinvigorate the attention on those jurors. I don't see a need for juror information to be unimpounded at this point. All the other information, I don't have the same concern.
Okay. All right. Thank you. All right. The next motion. So defendant's motion for discovery of communications in the possession, custody, and control of the Commonwealth. Who's going to argue that?
I will, Your Honor. I would say at the outset that in speaking with Mr. Brennan, he had expressed a preference to be able to respond potentially in writing. So we were in agreement, subject to the court's approval, if we're going to get another date for the Rule 17 motions, to have this motion heard at that time. But I'm prepared now if the court prefers me to argue.
I'll give you the opportunity. How much time do you need to respond in writing, Mr. Brennan?
You can respond by next week.
Okay.
Really, I'm accommodating the defense. I have a very broad perspective on Rule 14 statements. Our office has made a concerted effort.
Side note, this is also a lot of motions practice where it's backhanded remarks that aren't really like openly hostile, but conciliatory. Like there's a whole lot of Yannetti getting up and saying, well, we'll agree to allow him to file something in writing. He said he wanted to do that, so we're going to go ahead and do that. And then Brennan gets up and says, to be clear, that guy's an asshole. I was going to do it anyways, but let me be clear. I'm doing him a favor. So it's this kind of stuff. I do like it though.
I find this stuff super petty.
It is. It's a little bit petty, but you see it enough, right? It happens all the time. I don't like it.
I mean, in criminal law, it's my experience is like pretty chill where I am. Like the criminal lawyers all kind of get along. And so this kind of petty BS would generally be, viewed as like, why?
Yeah. But do you know how many fucking attorneys I go against that are just petty as shit for no reason whatsoever? There are clients that will come into my office and they will say, I'll have a client come in, potential client, I'll meet with them. I'll say, I'm sorry, I need a deposit of blank. And then there are clients who come in who tell me who the other side is, who the lawyer on the other side is. And I will look at them and I say, well, I will need triple blank. And it is not because the case is more complex. It is because I know how petty the other side is and how much they're going to make my ass show up in court and argue everything.
That's fair.
It is a real thing that happens.
To provide everything that's not only discoverable under the rule, but from my perspective, a broader perspective. I want to make sure I err on the side of caution and they get every statement they're entitled to. So we're in the process of accumulating all potential statements of witnesses which they're entitled to, and I'm going to provide them to them. I've already provided a number of statements that I frankly believe are outside Rule 14 parameters, and I'll continue to do that throughout this case.
Okay.
And so my response in writing really is to accommodate the request and then give an answer and a production of what I have. That's going to take me probably 10 days to put everything together, to adequately review it, and then to provide a package to the defense. And so I think that if I have 10 days, I might be able to accommodate the request without any need for litigation. If they decide to pursue further effort, then I can respond.
Okay. All right. So why don't we give you...
I kind of like them so
give you
far.
Until the 27th, just after, or just before the Thanksgiving break?
Appreciate that. Thank you.
Okay. All right. Does that work for you, Ms. Giannetti?
Certainly does.
I like that they're actually
Right.
acting like adults.
So let's talk about the Commonwealth's notice of scheduling, reassembly and testing of the defendant's Lexus telematics system.
May I?
Ooh, this
Yes.
is interesting.
I like the fact that he gets his ass up. Like, there's no lollygag. That was unintentional in that moment. I was intentionally going to use it later, but it came out here. The judge's like, let's talk about this motion. And he's like, I will fire out of my seat.
Lexus telematics system.
May I?
Yes.
As a matter of background, as I think the court is likely aware, the Commonwealth tested information on data chips that were found in different modules that were inside the defendant's Lexus. Inevitably, at trial, the court is likely aware that there's information taken from one of the systems that was provided, and it should.
Side note, he asked for permission from the judge. He said, Judge, would you like me to address you from the podium? And the judge says, where you are is fine. That is routinely. We do that all the time. Judge, you want me to remain seated? You want me to stand? What do you want me to do? And most times judges will be like, counsel, you can remain seated, because they don't want to see you get up and down. It's business as usual.
Yeah, or just,
key cycles.
you'll sometimes hear judges just say whatever's comfortable.
Yeah. I'm comfortable standing. I like getting up. I feel like I have to move up. I have to stand up. That's how I deliver my arguments. So
I did watch one judge who was unfamiliar with the jurisdiction rip into a lawyer and said, counsel, when you address me, you will be standing. And the lawyer backed his wheelchair up a bit so that the judge could properly see it. And,
oh my God.
Yeah, it was a moment.
I have 1 a.m. brain, which means that I should have seen that coming. But when you said, counsel, when you addressed me, I expect you to be standing, my head was like, well, yeah, I've had judges tell me that before. My brain was not to the point where I could have. I'm usually able to get there before you do. Or see
yeah,
where
that
you're
one
going.
was just a very, very spectacularly unfortunate moment for that for the judge.
Yeah. Well, you know, judicial temperament is sometimes taught the hard way.
I did watch another judge ask a lawyer, counsel, are you disabled? And when the lawyer was like, no, he's like, then get up. Yeah.
The wheelchair. Did the judge backtrack?
The judge was just like, we're just gonna move on.
We're gonna move on.
At different speeds, and I understand that was a exhibit at trial. There were two different search warrants by the government. One search warrant was for the car that included both a telestream and a telematics module, which is like a lunchbox with computer panels in them. And then in 2023, there was a second search warrant for the infotainment.
It's like a lunchbox with computer panels in it?
Kind of.
I hired an independent expert, and in the independent
I assume it
expert
also does
of
not
information,
contain
what
lunch.
he realized is that the information taken from the Infomatics manual and the information taken from the telestream manual had some irregularities. What he realized is that all of that data was unreadable. And so initially he thought that the data was not fully downloaded or compiled. He checked and he believed that gigabits were gigabytes and that there was a discrepancy. And the reason he thought this is because there was very obvious information missing from that procedure. There was information including navigation information, information regarding the phones that were plugged into the radio, travel logs, things that are particularly relevant for material in this case, information that is going to be extraordinarily inculpatory or exculpatory in this case. And so after he realized his oversight on the gigabit, he filed a supplemental report. And what we learned is not only was the chips that were taken from the telematics and infotainment systems and downloaded were read with the wrong reader. So that way the information was not available.
Oh, geez.
Side note, I love that the chat is dunking on this guy. Now I get he's an expert. The gigabit versus gigabyte. I had to look this shit up. Gigabit is a unit, digital measurement equal to 1 billion bits. Now that part I understood. Billion, giga, got it. While a gigabyte is equal to 1 billion bytes, but a byte is instead, a byte is what, 8 bits?
8 bits.
I didn't know that. Now, I would imagine experts should know that. I'm not going to fault the guy. I don't know.
I'm going to fault the guy.
All I know is we're not getting Trooper Paul. Yay! Hang on. We'll get there in a minute.
Also, in the the infotainment system, there were actually 3 boards, not 1. Only 1 was taken out. So there is a plethora of information on these chips that has not been downloaded that's relevant to this case. And so we provided...
I got pissed off at the plethora.
I don't mind the plethora. What I mind is what... like...
No, you're not going to fast track past the plethora part.
Yeah, I kind of will, because what in the 3-ring circus is this?
Why? No. The man just said plethora.
Yeah, it's a perfectly cromulent word.
Plethora?
Yeah.
Plethora. My God.
Sure.
Plethora.
Plethora? Oh, you're complaining about the pronunciation. Gotcha.
Yes, of course I am, because that was ridiculous.
Yeah, I'm not going to worry that much about it.
Plethora. Plethora. How do you get there? Plethora. And he says it so casually. It's like he's been saying it that way forever. Plethora. We're not going to talk about the plethora of information. No.
I mean, I wish this was the worst thing.
Plethora of information or plethora of stuff. Plethora.
I wish this was the worst thing that was happening in Canton, though.
No, I understand that. There's terrible things happening, but I want to highlight something that frustrated the hell out of me that's like oddly somewhat humorous. Plethora.
That's fair. That's fair. I wasn't really worried about his pronunciation so much as just all the other fuckery that happens in this town.
Niklas. Your Honor, my predecessor was a moron. We need to redo everything. We get there, Niklas.
I mean,
you saw it as well.
I also liked how he said this could be incredibly inculpatory or exculpatory. I'm like, oh, you're paying attention to that.
Yeah, bro, you run the dice. But we'll get there.
I did notice to the defense that our intention is that we are going to test this information that we have in our control and that we have a search warrant for. And my effort was to give them notice so they could have an available expert. So my purpose really was not to ask for the defense's permission. Rather, it was to notice them this is what we were going to
do. Whoa. Apparently, Rob has just died. And I assume not really, but yeah. Welcome back, Rob.
There's a back button on my mouse that I just hit on accident. I didn't realize it was there.
I'm like,
and when,
okay.
There's a back button on the thumb of my mouse. It's a new mouse, and I hit the back button, and hitting that when I'm in the studio sends me out of the studio.
That is not a good button.
No, it's not. It's a terrible button. It's awful.
You should maybe leave that button alone.
I should. I got too mad at the plethora. There was a plethora of problems.
Rob has rage quit over plethora.
Plethora. No, we're not doing this. I hit back. Nope. We were okay. We were fine.
You can see from my
You
motion,
ruined
I
it,
asked
Rob.
to do it within 14 days. Having recently arrived at the case, it was important for me to prioritize Rule 17 motions and new experts so that they could have adequate notice. The defense asked for today's date and wanted more time, and when I considered it, I thought that was reasonable. I think they were entitled to have an expert and consider what we are doing, even though I don't believe they have standing to prevent it. And so that's why I agreed to this date. Inevitably, we know that this information will be on these chips. And so we know there are 2 boards on the system that weren't tested, and then the other chips that were tested that came back with unreadable information with the proper computer programs, they call them programmers, we will get viable information from both of them.
Sorry. With the proper computer programs, they call them programmers. If it brings us someone that's not Trooper Paul, I'm here for it.
Oh, 100%.
And so I spoke with the defense. I know they've hired an expert. I have no.
Go.
That said, I will miss Trooper Paul because he did make me laugh.
He was good content.
Oh, he was freaking hilarious. I just wish like all of my cases involved an officer like Trooper Paul. But that's because I'm a criminal defense lawyer. Like, if the criminal defense lawyer is smiling, then the prosecution maybe shouldn't be. So, yeah.
Teddy Bear, this is why a lot of, this is what distinguishes really, really, really good lawyers from not really good lawyers. Like, a good lawyer is supposed to be able to digest and learn a subject matter really quickly and understand enough to talk about it competently.
Or at least
some of them don't pick it up that well.
Well, not just talk about it competently, but sometimes cross-examine an expert and get them to say things the expert doesn't want to say because you have successfully, essentially forced it out of them.
Yeah.
Yeah.
They filed a motion contesting our position. I'm not going to speak for them, but their position is today.
I like this guy better when he's not spinning wheeling.
I know. We were fine until we weren't. People that are saying this guy's not talking about smart today, I'm going to put about $20. I'll put $20 on it. When he's in front of the jury, you're going to hear a very different version. I guarantee it. Right now, he doesn't need a lot of the fancy. He's got a judge that's going to side with him. I bet it changes.
The motion asks to have their expert be able to intervene. We're not agreeable to that. They can watch and comment and criticize as much as they'd want, but we're entitled to the download. Notably, when the first download was done,
I also think this guy's way better than
the
Laffitte.
defense expert to do the
Oh,
download.
hell yeah.
That is not my position. I don't defer that responsibility. But it was the defense expert that overlooked the proper reader that was needed for the chips that were tested, and it was the expert that overlooked the fact that there was 3 panels in the system, not 2. And our expert was astute enough to find those oversights, and that's why we now...
Hold the fuck up. Wait, we're not going to let you blow by that, Mr. Brennan. You mean that you're the prosecutor. You have to develop the case and prove that case beyond a reasonable doubt, which means you have to actually take apart the system and prove via the system that the vehicle did the thing that you said the vehicle was going to do.
Mm-hmm.
You can't really say, but the defense expert didn't know enough about the vehicle to do the thing that we should have done in the first place. So, Ian, are we in agreement on this point?
A little bit.
Yes.
I mean, I would have done it if I was him too.
What, throw the shade?
Yeah.
Yeah, I know. But
I mean, you're absolutely there to throw the other side under the bus as much as you can. So
have an independent expert.
Wait, hang on. I'm not gonna. I will not take this. Where is this? Where is this? Someone said, "Where's the comment?"
He's not gonna take it.
No, I'm not. Jolly Rogers, this nasally voice, we will listen to this voice all fucking day. I will
just so long as he doesn't talk about the snow
or what if any. I will listen to this voice serenade me songs to sleep if it does not say the words "what if any" 9 million fucking times.
But it's a magic cure-all.
Who, if anyone, was driving the ambulance? That one. Just
it's
that
a self-driving ambulance.
Expert that is going to do this. I know experts differ. They're not frick-a-frack. They all have different opinions. But we've attached all of the protocols.
Bro, car talk.
They're not.
He said frick or frack.
What?
Frick or frack. Car talk. Did you ever hear car talk?
No.
No, I know a cultural reference that Ian doesn't.
I mean,
car talk.
This isn't super surprising.
This makes me happy. Okay, car talk was literally like late night talk show. It was awesome. It was phenomenal. Like it was car talk. They literally listened to people call in like, my car does this, and they would diagnose it on the air. It was the fucking best thing in the world.
Chat, please tell me I'm not the only person who thinks Rob is mildly crazy right now.
I am mildly crazy. It's 1 a.m.
Well, what we intend.
I mean, we all are.
I brought it before the court because I wanted to expedite this matter. It's important, and it.
I thought we were going to have that hearing within 14 days when we first got the motion, and then Mr. McDermott told me that the defense was looking for more time, so we gave this. But we're far into the case is scheduled currently for January 27th. Sounds like you have a lot to do before then, but as of right now, it's still January 27th. So all of these things, the Rule 17 motions, all of these things need to be done as soon as possible. So
I understand. And if I can just add, it might help in your consideration of a later motion. The reason why this is urgent to me to have this as soon as possible is because I also have noticed and hired an accident reconstruction expert. And that accident reconstruction expert will necessarily rely upon the information that is gleaned from this testing.
how long is this testing going to take?
It's a 3-day testing. It'll take within a week to read it. And the sooner we have it, the sooner we can have our reconstruction expert engage in any type of task that we want them to, but they necessarily.
Here is me making a very subtle request / begging Judge Bev Canone. Please don't fuck this up. Please give them the continuance. Holy shit, please give them the continuance. Let them begin this trial in April, because the last time when you did not grant the continuance, we had discovery being exchanged in the middle of trial. We had images being played for the jury that were actually the mirror image of what was actually supposed to be played. We had a fucked up trial beyond all fucked upness, Judge Canone, including you blaming counsel every single time when documents were being introduced that were not properly indexed. So please grant the fucking continuance. Otherwise,
or the regular continuance.
I'm doing the logical because I know there's a lot of ladies in the chat. Ladies in chat will generally say, please grant the fucking continuance. That's a joke on men, just in general. Anyways, please grant the continuance.
Yeah.
Because she's not going to do it, is she? No. No. I already know it. It's going to be a fucking botched trial again. It's a fucking clusterfuck. It has been a clusterfuck. It's going to be a clusterfuck. It's never going to be clean. It doesn't have to be this hard.
And that is my sense of urgency for this to be developed and done.
Who's arguing this for the defense? Okay, okay, Mr. Jackson.
Thank you, Your Honor. I'll start by saying, in principle, we don't have an objection to the retesting of the telematics or the infotainment center, our system data. The problem that we have, our issue sort of dovetails into what Mr. Brennan was suggesting about what was done the first time. He just suggested that his new expert, Mr. Shannon Burgess, was astute enough to find something that Maggie Gaffney didn't find. Well, to bring the court completely up to speed, when the initial testing was done, the Commonwealth's expert did not know how to do a chip-off, physically did not know how to do it, Joe Paul. He turned to Maggie Gaffney.
Oh, wait, I am now learning that someone in the chat does not know what FUBAR means. FUBAR is fucked up beyond all reason or rationale. Fucked up beyond all reason.
Beyond all recognition, usually.
Or recognition, just something. Fucked up beyond all recognition, all reason, all anything. Same with, there's also snafu. Situation normal, all fucked up. Which most people say this snafu. Don't realize that that's what they're actually saying. Situation normal, all fucked up. So people say repair, recovery, recognition. Yeah, FUBAR, it's military slang.
Our expert, who did know how to do it. She's a former MSD officer and extremely facile in this world. Of
And you have a different expert now. You're not using her now?
Wait, did Mr. Jackson grow a beard? I don't hate the move.
Well, we may use her, but we have an additional expert who specifically works, Mr. DeSorga, specifically works in chip-offs and chip-ons. That physical procedure of moving chips on and off of boards. It's a very technical procedure. It's a very skilled procedure. He knows how to do it. He's got an extremely long resume, having done this kind of work.
I read it.
We're bringing him up to speed in order to sort of engage in some oversight and some observation. I don't have a principled objection to doing the retesting. What I have a problem with is that their new expert, Mr. Burgess, right at the beginning, fundamentally misunderstood the data set on the 3 chips, the 2 micron chips and the expansion chip that he looked at, didn't understand the difference between megabytes and megabits, gigabytes and gigabits, and that gave us pause. If he didn't understand that, which is at the foundation of reading the data, we're concerned that some of the data could be destroyed in whatever process he engages in. Like I said, we don't have a principled objection.
We don't have any issue. It's just
we simply want to make sure that nothing is destroyed in doing that work. It's not, and I would take a...
Would be a great time to remind the judge, do I need to remind you that, blood evidence was conducted in solo cups, or that we thought that a leaf blower was the proper implement to search an area for, pieces of glass?
I love the leaf blower.
I don't. I hate the leaf blower. I mean, I like it for its comedy.
I mean, what other purpose do we need?
I feel like you could basically say, Judge, we have blood in solo cups in a shop and stop bag. So,
I mean, how else are you going to drink the blood?
That was good. That was a good one.
A little issue with something Mr. Brennan said. It's not that the data set is missing information. We don't know that it's missing information. Burla has now updated software that we believe, I think both sides believe, could be beneficial in culling or teasing out that data set from those chips. That didn't exist when Ms. Gaffney did her work previously. She put it on the reader, it was unreadable. It doesn't mean that the data is missing. It means that it's unreadable. As a matter of fact, one of the things that our expert would do and would suggest is that a process called a checksum be done. I'm going to use some made-up numbers, but let's say there's 5,123 bits or bytes on a particular chip. You can do a checksum and determine that there's 5,123 bits and bytes read now. That means down to the bit or the byte, nothing has been altered, nothing's been changed, and we know that we're dealing with the exact same data set. That checksum would be the first process in doing the additional reading. Then they can go back and use the additional Burla software to see if the data set could be read. After that's done, then my understanding is there would need to be a chip on. They'd need to resolder those specific chips, the 2 micron chips and the expansion chip, back onto the motherboard, install the motherboard back into the truck, and then turn the truck on. That's the process that I understand. My only request is that our expert, obviously, given his expertise and his knowledge of this information, he should be there to observe. And the only caveat to that is if he makes a determination, working with Mr. Burgess or observing Mr. Burgess's work, that what's about to happen is destructive to the data on the chips, we would ask gently, and I don't think this is much of an ask, that he be allowed to interpose his objection to moving forward, contact both counsel, both parties, and if need be, present his objections either to us to resolve it or to the court for intervention. That's all.
I'm going to say no. I'm going to say no, hard no, not going to happen.
Why?
One, yes, you have a point to make a motion. Destructive testing also occurs. But also, if testing is undergone, right, and if you've made, now Jackson's making his objection, he's kind of laying the foundation for what I think Canoni's going to allow the observation, but not allow the expert to cut him off and say, I object. This needs to be resolved by this way, because that's going to make for, I mean, just play this out in your head, Ian. You have an expert that's there who's questioning everything and says, well, you're soldering this the wrong way. I'm objecting. I'm going to stop this. I'm going to do this.
Mm-hmm.
You're going to continue this to October of 2026?
I mean, they should just not do it the wrong way.
They should. They shouldn't. But when they do it the wrong way, what's the remedy the defense has?
I mean,
Strike
you'd
the
ask.
evidence.
What?
I know. Bev's not going to do it.
Oh, I know Bev's not going to do it, but that's because it's Bev. It's not because it's not a good idea.
I know. My thing is, if I'm Jackson, and I get why Jackson's doing this. Jackson is doing this right now, not because Jackson thinks he's going to win. He's doing this to the extent that there's anything that happens during this testing. He is now going to be able to go back to the judge and say, Judge, I asked you to let my expert cut them off. You said no. You deprived me of my remedy back then. I want my remedy now, which is throw that shit out. That's what I think he's doing.
Probably.
Oh, did she rule already? Well,
I want the work done, but I want to make sure that the data set that is on those 3 chips or additional chips that are read is never destroyed or in peril of being destroyed. That's all.
All right. Any response, Mr. Brennan?
The defense expert will not be working with Mr. Burgess.
I love this. Julia, I love the aspirational. Really, because it sounds reasonable. Like they're both experts. It should be simple. Never. No. Experts that are hired by either side will disagree with other experts about everything. They will agree to one thing, and it's the other side is an idiot. I made Ian smile. That, yes, yes.
I mean, it's true. Now, to be fair, the other side includes, like, you know,
yeah,
like, yeah, Trooper Paul, etc.
Now, no, we haven't gotten bashing Trooper Paul yet. I will get there in a second because.
Oh, I'm just always there. That's where I live.
I remember that night still very much because that testimony scarred me forever.
The defense expert has no active role in this testing. There is no inherent risk that Mr. Burgess is going to destroy something unnecessarily. This is potentially destructive testing, just as it was the first time. Fortunately, the information was not destroyed the first time, so we can access it again, but it's potentially destructive testing. The defense is not entitled to veto power during the process. That will delay things. It has no role and no purpose in it. And so, inevitably, Mr. Burgess is well qualified. Mr. Burgess is competent, and he is going to test these chips and provide the information to the defense. They'll get an exact copy. The idea of checksum, there's no mystery to these words. There's a protocol that's followed where they use the old software that was ineffective, and they test to make sure it's the same amount of data that's unreadable. And after they confirm that nothing has been moved or destroyed or tampered with, then they bring in the right programs, the right software, and they'll retest it properly. They'll provide the information that will be available to both us and the defense.
All right, so if I act on this motion quickly, because there isn't a basic objection to it being retested, when can they begin, Mr. Brennan?
Can I also complain about the checksum shit?
Yeah.
So they keep saying checksum, and it's also really clear that they don't have a single fucking clue what a checksum is. because they say checksum, but what they actually mean is like they don't know what they keep saying, like, oh, the checksum tells us that there's the same amount of data there.
Yeah.
And that's not what a checksum is. A checksum is mathematically derived to be unique, or at least have very few collision possibilities, such that the checksum. Because the problem that you have is let's say your bank account has.
Doesn't it pick miscellaneous points of the data set and combine them to yield a singular result? And you combine it across multiple data sets.
It depends on which style of checksum, but it's usually just something that is algorithmically generated from the data, like as a
itself.
Yeah, and the thing is it's like, you know, let's say you've got a bank account and there is 20 digits in your bank, like for the amount in your bank account, because you are super wealthy, except that like the first 19 are 0. So you are not super wealthy. You have no money. But the thing is that data entry is exactly the same. Like,
make it here.
It uses the same amount of data as if those were all 9s.
Let me try this way.
So
let's say you have a bank
it's
account,
not
right? But
counting the bits.
Let me say you have a bank account. Let's say you have a bank account and you have pulled the data of all transactions in that bank account from January 1st, 2020 until now, right? And you know that when you did that data pull, there were 732,000 identifiers that were 0.03 within the data set, right? 0.03 appears within the data set 782,000 times. And it's a randomized thing, right? So the checksum is doing an aggregation, or it's doing, like what Ian said, an algorithm. It's picking some number, something that will aggregate a certain way, only if the exact data set is put in there.
Like, let's say our original data set is ABCD, right? They keep saying it's checking the length, and ABCD is the same length as QQQQ. But they're like, obviously, if your ABCD gets swapped in for QQQQ, that's a different data set. The checksum, however, will give you different results for those two different things. So, yeah.
Clitson's Vixen says, I think I'll go back and watch Rob and Ian on that review of Cross. I was very angry.
I'm still very angry.
I was
at Trooper Paul.
And actually, what Hank Brennan does here about how that data set was used is in large part, I think, he is recognizing why I was angry, because some of the shit that came out of his mouth didn't make mathematical fucking sense. So yes, it would make sense that the data was not pulled right because the extrapolation of the data didn't make mathematical fucking sense. Like all of a sudden the vehicle being 25 miles an hour in reverse. Fuck. So we're on the same page.
This morning. Yep. And I asked him for a schedule when he could test. I told him I'd like it as soon as possible. We didn't finish the conversation. What he told me is December 2nd or 3rd. I told him that would be inadequate. That's too far out. I want it done before Thanksgiving because time is of the essence. And I think it really develops everything else that will happen in this case as far as other experts. So I need to resume my conversation with my expert, encourage him, and insist that we make some changes in schedule.
Expert's not available in time. Lady Fang, this is awesome to hear. Actually, for the chat, I actually am very curious. In the comment section of this video, would you mind dropping a comment
so I can't give an exact date because that conversation.
What stream, whether it was mine, Ian's, Emily's, Rick's, Alita's, any of my friends, what stream that you were watching that kind of made you interested in this type of content? Just,
I think there's going to be a lot of depth.
It might be, but there's probably a particular stream. And if you have to refer to it as like something where something was said, I'm actually very curious about this because I know that people have been following for a long time. Some people for less than others. Some people joined because of Maya. Some people joined because of Karen Reed. Some people joined because of Depp, Murdaugh. We've covered enough trials. But there had to have been like one stream where you watched and you were like, huh, I could watch another one of these. I'm very curious. And if you're watching this on replay, do it in the chat because I actually want to go back and read these. I'm very curious about that. I want to go back and reread them.
Conversation wasn't what I was expecting, but I don't think we can tolerate waiting that long.
Okay. All right, this one I will act on very quickly. All right, so I think that just leaves us with motion to continue. I know it's a joint motion, but I need to hear from both sides as to why I should do that. Mr. Brennan?
Can I begin?
Yes. And the request is for an April 1st date. You're not looking to go any further than that, correct?
We are not. We are not. Your Honor, the Commonwealth has been on this case for some time, and I am newer to the case. I'm not looking for a personal accommodation, but I think the idea of a motion to continue in our joint request is in the interest not only of justice, but I think inevitably, I truly believe it's going to have a more efficient and effective trial. Part of my perspective is to move as quickly as I can, and that's why I started with the Rule 17 motions. I've also tried to retain as many experts as quickly as possible. The experts will need to do whatever testing they're going to have and conduct, and then I need to provide the reports to the defense. The defense then may have counter-experts in reciprocal discovery that I want well in advance of trial. When I first entered the case, I was committed to January 27th, and I still am. If the court decides that's more appropriate, I will be ready on January 27th. However, I realized when I was trying to move and facilitate the testing of these ships in 2 weeks, and the government, the defense wanted more time, and I appreciated that their request was reasonable and began to understand that it is going to take a little bit more time than I wanted to have the experts notice, the reports done, and then the defense have time to manage whatever the information is. I do not want to get into a position where we're turning over expert testimony, they're retaining experts to counter that testimony, and then to reciprocate in discovery where days, weeks, or in the midst of trial. I want to avoid unfairness to the defense at all costs, but I also want to avoid any unfairness for the prosecution, and that includes reciprocal discovery. And certainly, the reciprocal discovery cannot happen until I've provided everything that I intend on using. I have tried to exercise extraordinary diligence in this case. In addition to Rule 17s, and in addition to retaining experts, we have brought on my full-time paralegal, and we are going through the entire discovery. And I know it's already been provided, but...
And I know there's comments about this, the full-time, so he is in private practice still. He still has a full private book of clients. This is a separate client of his. So he has this on the books as a client of his. And he has a paralegal he employs in his practice of law. And when he says he brought on his full-time paralegal, I have learned since that he brought on, like, his full-time paralegal is still being paid by him separately, not out of state funds, not state paying it. He's paying her. Or him.
Oh, interesting.
And they are now on this case, helping him digest the information. That was interesting to me. And I imagine that's one of those things where, look, my paralegal, whom I love and will never leave, like ever. If you are watching and you decide that no, we've had this discussion, you are not leaving. Paralegals become the outward extension of a lawyer. Like they understand how that lawyer's brain works, and they organize and consolidate information, because we deal with a ton of information that comes in, massive amounts of information, whether it's phone calls, emails, communications, volumes of documents, financials, correspondence, everything. The paralegal that's your gatekeeper. That's your filter. That's the person who takes that information and has the first shot at it, who digests it and gives it to you in a fashion that you can handle. And then when you're sitting there going, I need that thing, and you're saying that thing, the paralegal is the one who kind of somehow understands what the hell you're talking about. Like they somehow get it. What?
Maybe.
What? They might. The good ones, the ones that, this is why I'm talking about Brennan here. When you made the comment about like the paralegal, paralegals pick up on your tone where you're like, I can't remember they're like, you have an appointment at 3:00. You're like, thank you. Or the paralegal that comes in and says, Rob, you were supposed to be out of here 15 minutes ago, and I'm telling you to turn your computer off. And I will go and turn that computer off if you don't get your ass out of this office. Those people. So paralegals are your trusted person in your employment. They help get you from point A to point B, and they cannot be they are the most important asset to any lawyer, period.
Yeah. And any lawyer who treats their paralegal badly is really dumb. And also, I would tell clients, because sometimes you get a client who's really pissed off. And in criminal law, you get clients who are really pissed off and also have anger issues. Mm-hmm. And so they do something like, like they would yell at my paralegal, my assistant. And I'd tell, it's like, listen, you get one of those mistakes, but you, this cannot be a thing. If you do this again, I will fire you. You will not be my client if you're going to treat my assistant, my paralegal like that. If you want to yell at anybody, you yell at me, not them. Full stop.
Yeah. If a client calls and yells at my paralegal, that client gets one phone conversation with me, and it is not a friendly conversation.
Yeah.
And it is one where the client says, but I'm paying, and I say, you shut. I use words I will not use on this live stream. And it's very, no, you don't cross my paralegal. No.
Yeah.
You want your case to be facilitated properly? That is the asset that you go through. And my clients are very well trained. And I don't mean that negatively. My clients are very well trained. I involve my paralegal very early on. And I try to develop a relationship between my clients and the paralegal where it is a team approach. We are all doing something. We are all aiming at a goal. So and I don't understand how attorneys abuse their paralegals. I really will not. That paralegal controls every aspect of your success or failure.
And the thing is, if a paralegal, every once in a while, a paralegal goes bad on a lawyer and actively goes out to screw them.
Oh, you're fucked.
And the damage a paralegal can do is insane. I had a paralegal who wasn't actively trying to screw me, but she was bad at her job. And so she messed up my calendar, something fierce. And the amount of work that took and the amount of apologies to judges that took to clear up was a lot. And I mean, you never want to be in a position where you're telling a judge, hey, sorry, I missed this court date because my assistant's, was. So, yep, you absolutely, yeah. A good paralegal is, there's just no way to function without one. And, lawyers who treat them badly deserve what they get.
Yeah. Sam's Galaxy, then they should get weeded out. And if their paralegals are looking for work and they live in the Northern Virginia area, give us a call. We'll hire. We will hire.
Assuming you're good.
I mean, I'll poach. There was a young associate. There was a side moment for a moment. There was a young associate that I worked against, or I had a case against, and Virginia's bar numbers are progressive, right? So they go just up.
Yeah.
So this associate, their bar number was a lot higher than mine. And I looked at his picture on the website of the opposing firm. All lawyers do this, by the way. And because I'd never seen the name, and I was like, oh, he's a baby lawyer. And for a split second, I made the mistake of kind of discounting this baby lawyer. Because, I've gone against baby lawyers before, and they're baby lawyers. And I don't mean that disparagingly. What I mean is that every lawyer that just passes the bar, there's a very big difference between what they teach you in law school and what you actually do in court.
Yeah, that is fair.
So it's a motion, and we're in front of a judge, and the lawyer talks to me beforehand, and I was like, we're fine. We'll just argue it. It's no problem. So I'm going to argue why it can't be heard today. The judge says you have a max of 30 minutes to argue your motion, right? But there's a practice where you say, Judge, I want 2 minutes as to why this can't be heard today. Like you're telling the judge, I can't hear this in 30 minutes. So I want 2 minutes to explain to you why it can't be heard in 30.
Yeah.
This baby lawyer's there, and I get up and I tell the lawyer ahead of time. I said, I'm going to ask it not be heard today. It's like, okay. And he's very quiet. And I'm concerned because he's not doing the things that baby lawyers do, which is usually the little panic, the talking, the filling the space with noise and words. And
or getting angry.
I was there. I was back there. And the judge announces the case, and I say, Judge, 2 minutes as to why it shouldn't be heard today. And he stands up very calmly and says, that's fine, Your Honor. And I was like, oh, shit. Like just in that moment, just like, oh, shit. I calculated wrong. And I get up, and this kid, and I say kid because, he's probably 25, 26, 27. Younger. Gets up and makes a very cogent, logical, calm, not erratic, no exasperated breath, nothing indicating any concern, argument. And I'm just going, holy shit. Wow. Okay. And I get up and make the argument, and the judge goes, I think I can hear it today. I was like, fuck, I just lost. We're hearing this today. I thought I was going to get kicked. And this kid comes out and swinging. It's like, Judge, I'm going to step in the hall and have a conversation with opposing counsel. You do that, Mr. Morton. So what do? The smart thing. I realized that had this case gone to 30 minutes and I didn't get the full day, I was going to lose it. So I went in the hallway and negotiated a deal. It was the right call. But it's a very valuable lesson about this young lawyer. And said lawyer, I'm not actively trying to poach him from this firm.
But you're not inactively trying?
I am passively. Litigation is a very interesting.
So there's like a lot of lunch invitations going on.
Well, it's just making it known that there's an opportunity outside of where they are. Because litigation is a funny thing. There are people, it's like it's a talent. And there are people that are naturally predisposed to it, who develop the confidence, the ability to communicate in that fashion, the tone, all of the above, the mask, so to say. And there are those who have to learn how to do it very slowly. So some will just have the tone, demeanor, confidence built in, and the intelligence to back it up. And there are some who have the intelligence and they just have to build the confidence slowly and slowly and slowly. The challenge is that confidence can take 5 years, 10 years, 15 years. You don't know if it'll overcome. I'm poaching. I'm totally poaching this kid. I'm going to find this. I'm going to poach him. I'm poaching him. It's the fucking tone. It was the tone. Oh, fucking killed me. The second he gets up and says it, I was like, shit, I miscalculated.
Rob's
So
got a
mad at
mild lawyer
myself.
crush here.
No, I'm mad at myself. I'm mad at myself because you walk in and you promise yourself you're never going to be overly confident. You're always going to do, you're never going to walk into a case too confident and think you're going to run over somebody. But every now and then you have a case where you feel like the facts are right, the judge is right. Sure, you don't have to be as cautious as you otherwise would be. And it was that one walking into the ring, stepping into the ring, and seeing that first jab come a little bit quicker than you thought it would. And you're going, oh shit. All right, we actually have to fight. And it was honestly kind of cool. I felt pretty happy about it because it also showed me that the bar is producing these attorneys that are really good.
That's fair.
Yeah, I'll take that. I absolutely did. I was smart enough to recalibrate. That's the problem that most lawyers don't make. Most lawyers will make is they will not recalibrate. They will walk in there and still think I can still beat this person, and they will not have recalibrated their expectations based on what they just saw.
It wasn't Bates' number, which I'm accustomed to, and we are re-indexing all the discovery and re-providing it, even though I expect most or all of it has been provided. And I'm doing that out of an abundance of caution so I can be confident that the defense has every document I have. That will resolve or prevent any delays at trial of inadvertent late disclosure or any concern or confusion about documents that have been provided. I also, with the office, have diligently moved to obtain all Rule 14 statements so that we can get the information to the defense as soon as possible. I've employed a practice when I'm retaining experts. I don't wait until we've done testing or reports. I immediately give the CVs to the defense so they can get started on investigating and looking into the experts. So nothing is held back when I receive it. If I receive any information that is discoverable or frankly not discoverable, I provide it to them. You can see in my discovery notices when I get emails from strangers with theories that I don't even agree to, that I don't know, I don't evaluate it, I give it to the defense. And so we're doing all of this to try to be as efficient as possible to avoid delays at the time of trial. And it will allow me, when I evaluate this case, which I'm still in the process of doing, of reducing the witness list substantially. And so although it does delay the case, if you allow this motion, I think it will make for a shorter, more effective, efficient trial, and I think it will be, importantly, more fair to the parties involved. And that's why I asked you to consider that continuance.
You know what? I'm kind of digging this lawyer.
I don't hate him. He's effective. And I'll tell you why I think half of what he spewed was bullshit. Half of what he just said was bullshit.
I mean, that's low by lawyer standards.
I know. It's not terrible. The statement of I give them everything right away, immediately, blah, blah, blah. That is his recognition that the prior trial was a fucking clusterfuck.
Mm-hmm.
That is him like telling the judge, I am not going to let this be the last trial. And it might be real. It might not be real. I doubt it's actually 100% real, but it's what the judge wants to hear.
I see somebody noting that he sounds like a dweeb. Sure. I have seen some terrifyingly effective dweeb ass lawyers.
Yeah.
And I mean, I say this as a guy who is fairly nerdy. Hopefully nobody will take offense to me calling myself fairly nerdy. But I have seen some lawyers who really, really like that just make me look like super super what do you call it? with it kind of thing. And yeah.
I don't have to hear what, if anything, every 2 fucking seconds. I'm happy with it. The arguments they're logical, they're cogent, they make sense. They're not circular. He makes the point and he gets out. He doesn't make the point forever. He makes the point, he stops, he lets the judge rule, and he moves on.
Yep. I mean, I don't
with that.
I don't hate him at all.
I could find like Christmas lights ish. I talk about Bruno, so that's what we got right now.
Do not expect that we come before you and ask another continuance. If something cannot get.
No. It waited all night. We were fine. We did so well.
All right. Who's going to argue this for the defendant?
I will, Your Honor. I'm not going to belabor the point. I mean, not surprisingly, in a joint motion, I agree with the argument made by Mr. Brennan. You've heard that there will be new Commonwealth experts. There are no reports yet. There have been no disclosures. No forensic testing has yet taken place. And the time frame, according to the motion, is somewhat unclear at this point. Clearly, once testing is complete, disclosures are made, we would have the right.
Here's the other part of this. This is why let me tell you why Yannetti is joining this motion. Yannetti is joining this motion because he got hit and Jackson got hit in the last trial for a violation of reciprocal discovery obligations. So in Massachusetts, they have a discovery obligation. When discovery is provided to them, they have to provide the Commonwealth with reciprocal discovery within a certain period of time. If you're in the middle of trial, it's very hard to do that. And they had an adverse ruling go against them on more than one occasion where the judge found discovery violations on their part for responding to discovery that was given to them in the middle of trial, not in a timely fashion. So Yannetti is like, I don't want to do this. Give me the ability to argue these things in a reasonable fashion.
You should not trust me in any code base, but I can just barely navigate some JavaScript. The thing is that sometimes you have to learn stuff in order to, cross-examine. And so it annoys me when I see people getting it wrong on that stuff. And I'm just like, no. So
a few more minutes.
To consult with our experts and potentially employ additional experts depending on what the testing.
Have you been working on that?
I love how Bev jumps down. This pisses me off. Cannoni jumps down his throat, but doesn't cut off the other side. It drives me fucking nuts.
In anticipation.
We have.
Okay.
Yes.
It really drives me crazy. I don't think we get anything else out of this. There's the red eye.
That discovery is not complete well in advance of trial so that we can assimilate and incorporate that discovery into what would now be a retrial. And our position is, Your Honor, there's simply not enough time between now and January 27th to get all of that done and properly prepare for trial. And I would just close by saying
he's
that
right.
Both sides and the court have an interest in having this matter proceed to trial expeditiously. But in our view, and I would expect in the court's view, the most important consideration here is Ms. Reed's right to a fair trial. And in light of what's outstanding and what needs to be done, we believe she would not be able to receive a fair trial at the end of January. We're essentially asking for a 2-month delay, which I believe is reasonable in light of what we've already discussed. We do not anticipate any further continuance requests, just like Mr. Brennan said. So we'd ask the court to allow this motion.
All right. What do you anticipate we need to do for in-court hearings? You mentioned in your motion, in the joint motion, a Daubert hearing. How many dates are we talking about? We already need a new date now for Rule 14, for the Rule 17 motions that we have. So we need to start moving forward with all of this. Is there going to be a Daubert hearing, and who is the witness that you anticipate a Daubert hearing on? I'd like to get that on our schedule now.
We have not yet drafted the motion, but I just thought the government at trial called a expert regarding a dog bite forgive me, I haven't watched all of the trial.
No, that's fine. All right.
That expert, I do not believe, followed the proper methodology or had the expertise to make.
All right. Does the defense intend to call Dr. I've forgotten her name.
Dr. Russell.
Dr. Russell, do you intend to call her again?
Oh, I loved her.
All right. So why don't we set a Darber hearing sometime in December? Does that give you enough time, Mr. Brennan?
It does, Your Honor.
Okay. So why don't we set a Darber hearing? I know you'll have to fly her in, but why don't we get a date now in December for that?
Does the court anticipate that being a different day than the date we're going to set for the Rule 17?
Rule 17 we're doing as soon as possible. We'll do before that date.
Understood.
Somebody says, why
Rule
do they need to
17.
do the hearing again for Dr. Russell? It's a new trial.
Different trial.
Everything starts over.
New trial.
So we're going to
And by the way, the Commonwealth has a better shot at this one than they did their last one. Last one was like they discovered her mid-trial.
So, Mr. McDermott.
May I put Mr. Brennan?
Sure. Jim, can you pull up Jim? How was December 10th?
I will say these lawyers get along a lot better than Lolly did, and them, like Lolly and them, hate each other.
Would the 13th of December be available?
This guy's also a lot more respectful of defense counsel.
Something else on
Yeah.
this morning that would be time consuming.
I could also do the 12th if Mr. Brennan.
Like, I'd have no problem working with this guy.
No.
I was looking at the 10th, but Jim, could you look at the 13th?
Yeah, this is the 10th.
the 10th work for both of you. The government's available on the 10th.
So I have a, you cannot do the 10th, okay.
Your Honor, just to be completely candid, I have nothing on the table.
I see, because he's a defense attorney. Yeah, did you watch the Baldwin trial?
I'm sorry, first on the 9th, I didn't fly out on the 9th, and I've got all the hearing on the 9th back in California, so I can't fly that day. So
Well, court ends at what time?
I'm sorry, Your Honor?
You can take, a lot of people take a red eye, right? Can you come out then?
I do every time.
You can't fly out on the 9th, the evening.
I had seen the clip, but I hadn't seen what led into it. I didn't see. I had seen like little 1 second thing that had been replayed all over the place of Bev asking like, "You can fly out on the red eye, right?" But I didn't see what led into it. Jackson just said, "I have an all-day hearing on the 9th," like an all-day hearing, which lawyer speak can be until 5. It can be until 8 p.m. You have no fucking clue.
Yeah. And she's like, take the red eye.
Like, ten out of 10. 10 out of 10, the judges I'm in front of would have said, well, let's look at other dates. And if we can't find anything else, let's go back to that and revisit it.
Yeah. Oh, we've got an Ada raid. Nice.
Hey, Ada, how you doing? Thank you for doing all you did. I just want to see this again. This is just...
Well, court ends at what time?
I'm sorry, Your Honor?
You can take, a lot of people take a red eye, right? Can you come out then?
I do every time.
You can't fly out on the 9th, the evening of the 9th?
There's no way. I can't take a flight on the 9th.
What about the 16th? It's a Monday. Is that?
We're fully booked that Monday and Tuesday.
Let's stick on the 13th. Are we still on the 13th?
Sure, if it's available. Jim, we just put Gaston on for that day. Yeah, we have a full competency hearing, and we also do a Gaston.
Dude, this judge and I would not get along. I don't know if I could do this. I couldn't do a trial like this.
There's a certain point where I'd just be like, what part of I was unavailable was unclear.
The 12th first.
I can do the 12th.
I can do the 12th.
Like, Judge, if you would like to deprive my client of the right to counsel during a critical part of this proceeding being a Daubert hearing, please deprive them of that right to counsel. Make the call. Go ahead. You want to do it? Sure. Now, would you ever have the balls to say it like that in open court? No. No lawyer would ever say it like that. Jeez.
We'll accommodate, yes.
All right, so the Daubert hearing will be December 12th.
That'd be at 9 o'clock, Your Honor?
Yes.
No, the heavy breathing has reduced because she learned how tilt her fucking microphone away from her.
We'll get a date on that in just a minute. When are you available for the Rule 17 motions? How about November 26th?
You know how much I could not do what Adam Lally is doing right now? Like,
just sitting there while everyone is like,
I can't do that.
Quietly. Well, especially because they are kind of quietly sniping at him. And I'm like, yeah, that'd be rough.
Yeah. He's just sitting there, not arguing, not saying a word. I hadn't said a word in court. I can't fucking do that. No
I'm
way.
pretty sure I'd be like, can I just go to like Sweden for this?
It's like no one puts baby in the corner. I'm in the corner. I'm baby. Don't put me in the fucking corner. I can't be in here. Like either let me out of the courtroom where I don't have to be here and see all this.
Also, nobody puts baby in a corner. It's a hilarious thing for you as a sort of thing to cite.
No one puts baby in a corner. I'm baby. Don't put me in a fucking corner. Yes, and on the thing of pet peeves, what the fuck is with this courtroom and the desks behind each other? Why are we here? Just Massachusetts. I don't understand you. I'm sorry.
Mm-hmm.
Lovely people from Massachusetts, but what the hell?
I have a trial that morning.
Where?
Why are we
in Woburn District Court? To the
What is
extent
that
that the court
angle?
would give me a protective order, I can.
Or tell them that you have a trial here, and if I need to speak to anybody, I will.
Okay, appreciate that.
We're not a trial here at this motion hearing.
Okay.
I'd like to do it as soon as possible to get those out, get them.
See, Bev, Judge, that's what you do. You say, if you have a conflict and it's in this courthouse, I will talk to the other judge and say, I need them here.
Moving.
Thank you.
So November 26th, Jim, can we do that in the morning?
Yes. I'm told that Mr. Jackson cannot make the 26th.
For the Rule 17 motions, do you need to be here in person?
If I could have 10 seconds.
It's a client call.
Your Honor, in this moment, if I could just alert the court that there is one additional Rule 17 I'll have filed by Friday. It is similar to a number of...
File it and send notice immediately of the date.
I will. And may I inquire, do I send notice on behalf of the Commonwealth, or does the clerk's office send it?
Mr. Lally can inform you on the process, but you send it right out.
We will. Thank you.
Yes.
Okay. Yeah, we'll make the 26th work.
Great.
I likely will not be here, but.
Okay.
Are we 9 a.m.?
Why don't we do 10 a.m., Jimmy?
10 a.m. on
Get
the
all the
26th.
record holders who want to be here.
10 a.m. on the 26th.
All right. And all the other motions are taken under advisement.
Great.
Okay. Thank you very much.
Thank you.
All right, please.
Well, would you look at that? Wait.
I would,
can't
but
do
you took
Judge
it off
Bev.
the screen.
I can't do Judge Bev. Judge Bev.
Yeah, she is something.
Well, there you have it. 26 is the next motions hearing. So we will have something on that date, which is oddly the day after. We'll have more in the Infowars auction issue, which is 25th. So we've got all kinds of stuff. Why be? Yeah, Rob's in motion right now. She brings to mind a particular judge that I will appear in front of from time to time. And if you ever walk into court feeling like you are already behind the 8 ball, like you are already behind in the count when it comes to a particular judge, and when you stand up, they're already going, oh. That is how Judge Bev just kills me. I can't. It drives me nuts. Either way. 26 November. Yes. And we have 25 November being the date when we'll have the Infowars update. All right. So let's catch up on some super chats and get out of here because it's been a 5.5 hour stream and we're just going to, we're going to roll with it. But we will do it. We'll swoop to super chats and catching up. Okay. Swoop. Mispronounced name. Is he brought on for Reed prosecution or for O'Keefe investigation? Could be bring charge against other people. Either way, he's better than Lolly. Realistically, he's not in charge of initiating new charges.
He could make a recommendation, but they're not.
He
He's not going to turn around and like charge Trooper Proctor or Bukaki or anything like that.
He has very limited scope authority. His authority is acting on behalf of the DA in this case in particular. He can't initiate new ones. Rosie, glad to see you too. Post-op, not dead yet. Always good.
We
Hope
are
you're
glad of
healing
that.
and recovering. Go ahead. Sorry.
We're glad.
Yeah, very much.
We very much like the not dead yet.
I am firmly in the not dead yet camp. I think it's a good thing. In all sincerity, Rosie, heal up, feel better, and glad you're here. 20th Century Fox had said phones plugged into the radio. So cute. Oh, I missed that part. Linda M. Car, remember to hit the like button. Chat. Yes, remember to hit the like button. Please hit like button. Classic overthinker. Hank is being paid $75,000. He's using his paralegal.
$75,000 is actually, they're getting a bargain for that.
On a trial like this is nada.
Yeah, they're getting a bargain.
That's nothing. That's someone who feels like it's a civic duty or whatever their motivation is. I'm not reading into it beyond that.
I don't know how
God,
you could do this one for 75.
What?
I said, I don't know how you could do this one for 75.
Not with how much is being, I mean, granted, that's just straight fee to you, but even so, that's, let me put it this way.
He's going to have a whole bunch of costs that come out of that.
I know. I have like a 4-day divorce trial. If it's 4 days, discovery leading up to it, motions practice before it, you're there. That's a 4-day trial. Bench trial, not jury. He's taken a haircut. SF, oh my God, I forgot about car talk. It's been a minute. It has been. I love click and clack. Freaking frack. Freaking flack, click and clack. Click and clack. Maybe it's click and clack. Freaking frack. Either way. Tamau, spending time with you all as it became my brother's birthday. Happy birthday to your brother. Thank you for streaming on a night when it's hard to sleep. Less than 3 months since cancer took him. Read the rest of the chat, Rob. You both are amazing. Ty, I'm very sorry for your loss. Extremely. And I think we can all agree, fuck cancer in the horse she rode in on or he rode in on. I don't really care. Fuck cancer.
Yeah.
Cancer takes too many people at always the wrong time. There's never a right time, period. In honor of your brother's memory, cheers. And hold him close. Never forget him. He's never going to leave you. So, cheers to you. I'm sorry for your loss. Sandy, motion to do nightly recaps of this trial, please, and thank you.
I will likely be doing nightly recaps, but when it gets started,
recaps.
It's going to be a ways out.
Yep. I imagine it's going to be April. I think the judge is going to have to give that April date. I cannot see this going forward in January.
If it's January, I may not be able to do the nightly recaps because I got SHOT Show. I'm going to be gone for a week.
Tell you what, if it's January, end of January, I will have Gundy's, which is one night. Arguably, if I'm invited. I will have Gunnies, which is one night, which is not SHOT Show, which means that I am all in for this shit show if the judge decides to try and do this January, because it's going to be a shit show. This might be a trial where you're going to have all hands on deck covering it, because I am really curious. You have testimony that's now been heard by the whole world, and how you're going to reframe it. And wow, it's going to be interesting. Creed, question: how awkward would it be if the special prosecutor gets the testing results and decides he doesn't want to move forward?
I mean,
it'd be the
not
right
at
call.
all. I've seen it. I mean, I've had a file where they went and they got one expert report, and they didn't like the expert report. They kind of thought the expert report was a little thin for their purposes, so they got a second expert report, and the second expert report contradicted the first, and the prosecutor was just like, "Yep, file's done."
Well, here's what pisses me off. We have now learned the scrape was not a complete and accurate depiction, which we had kind of surmised from Trooper Paul's testimony as to how fast the vehicle was going. Everything about the metrics that were being relayed to the jury felt wrong. Like, it just felt incomplete. But you had a so-called expert up there conveying that information with the authority of, the science. And here we are, a second trial, and now we get a whole new scrape and software that can apparently comprehend what actually happened.
I mean,
do we trust it? Do we not?
I wouldn't trust Trooper Paul to tell me the weather, except, and I mean, maybe I might trust Lolly to tell me the weather, especially like around the winter season. But yeah, no, I just
no, I don't trust Lolly to tell me shit. It will be 100-degree day in the middle of June, and Lolly will ask me if it's snowing.
No, he'll ask you, what if any snow was? Oh my God. What if any weather was going on?
If there is a witness that Lolly gets to examine, I will have a wall in front of me, just bash my head into it the whole time. The whole time. K-Rab, a checksum is a calculation based on the data, and it is highly dependent on the order of the data. It is fairly unique and will show corrupted data. Yes. We tried to explain it the best we could, perhaps less artfully than that, and thank you for that. I talk about Bruno, you're not sleeping yet, superheroes. No, not yet. I will be soon. Lucy Wu, EDB, and Depp was how I found you. I've been a member for a while, and the care and compassion you bring to trials such as Maya's is why I continue to be here. Thank you, Rob. Also, Ian's mission and Extra Life fundraising. Yes, Ian did phenomenal. What are you up to? Did Reddit match yet?
Reddit hasn't matched yet, but I've been knocked down the leaderboard.
No.
I was at number 3. I am now at number 4. And so we'll have to see, because I'm at 85,000. The guy who's ahead of me is at 111,000. Now, when Reddit does their matching, hopefully that'll take it up to 105,000, but that still puts me 6,000 behind this guy. So I might not get the number 3 spot.
Well, I have pinned the link to the top of the chat. So please, if you guys are there, please consider donating the Extra Life charity live stream. And we mentioned earlier, please go back and watch that video, the Lawyers and Dragons video, where, well, D&D, where we all got together and played Dungeons and Dragons. Great cause. We do it. We've been doing it every year for the past, this is 3 years, right?
Yep.
Yeah, 3 years.
And we do still have a bunch of stuff left to auction. By the way, so Canada Post is on strike right now. I have a pile of stuff right here. It is literally piled up to like my waist. I also have a pile of stuff on my kitchen table that is like heaped, and there's just so much stuff. I got to start trying to get it out of here, but I can't even drop it off at the post office.
Pretty sure people are going to give you some grace. So
I hope people are not going to be like, where's my stuff? Because if they are, it's like, sorry. And I mean, the shipping is going to be expensive. It's going to be a lot, but if I start having to send it out because of what is it, like by courier, like DHL or something, it's probably going to be like double or triple on the shipping costs, and then that'll be a problem. And Darian saying, Runkle, are they on strike because of how long you take to get your P.O. box? I go to my P.O. box at least once a week. The problem is that they had a whole bunch of stuff that they had forgotten to give me, and some of it they had marked internally in their system as delivered. So, yeah, that was a thing.
Yep. Chris and M96, with holidays, what are the odds of an FNF? For the November date, I don't know. I will project that I might have an argument to make to do a live stream because I might be in a different time zone. I don't know. But that is largely dependent on family. And I hope you guys understand why. Family comes first.
I feel like that should be fairly understood.
Yeah. I do my best. Family comes first, but I try very hard. Very, very, very hard. Fiona W., thanks for another great stream. Thank you very much for being here. Lori Marie, thank you for becoming a member. Much appreciated. And Dandy Daisy, how many what the fuck comments were made when the lawyer came? Which lawyer and in what context? I don't know. Probably a lot. So, to all of you, I wish you, it is 2:22 a.m. my time, so 2:22. Everyone make a wish. I wish you all a very, very lovely weekend. I hope you get out and you go and make something. I made something this week, and it made my life a whole hell of a lot better just to get out and make. Please go make something. You'll feel better, whether it's writing, drawing, building, crafting. Engage a part of your brain you don't otherwise engage on a regular basis. And thank you guys for sticking around. We made it through 3 of the 4 topics, which is more than I thought we would, especially with the late edition. Ian is going to be live on Monday.
I should, barring, surprises.
Ian will be live on Monday. I don't have a Chaos Gremlin in my possession, which means I might be joining from the shop.
Sweet.
Which would be lovely. I'd love to be able to do that. I haven't done that in too long. So until then, cheers to all of you. I imagine, Ian, you're covering Richens. You have to cover Richens because I haven't done it.
When does that start?
Well, there was a Richens motions hearing, which is this week, to sever Enver bail again. She wanted to bail again.
Yeah, I'll probably cover that, even though if you haven't been following it, you already know the answer about whether she got bail.
She totally got bail, right? Like she's out, hanging out with everybody. No, she didn't get bail.
Of course she didn't get bail.
The person who wrote the letter of please help me lie to other people is not going to get bail. Anyways.
Yeah, there was never a universe where she got bail.
No.
So, yeah.
So, cheers to all of you. Thank you for being here. Much appreciated. Thank the mods. Please, guys, thank the mods. They do phenomenal work. And they're here. They're all volunteering to give their time to make sure the chat behaves and has fun. and talks about stuff that's important and critical. So thank you to them. Thank you to all of you for being the best chat in the world. Ian and I share in large part a lot of you as chat and channel followers. So thank you, thank you, thank you. Have a lovely evening, a great weekend. Go out there, make something, feel better, do better. And I will catch you next time, hopefully on Monday. So cheers.